Well, good evening and happy Friday to all of you. For those of you on the replay, happy whatever day it is you're watching this. Good morning, good afternoon, good evening, and good night. Hope you guys are doing well. Hope your week went well, and I hope that everyone, had a great week. So we are back after one day off to recap 2 days of the Kowalski trial. For those of you that are new and not really sure what we're talking about the case of Maya Kowalski, rather Jack Kowalski, Maya Kowalski, Kyle Kowalski, and the estate of Beata Kowalski versus Johns Hopkins All Children's Hospital, J Hatch. This is a case stemming from the facts that were discussed in the Netflix documentary Take Care of Maya. The general facts of the case are that Maya Kowalski, who was diagnosed and suffers from complex regional pain syndrome, CRPS, was admitted to Johns Hopkins All Children's Hospital on October 7th of 2016. After being admitted, she was, treated, and then the hospital began to gain suspicion that there was perhaps a misdiagnosis of CRPS and that it wasn't, in fact, Munchausen's by proxy. Hospital began some actions to allegations that the hospital prevented the Kowalskis from removing their daughter from the hospital's care, and that eventually resulted in a DCF action with a shelter order that went in place on October 13th of 2016. The shelter order existed until January of 2017, and in January, I think January 7th was the date of 2017, Beata Kowalski took her own life and left a letter behind saying, "Take care of Maya," blaming in large part, the hospital for the deprivation of, a lot of things. Because the subject matter we're discussing is sensitive in nature, I have been running a little bit of a ticker or a banner on the bottom of the screen while we talk about this case. I don't like using the T word. It's just a warning to those who jump in and decide they want to start watching and not sure what we're covering, so that they're aware that some of the subject matter we're discussing is relatively sensitive in nature. Let me throw that up. So, as I mentioned at the outset, I did not do a recap last night. And lo and behold, I don't know if it's because of a certain friend of mine with purple hair who, whenever she travels, something in court always goes a little bit wild. But that seemed to be the case. We got the depositions of Sally Smith, and we got a motion for mistrial by the plaintiffs. If you're keeping score, that's 2 motions for mistrial by the defense, and this would make 2 motions for mistrial by the plaintiffs. This case is exceedingly complex in its facts. So we're going to try and walk through 2 days of testimony, and I do have a redirect set up for Friday Night Frenzy, which is my regular Friday show, which has been pushed to 9 p.m. instead of 8 p.m. so that I can try to get through as much of this as I can, explain where we are in this case, and where we will take things up on Monday. No, the plaintiffs did not rest today. That was in large part due to the fact that they had a witness that was unavailable to them. So the witness had a death in the family, and therefore they could not call that witness until Monday. So I have made mention, and several people have been critical that the commentary that I give while discussing this trial thus far has been it's had the appearance of being pro-plaintiff. And the way that I've explained that is this is the plaintiff's case in chief. After every witness, they get the chance to not lead the witness, but walk the witness through their best version, their best narrative. And the defense can punch holes here and there. Defense scores points by impeaching credibility, bringing up an inconsistent fact. But in large part, this is the plaintiff's ship to steer right now. And if the plaintiffs are doing their job properly, you should be feeling pro-plaintiff at this point, if they're doing their job properly. If they're not, then you might have other thoughts. That's just kind of where we are in the case. When we get to the defense case, as I'm going to discuss later this evening, I will give you what I believe is going to be their strategy going forward and tell you how they're going to approach this, based in large part on some of the arguments that were made at the conclusion of today's trial proceedings. And because we have so much to recap, I'm going to be glossing over and skipping through some of the testimony that we received both yesterday and today. I will give you guys ample notice right now I listened to the testimony of Jack Kowalski yesterday and Maya Kowalski today. This was testimony that was on the issue of damages. It's emotional testimony. It's impactful. It is somewhat duplicative of the earlier testimony. I'm not going to be recapping that because we have a whole lot to cover other than that. If you do want to take a look at that testimony in full, I would very strongly recommend you pull up Tampa 13 has been doing wonderful coverage of this case. They are the in-court feed. But for today, I have to pull up Law and Crime because Law and Crime has the full day broken up. And I can't have, I try to pull up the Tampa 13 feed for yesterday and today. I had like 12 windows open. So I needed to kind of streamline this. So I have to use Law and Crime, which has the full beginning and end. So let me see here. Is FNF for members only? No, it is not. I don't place legal coverage behind the members only. The members only is, I mean, that's access to some of the stuff I do in the shop. So it's shop stuff, it's discussion, it's how I practice law, it's various things that are more personal. So without further ado, let's go ahead and get into some of the beginning testimony from yesterday's testimony. First up, we have Jessica Blackrick. Now, so I don't have to pause, I'm going to tell you who Jessica Blackrick is. She was the guardian ad litem. Now, I have made the comment that a GAL, guardian ad litem, is an attorney. That's how it works in Virginia. Different states have different designations for the qualifications that must be held by these individuals that represent children, and the capacity in which they represent children in front of dependency court or in front of juvenile court. In Virginia, GALs, guardian ad litem, they are the attorney that is appointed by the court for the representation of the child. In Florida, a GAL that we'll learn from Ms. Blackrick does not have to be a licensed attorney. They are, I mean, in Virginia, we would call them a CASA, kind of a court-appointed special advocate. They are a non-attorney third party who has some particular training in the area to advocate for the best interest of that child. So Ms. Blackrick was appointed during the dependency action when Maya Kowalski was removed from the care of her parents and placed under a shelter order that was implemented by the Department of Children and Families in Florida and carried out by the hospital where she was staying. So let's hear from Ms. Blackrick. I had the volume gained up 600% from the court feed. That's so that you guys can hear. There was no closed captioning available on this particular stream, so I apologize for that. But with the increase in volume, hopefully you guys can hear. At times, I might increase the speed to 1.5 times. I apologize if it sounds a little bit quick, but I need to make through a lot of testimony, and I do encourage and will post links in the description of the video to the full stream so you can go back and check the testimony if you want. As you can see, Law and Crime was kind enough to place timestamps in here for the different parts of trial, and we're going to make use of those as we kind of explain and discuss some of the things that took place during the court yesterday. So let's go ahead and get rolling. Mr. Whitney, or who?
Plaintiff's called Jessica Blackrick.
She's outside.
You solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Morning.
Morning.
Would you please state your name for the record?
Jessica Blackrick.
Have you been called here this morning to testify as the guardian ad litem for Maya Kowalski during 2016 and the very beginning of 2017?
Yes, sir.
First question is, would you please explain to the jury what a guardian ad litem is?
We are there for the best interest of the child. So in a dependency proceeding, the court can appoint a guardian ad litem where we're not for the parents or for the state. We are an independent advocate for the child's best interest. And specifically for Florida's guardian ad litem program, we're part of a three-pronged team where there's a child best interest attorney, there's the child advocate manager, that's the role I was, and then there's also a volunteer guardian ad litem.
Is it fair to say that the guardian ad litem, your position, you're there as an advocate for the child?
Absolutely.
We'll talk about some specifics of your interactions with the Kowalskis in the hospital during this time. But before we go there, would you just briefly describe your educational background?
I have a bachelor's degree in psychology, and that's an associate's degree in liberal arts. That's it.
All right, and approximately what year did you get involved with the guardian ad litem program in Florida?
In 2016.
And how long did you work as a guardian ad litem in Florida?
I was about 6 months. I worked in the Third Circuit, which is Live Oak and Lake City, Florida. And then I transferred to Sarasota in July of 2016.
And you worked in Sarasota in that circuit for approximately 4 years?
Yes, August of 2020.
And after that, where did you move or go to work?
I moved to Waycross, Georgia, and I worked for a domestic violence agency for several years. And in May of this year, I took on the position as a program director for CASA, or Southeast Georgia CASA, which CASA is court appointed special advocates. It's very similar to what guardian ad litem is in Florida. The only difference is we provide all the funding ourselves, but we follow the similar national curriculum that's called the National GAL CASA curriculum for everything we do.
So when you were in Florida, you served as a guardian ad litem.
Yes.
And in Georgia, did you take on a more managerial role?
Yes.
Can you explain that to the jury, please?
I'm the program director, so I actually do have some cases where I'm the CASA advocate just because I never want to not be doing that. But for the most part, I supervise the entirety of the program, and I write grants so that we can be funded.
With all that in mind, is it fair to say that you've been involved in this type of work, child advocacy, guardian ad litem work, for the past 7 or 8 years?
Yes.
Let's move to your specific interactions with the hospital and Maya Kowalski, BiFulco. Were there occasions on which you supervised phone calls between BiFulco Kowalski and Maya Kowalski?
Yes.
On how many occasions do you think you did that?
Either 2 or 3.
Have you had an opportunity to review the court order that was in effect for that time frame?
Yes, sir.
Is it your understanding? What is your understanding about who was appointed to supervise phone calls?
Myself and the case manager,
Who was the case manager?
Charlotte Laporte.
And how long did you work with Ms. Laporte?
Well, at that point, since July 2016, we probably had some random cases together.
Right. So if I understood your testimony, there's 2 people appointed to supervise these phone calls,
Yes.
either yourself or Ms. Laporte.
Yes.
Was there a time that you would supervise these calls simultaneously
With
Ms. Laporte?
no.
Is it fair to say it was one or the other?
Yes, that was the point of adding me, because normally we weren't appointed to actually be supervisors of phone calls. We would just be observers. But the judge in this case did do that.
All right. Did you ever delegate your responsibilities or authority to anyone at the hospital to supervise those phone calls?
Sure. Microphone 1, rub 0. Delegation of authority, Kathy Laporte. Why are a lot of these questions kind of seeming why are we not getting a whole lot of background? Because a lot of this is going to be contradicted by the hospital. The phone calls that we heard earlier that were testified to by both Maya Kowalski and I believe one other individual, I think it might have been Jack Kowalski, that the voice on a call interrupting Beata speaking with her daughter was that of Kathy Beatty. The hospital is saying that they are going to have Ms. Laporte come in and testify that it was in fact her cutting off Beata Kowalski in those conversations. So credibility is a big issue here. So the reason they're going through that is they're trying to establish J. Blackrick or Ms. Blackrick as being the more credible of the 2 sources and the person that you should believe. So that's some of the reason for some of this preliminary back and forth. We're going to go ahead and skip through. And listen to the call itself and the testimony about it.
Have bits and pieces of evidence. I'd like to play for you what's already been admitted as 2608 alpha, and it's about 1 minute and 10 seconds.
Okay.
Okay, I'm recording this phone call so everybody knows.
Okay, hi, Mommy.
Hi, honey. How are you, sweetie pie?
I'm great. I miss you.
I miss you so much too. I miss you so much every day, every single day.
You know how happy it makes me feel to hear your voice.
Same here. I miss you so much, and I am so happy that I'm finally able to hear your voice too. Yeah.
I hope
So,
I see you.
what did you say, sweetie?
I hope I can see you soon.
I would love to see you soon. I would love to see you soon. We just have to wait for the judge to make the decision, okay? As soon as he makes the decision, then I'll be able to see you. Okay?
Beata,
Yeah.
we're not allowed to talk about the case, okay? Maya, honey, we're going to talk about what you've been doing, if you need any Shopkins or things like that.
Hang on. I'm going to slow this down to real time so we can hear the voice. And I'm doing this expressly for this reason, as Ivan points out. Ms. Laporte, the hospital says, is going to be testifying on Tuesday. The hospital anticipates and has stated that Ms. Laporte is going to testify that this is her voice, that this was her that cut off Beata. The reason why this is important, another question that I kind of saw when flying by, why is it important to establish which person cut off Beata? If it is Miss Laporte, that is DCF. That is a person that was properly charged with supervising these calls and had authority from court order to interrupt the call and redirect the conversation. If it's Kathy Beatty, that's an employee of the hospital who presumably did not have that authority to cut off the conversation. So we're going to go to real time because I actually want to hear the voice. I want to hear the voice, and I want to be able to keep that in my mind while I compare that on Tuesday to the testimony from Ms. Laporte.
Yeah, it's okay.
Would love to see you soon. We just have to wait for the judge to make the decision, okay? As soon as he makes the decision, then I'll be able to see you. Okay?
Beata,
Yeah.
we're not allowed to talk about the case, okay? Maya, honey, we're going to talk about what you've been doing, if you need any Shopkins or things like that, if you had nice visits with your daddy, but we can't discuss the case, okay, honey?
Do you remember that call?
Yes, sir.
Oh, was that you interrupting the phone call?
No.
Was that Miss Beatty?
Yes.
Beyond that October 15th call, did you have additional phone calls? Were you supervised?
Yes.
Was Ms. Beatty present on those calls as well?
Yes.
Do you recall from the order any limitation on how frequently phone calls were to be facilitated between Beata and Maya?
Same objection and also in terms of foundation and time.
Why don't you deal
Sure.
with the time
Sure.
issue, but otherwise overruled?
All right. Do you recall that you supervised several phone calls in mid to late November?
Yes.
All right. The court order in effect at the time, having reviewed that court order, was there any limitation placed on the frequency of the phone calls between Beata and Maya that were allowed?
No.
Was there any limitation imposed on the length of those phone calls?
No.
Did you make yourself generally available to facilitate phone calls as the supervisor under the order?
Yes, sir.
Do you recall a time that Beata had requested a phone call on Thanksgiving?
Yes, sir.
Did you make yourself available?
Yes.
Was that phone call allowed to happen?
No.
Why?
Because Miss Beatty's schedule didn't allow for that.
So Ms. Beatty was not amenable to a phone call on Thanksgiving between Beata and Maya?
She just wasn't. It just wasn't in her schedule from what I know.
Do you recall a phone call after Thanksgiving?
Yes, sir.
Have you had an opportunity to listen to that phone call?
Yes, sir.
If that phone call is allowed to be played for this jury, do you consent to the point of that phone call?
Yes, sir.
In that post-Thanksgiving phone call, did Maya Kowalski attempt to pray with her daughter?
Objection
Yeah.
to hearsay, Your Honor.
I
It's
haven't
not the
asked for-
truth.
Overruled.
Not the truth that matters, sir.
Ms. Kowalski attempt to pray with her daughter.
Yes, sir.
What was Ms. Beatty's reaction to Beata trying to pray with her daughter? If you could explain that to the jury, please.
Well, the phone call was Ms. Beatty had mentioned that the phone call, it was time for the phone call to end it because she needed to go to a meeting. And Ms. Kowalski asked to pray or began praying. And then at one point it was interrupted by a lot of loud noises. And Ms. Kowalski asked what the noises were. And Ms. Beatty said that it was her office stuff. And anyway, she proceeded to finish the prayer, and then the visit ended. And afterwards,
Let me stop you right there.
Sorry.
You're doing great. I just wanted to clarify, when you say the visit ended, does that mean that at that point, after the prayer, which was slightly interrupted, that Maya and Beata both hung up?
yes.
So at that point in the phone call, it was just Ms. Beatty at the hospital and yourself.
Yes, sir.
All right. Please continue.
So at the end of the call, Miss Beatty said to me that that prayer was just the mom's way of extending the phone call. And I said, well, she has a right to pray. And then we were going to schedule, I asked her, can we schedule the next phone call? And Miss Beatty said, no, we're not going to schedule anything right now. I'm going to end the phone calls at this point. I'm going to take care of that.
And as part of your training as a guardian ad litem, do you receive training on the right of families?
Okay, a couple of good points are being made here. So Michael Stahl, good point. Very good point. A voice on a phone is just a voice on a phone unless or until someone stipulates it to it being their voice. That's a good point, with one caveat. The voice on the phone is the voice on the phone. However, individuals can testify to their personal knowledge and experience. If they have spoken with an individual for enough times, they can say, I've spoken to this person 9 million times. I can recognize their voice. I can identify their voice. Now, it doesn't become an established fact. It goes to the credibility of the person who's saying, I recognize that voice on the phone. So that's where we are right now. It's a really good point. Thank you, Michael Stahl, for bringing that up. Good point. Regarding the timing of this is all very, very important because the orders that were in place set forth certain parameters that have to be operating or that the parties are tasked with operating under. And the original order said that DCF could supervise phone calls and laid out certain restrictions. The original order, I think, didn't restrict very much contact, just said supervised by DCF, which is why the guardian ad litem was on the call. She was one of the parties under the order who could supervise. Kathy Beatty was not expressly named. Thanksgiving of 2016, I had to look this up, was November 24th of 2016. I believe there was a subsequent order that was entered on the 30th that may have expressly directed that hospital staff could listen in. But prior to that date, they were relying on this argument that DCF delegated that authority to them. That's why that's relevant. So that's why that's relevant. And then you have this testimony, which is basically saying that after this call, Ms. Beatty said, we're not going to let that happen anymore. So that's why this is coming in. Let's go to Mr. Shapiro's
In these
cross-examination.
types of situations to make your witness.
Good morning.
Good morning.
Just a few questions for you. So if I understand, I think I understand. So the jury understands the rule. The guardian ad litem program is the neutral appointed in the best interest of the child. True?
Yes, sir.
Okay. There's training that you go through. And then there was also somebody who was, I think you said, a volunteer that was assigned as well.
Yes, sir.
Okay. Do you remember who it was?
Yes, Sharon O'Leary Johnson.
Okay. And she would be someone working. Is she working under you?
Yes, so I would be her supervisor.
Okay. And she reports to you. Well, let me set the preface. I know you and I know what's going on, but I think for the benefit of the jury, let's sort of explain the role. So you would go to the hospital and visit when you could, right?
Yes.
And Miss O'Leary Johnson, as the unpaid volunteer, would also go as well, right?
Yes,
And they would file their observations of what they saw in the hospital in reports.
correct.
And you would do that as well.
Yes.
Okay. You're not hired by All Children's. You're not paid by All Children's, right?
No, sir.
And you're not paid by the Kowalski family.
Correct.
You're the true neutral.
Yes, sir.
Okay. And not to say you would do anything else, but actually you guys have to sign an oath to the court that you're going to advocate only in the best interests of Maya, right?
Yes, sir.
Okay. And you make recommendations to the court based on what you see as well, true?
Yes, sir.
Okay. So let me ask you a little bit about, have you reviewed your notes?
No.
Okay.
One.
Got it. All right. So if you need to refresh your recollection, let me know. But Do you recall that you first visited Maya at All Children's Hospital on October 14th?
Yes.
Have you reviewed that?
Start paying attention. Yes, to those in the chat, I did catch this part, and we're about to get to our first spicy moment of yesterday.
Note.
That's the only note I reviewed.
Okay. If you need me to, would it be helpful to have the note in front of you to refresh your recollection?
Yes. That would be
Okay. May I approach, Your Honor?
You may.
And I do have an extra copy for plaintiff's counsel. Okay. So what I'm going to hand you for the purposes of identification is going to be Defense Exhibit 3250, pages 1 through 4. And I'm glad you have your glasses on because the type print is very small.
I'm actually gonna have to take them off for that.
Okay.
That's the first thing probably.
All right. Do you want to take a moment to read that one? Would it be helpful before I ask you questions?
Okay.
Okay. So this note is computer generated by you, correct?
Yes.
And it shows in here that the date of the visit that you made to All Children's Hospital was October 14th, 2016, right?
Yes, sir.
And it says that it was a face-to-face meeting with Maya, correct?
Yes.
And it says that the meeting was about an hour and a half. Is that right?
Yes.
Okay. And then you made some notes on your meeting, right?
Correct.
Okay. In your note, where was Maya at that time?
She was. Let's see. Yeah, she was in her room, her hospital room.
Okay. Did the hospital ask you to come to the hospital and explain to Maya why she was being held at the hospital?
Yes.
Okay. And just for a frame of reference, on October 14th, earlier in the day, you were at the dependency court, correct?
Correct.
And you made a note that the Kowalskis did not contest shelter at that hearing, correct?
Approach both.
You see her double checking her notes? You see her double checking her notes? That question is what's going to yield some fireworks. Because Shapiro, having provided this document to her, says, do you see, you made a note that Beata and Jack Kowalski did not contest the shelter order.
Disregard that last question. It's not relevant to this case at all.
You were asked by the hospital to come to visit Maya and explain to her why she's staying at the hospital. Is that right?
Yes, sir.
Okay.
Second part, ready?
You made some observations while you were at the hospital. Is that fair?
Yes, sir.
Let me ask you about a couple of the comments in here. May I approach on a question before I ask you?
Yes.
I have a suspicion. I'm going to tell you now. I think that Shapiro knew what this witness may have said in open court in the dependency proceeding. And the witness in the dependency proceeding, after explaining the process, the dependency proceeding after the parties are appointed attorneys, if the parents say, you know, we understand the burden here, we understand we want to get our own attorneys, we don't have an opposition at this time. That is not the same as consenting to a shelter order. They are pretty distinct. Pretty distinct. What he is suggesting, though, is that her notes said that. This next admonishment is going to have is one that, well, let's do this. Let's go straight to that. We'll go and excuse the jury. By jury, you go out.
For a few moments. Do not discuss this case amongst yourselves. Do not do any investigation and receive no information. All right.
Bye jury. Yeah, Creed. They are. They're both playing the line. They are dancing on it. A lot of that's a legal standard.
Okay, the jury is out of our presence. Ma'am, can I actually have you go sit out in the hall for a few moments?
Now, you'll remember Anderson stepped in it earlier and got admonished strongly by the judge.
Okay, the witness is out of our presence, so is the jury. Mr. Anderson.
As we explained it to the court above, and again, for the record, by virtue of counsel having taken a DCF note, held it up.
I'm just,
Sorry,
I know you're not on this motion, so you go. Sorry, Mr. Tracy, go.
By holding it up, showing it around the courtroom to the jury, referencing it as what it is, and then reading out sections. Admittedly, as we watched, yeah, there's some slight paraphrases, but in essence, the language of that note was being portrayed then to the witness. And in that way, the jury is now under the impression that there are notes out there that are contradicting everything the witness says and introducing the whole idea here, the concept of who was in control at what point, which is in direct violation of this court's instruction that we are not supposed to be getting into that stuff. And the plaintiffs have been chastised, and I understand the court's position on those. But in this instance now, we have got effectively a published, or at least part of a published note in here on something the court specifically instructed us, the plaintiffs, and the defense was there not to do. And so we asked the court to take under advisement, because obviously with 5 years into this, we want to see a jury verdict here. But we asked the court to take under advisement a motion for mistrial in that regard. And we asked the court also to consider, if indeed this is the way they're proceeding, and at this point that the door has been opened for us to attack some of these notes and some of these positions and some of these actions that were behind the orders and DCF directions. So that is our position.
Well, let me be, are you or are you not moving for mistrial? I need a clear, you are or are not moving for mistrial.
May I inquire from the court, if I may move as previously done here to move for mistrial?
No, you cannot defer the ruling on a mistrial. You can't defer the ruling on a mistrial. I have been thinking about this particular question for a while today, Michael. Was Shapiro trying to cause a mistrial? I have been thinking about this particular question for quite some time. Ever since I heard this yesterday and I saw the question first pop up, I don't know the answer. I don't know the answer. When we get to the end of today's testimony and argument on the motions, I will give you my thoughts, because I have a lot of thoughts. But for now, we're going to listen to the argument being made and the admonishment that comes after it.
Trial, but have the court take it under advisement until the conclusion of the case, because I do not want to take a step right now that wastes 5 years of litigation and now 3.5, 4 weeks.
I am not in a position to give an advisory opinion about what I might do on a motion you haven't made.
Then I cannot make it, because I do not want in any way to have this trial.
So to be clear, you are not moving for mistrial.
Under these circumstances, I am not moving for mistrial. I am, however, documenting for the record that the extent of the damage done here is a basis for it, but I cannot move for a mistrial at this point based upon the circumstances of this case and a disservice to my client after all this effort. So I just want to say that for the record.
One comment if I might. There was a representation made to the jury about the Kowalskis not contesting the shelter petition, which is damaging. There was additional representation made. That comment was made because something in this note comments on that. I've reviewed the note again. There is no commentary in this note on the failure of the Kowalskis to properly contest that shelter or consent to that shelter, however you want to phrase it.
Well, first off, is this document in evidence?
It is not, Your Honor.
Okay, let me see this document. Just put it, what's the
It's
number?
defense exhibit 3250-001.
And can you make that note bigger so I can read it?
Shall we read? I think we shall. Okay, Rob, speed read. I went to All Children's Hospital to visit Maya. First, I met with hospital social worker Elaine. Then Elaine took me up to meet with the nurse and physical therapist. She's in a regular room on the 8th floor. I then met with Maya. The hospital wanted me to tell Maya why she couldn't see her parents at the time. We talked for a bit, and Maya asked about her father and her brother several times. I explained a bit about who I was, and I supervised a phone call between her and her father and brother. The father was appropriate and loving. He answered the questions in an age-appropriate manner. I stepped out of the room and spoke with the father for a while, explained who I was. He said that, quote, it took a while for her to come out of that, end quote, referring to the mother collapsing at the shelter. This was the shelter hearing. He also said, quote, we saw what that did to her, end quote, when speaking of the no contact order and the mother collapsing. Other than that, the father was very appropriate and respectful and grateful for the phone call with Maya. Maya has a small frame, it seems. She's very thin, not a lot of color in her face, and she is shaky, weak. The PT said something sitting up for a minute at a time, and they can have her standing, use a potty chair so she can bear weight on her legs. I think it's important to note that Maya only asked once about her mother at the very beginning of the visit. The whole rest of the time, she was asking about her father and brother. That's the note. Where in there does it say anything about consent? Where? Where?
Mr. Shapiro, I thought the question was now, maybe we can have the court reporter ask it again or read it back, but the comment or the question that you asked, which was not, I don't believe it was answered, and then ultimately I gave an instruction for them to disregard, was something about her note indicating that the Kowalskis consented to the shelter proceedings at that court hearing.
I believe I asked William, but
Can we have the court reporter read back the question that right before we went to sidebar that started all this?
I'll answer this later.
The question, and did you, and you made a note that the Kowalskis did not contest shelter at that hearing?
Was there an answer by the witness?
Yes, same time as the judge.
I apologize. Your Honor. It was because her note says that she just came from the hearing. I was trying to set the table, and I thought it was because the plaintiffs opened the door to the orders, the interpretation, and the no contact that was entered.
I think my assessment is right. I think that he wanted to get to what happened at the shelter proceeding, and he had underlying knowledge of what happened there. Let me tell you why this is problematic, though. Let me tell you the point that's about to be made. The point that's about to be made is essentially, and it's different for jury trials and bench trials. When I have a witness that's on the stand, sometimes I will walk over to my desk if I think the witness is going to lie to me, and I'll pick up some papers. And what I will do is I will say, isn't it true that this thing that I know occurred, but I don't have an email? I'll say, isn't it true that you emailed the school telling the school to remove father as a point of contact? And they'll say, no. And what I will do is I will casually flip through my notes and hold up my piece of paper that might say nothing. And I will say, are you sure that on this particular date, you did not say that to the school? Now, I have other information that tells me it's that date. What I'm trying to do to the witness is kind of basically say, don't lie to me. I know you're lying. I don't have your email because you either destroyed it. I'm trying to say that to the witness in not so many words. Here's the difference between that type of conduct in a bench trial versus a jury trial. In a jury trial, I'm not allowed to theatrically use a prop to bolster the credibility of the question that I'm asking. I can't do that. What makes this even worse is that, let me rephrase my question. Isn't it true that the email was sent? That was the first question, right? On this day. Second question. Isn't it true that in an email dated December 26th, you said to the school, please remove fathers of contact? And then I put the note down. And it doesn't say anything like that. One is a bit of gamesmanship. The other is an outright misrepresentation. This falls in that second category. Now, people are going to say, why didn't Shapiro get sanctioned? Well, Anderson stepped close to the line too. Both of these attorneys have played very close to the line. They have skirted the line on this. And the judge is there to call balls and strikes. The judge is there to keep them in line. If the judge thinks that what they did was damaging enough that they need to do a sanction, they will. If they need to award a mistrial, they will. Now, what Anderson could have done is Anderson could have asked for a sanction, but he didn't ask for it. People said, why wasn't he sanctioned? He didn't ask for it. The question was, are you moving for a mistrial? That's the difference. Anderson does not want a mistrial. He wants this going to the jury. He thinks he has the jury. He thinks the jury is with him. He wants to go to the jury. So he's trying to manage these statements in real time. Very, very difficult. Very difficult. And Shapiro, I can tell you this. I have seen attorneys that are kind of brazen about it. Let's say Binger in the Rittenhouse case. AG Binger in the Rittenhouse case openly crossed the line 9 million times and said, Judge, I'm sorry. Could you think of someone who was more condescending when they made the comment? I think Shapiro, honestly, if I'm giving an assessment on this one, and people are going to judge me for this, I'm going to give him the benefit of the doubt on this one. I think he had a note in there about what took place at the shelter hearing that he knew he couldn't go into. And he thought that the comment about observations might have opened that door, or he thought he could get to page 2 of his notes and not stay on page 1. What is a mistrial? A mistrial is, I am dismissing this because the jury is tainted. The jury cannot reach a fair result based on how they have been persuaded improperly. Go back to square one, impanel a new jury, start over again. The cost of that is immense. It is remarkable. That is what I battle with here. The plaintiff, I think, at some point in time in this trial is going to have every reasonable ground to move for mistrial. But they might not, because they might rely on this jury, that no matter what shade is thrown, that they might rely on this jury to reach the verdict in their favor, because the consequence of a mistrial is going back to square one. The dollars that I'm talking about are unfathomable, like the hundreds of thousands of dollars to get to this day. Sanctions can be money. Sanctions can be a CLE. Sanctions can be counsel, grab your toothbrush, spend a night in jail. So I will say this, Shapiro really, he one of the things I think saved his ass a little bit is he jumped pretty quickly to the I'm sorry.
That was the purpose for going through it. I will stick my questions for this witness only to their observations at the hospital going forward. It was completely unintentional to make that reference, although with the way the plaintiffs have opened the door to this throughout the trial. But all that being said, I apologize for the comment if it was made out of context, and I will stick to our observations at the hospital. If I may, since I don't want to step in any more hot water on this, the plaintiff did.
I don't understand how that question was asked based on this note. And given the nature of the defense, let's not talk about the dependency. Let's not talk about the dependency for years. Let's not talk about the dependency. You misrepresent a note on a question that you know can't be asked.
My apologies, Your Honor.
There's no motion for mistrial. So
we'd like to discuss with our appellate counsel what an appropriate curative instruction would be if we can come up with one.
And also, we're trying to document for the record the seriousness of this. And we're aware of the second district law on the necessities here. We're in a box. We would ask the court's indulgence to give us the opportunity at some point in the very near future to discuss this with Mr. Tanner, Mr. Elliott, and determine what the best approach is. And also our clients who are not in the courtroom at this moment, at least I don't think they are.
Yeah.
And so, but now that the jury thinks that we're consenting to all this, I can't imagine anything more damaging.
well, I will give you time to discuss with Mr. Elliott and your clients what we're going to do. My suggestion at this point, and maybe you need to take a couple moments, is that we just continue on. Again, to be clear, the plaintiffs have not opened the door by talking about whether there was that delegation in the specific time. I know you disagree,
Mhm.
but that's the court's ruling.
I
And you
understand.
have to live with the court's ruling. So
Well, and my
you
apologies.
can't. We're,
I humbly apologize, Your Honor. I believe they opened the door by talking about what the order said, who was responsible, who was allowed to contact who. But I apologize. I
as
really,
a reminder, I mean, we've been,
I get it.
and I know you weren't there for so many of the hearings and you kind of came in to this late, but we always talked about before you do something that is possibly out there on come talk to me ahead of time. You didn't do that.
I agree. And I did it the second time. So before the witness comes in, just so I don't step in it again, there are 3 notes written by the guardian ad litem regarding their observations of Maya at the hospital. May I inquire of this witness what the observations of the guardian ad litem were? And then at the end of
Absolutely, at the hospital, sure.
yes. And then just again, so I'm approaching.
All right, I'm gonna fast forward because I'm gonna give you a recap. Here's what he says: there were notes and observations by other people. That's outside the scope. You can't go and say what other people said. He tried to get the exception thing fails. A couple of points that are really important to make here, and I want to bring up 2 comments to do it. Jason Smith, yeah, but Rob, it's disingenuous. He knows that door isn't open and objects vehemently when plaintiffs approach that door. His sorry is followed by a bad excuse. If you will remember, this is me being fair. If you will remember back when Anderson jumped on the sword and basically had said, the judge brings him in and admonishes the hell out of him. And Anderson says, there were 52 summary judgment orders. I apologize. I did not remember that order. That might have been a complete disingenuous argument. It's a bullshit argument. It's not one that's a real argument. You walk in there, you know an order exists, or you're tasked with knowing the order exists. You know not to go there and you go over that line. So Anderson has done it too. He has. He stepped in it and he apologized when he did it. So did Shapiro. This is the judge ruling fairly. And with that caveat, this is why the judge is ruling fairly. Creed M. By the way, later the judge asked Anderson, are you asking for any relief? And he says, no. The judge asks for if Anderson's moving for mistrial. And Anderson says, no, not at this time. Because the judge isn't just going to say, you can move for mistrial and I'll wait until the jury comes back to rule or grant it. No, you either move for a mistrial then, or you don't. Or you ask for specific relief. One of the things that you heard was Anderson was talking about a curative instruction. What's a curative instruction? The jury is then instructed specifically that a comment was made and they should disregard that comment. What the judge suggests to Anderson, and what I think Anderson made a strategy call to do, was to basically say, apologies, my brain went somewhere else for a second, was to basically say, give me one sec. My brain just went to something that I need to make a note of. Otherwise, my brain's not going to brain and I'm going to forget. And it's probably going to result in a poll. And it's a question on, never mind. Okay. ADD, ADHD, focus. What the judge basically said was, Mr. Anderson, you have to think long and hard about this. Do you want me to give a curative instruction? Because what that's going to do is it's going to point the jury right back to that question. It's going to point it to that question. It's going to point it to the answer. And the jury is going to be asking, well, why was I told to disregard this if that's what her testimony was? And Anderson's going, if I weigh the evidence that's been heard thus far, how much weight is the jury going to place on that 5-second exchange? And is it important enough? And what's the risk of me asking the judge to go back and say, bring it up again after they've had this little time break, bring it up, bring up the question, bring up the answer, and then re-inform the jury, disregard it? There's an inherent risk there. And Anderson is weighing in the balance. He's going, risk reward. This is what attorneys get paid to do. This is one of the big factors in that. They basically are arguing to themselves, if the judge brings this back up, can that hurt my case? The damage was done. It was done. He could have asked for sanctions. He could have asked for something, but he basically said, I want to get on with my case. So what Shapiro did there, oh baby, not great. Not great. Nope, not good. But it was a judgment call by Anderson not to ask for the relief. And Anderson's, he's boots on the ground. He can see the jury. I can't. So, and this is the thing, the jury is already dying to hear about the orders. The jury is already asking the court, when are we going to see the orders? And if another fact gets introduced, if another instruction gets introduced to highlight the orders, doesn't that hurt the plaintiff's case? So I was remarkably curious. Well, not curious. This was something that I thought was, honestly, for Anderson, a decent judgment call. Because I think he's also weighing in the back of his mind, if the defense really oversteps, they can ask for a mistrial. And if they continue down this road, and also it's one of those things where, and I'm going to have to get to the end of today's testimony to give an explanation on it. It's one of those things where my question becomes, is the defense going to keep kicking that door, keep on punching at a possible mistrial? And how much more difficult is the judge's job going to be to keep these parties in line as the defense begins presenting their case? So let's go on to Sally Smith, because I've been waiting for her.
Seamus, I'm trading it gently.
Let's take a
I don't have any further questions.
When you
Mr. Anderson, Mr. Whitney, your next witness, please.
Dr. Sally Smith by video deposition.
Okay,
Just to inform the court, I'm told there's 5 different tapes. We'll have some breaks here.
okay. Watch this. I did. How's that? Alexis, please sit down. Please sit up. I went to school for that.
This judge's demeanor with the jury right now is it's impeccable.
Just don't ask me to turn it back on.
Would you raise your hand, please? Do you solemnly swear or affirm that the testimony you're about to give in this case is the truth, the whole truth, and nothing but the truth?
I do.
State your name for the record.
Sally Marie Smith.
And you were a pediatrician working for the state in the case of Maya Kowalski. Is that true?
I was the medical director for the child protection team, providing medical evaluation for Maya Kowalski, yes.
Following medical school, what did you do?
I did a pediatric residency. I did a year and a half of residency training at All Children's Hospital in St. Petersburg from 1984 to the middle of the end of 85. And then I transferred back to St. Louis University at Cardinal Glennon Children's Hospital. And I did the remaining year and a half of my pediatric residency there and completed that in 1987.
In your residency program, how long did you spend? And you rotate through a number of different areas, do you not, in
Yes.
residency? All right. How long did you spend in pediatric psychology or psychiatry?
I, again, did not look at my transcripts before I came here. I really have no idea specifically. I'm sure we had training in pediatric psychology and psychiatry as part of multiple components of the residency program, but I don't specifically remember like how many weeks or if I did a specific rotation or something like that.
Okay. And do you remember any of your professors, or I guess they're doctors that are also adjunct to a medical school that you were working with? Or I'm trying to figure out the setup there. And my question really is, were there any doctors who are also professors that specialized in pediatric psychology or psychiatry that you worked with over this residency?
I don't recall.
Okay. After your residency, what did you do?
I did an additional year of fellowship training in ambulatory pediatrics at Sandhurst University Cardinal Glennon Children's Hospital.
What is ambulatory pediatrics involved?
It was fellowship in, ambulatory is people who are not hospitalized essentially. And so I worked in clinics with various mentors, learning to essentially teach academic pediatrics in the clinic setting. I don't recall that I did any specific inpatient work as well.
What is academic pediatrics?
Pediatrics that is sort of focused on education and training of medical students and residents and interns, and in many programs in academic medicine, there are also research components.
Listen to her tone. We're going to go to 1 normal speed. Listen to her tone. And for those of you curious, I've already forwarded this to Spidey.
To the work.
The past 17 years, you've worked at Suncoast Center in one form or another, correct?
I don't believe so. I don't think that the Suncoast Center has held the child protection team contract that entire time. There was another agency called Help a Child that held the contract from the Department of Health. When I initially became the medical director, I've worked with the child protection team since 1990.
Okay. So when it says medical director, Suncoast Center, child protection team, were you working for Suncoast Center from 2002 to the present?
I've been the medical director of the child protection team from November 2002 to the present. It probably should actually say Department of Health rather than Suncoast Center, because Suncoast Center is just the agency that holds the contract.
Okay. Well, Suncoast Center started at ACH in 1979, did it not?
No, that was the child protection team, not the Suncoast Center. I'm going to guess it was around 2007, 2008 that the Suncoast Center took over the contract for the child protection team, but I don't remember exactly when that was. I'm not sure, sort of what corporate name was, assigned or that kind of thing. When I worked with the child protection team, in 1990, it was, their signage and things said Suncoast Child Protection Team.
Okay. Well, when did you return to All Children's Hospital after, I think you were at University of Medicine and Dentistry of New Jersey, New Brunswick, New Jersey from 88 to 90?
Correct.
And then you were back at
Chat, I need your help for something. I'm really torn. So Friday Night Frenzy is every Friday at 8 p.m. and I pushed it to 9 because I'm doing double header. Every Friday at 8 p.m. and I do a recap of some of the cases I've been covering. So tonight it was going to be Sam Bankman-Fried, the trial that's going on there. And it was also going to be some cases, honestly, I don't have a lot of facts on. I am torn because I am very sensitive to the fact that this particular trial is one that I'm not comfortable having guests opine on. I'm not. I have watched this trial with you guys from the very beginning. I've watched it from the very beginning, and I can explain the different evidence and testimony that's come in. And honestly, this is one where the jokes that are made without knowing the evidence don't land the right way. So the question is, I'm going to pose it as a poll with that understanding in mind. Now, keep in mind, Ian does a Monday stream where Ian does a Monday stream where he recaps some crazy cases, and I think I can give him the info on SBF, and that could be the Monday thing. I'm going to post a poll, and I'm going to stick with the results of the poll. So for the next 30 minutes, the poll is going to be up. And keep in mind, like the FNF is lighter. I like this case, guys. So let's bring Sally Smith on. If there are comments in FNF or gifted memberships in FNF, I will pull those up and I will read those here. And I will apologize emphatically for missing FNF. The poll should be live right now. It should be live. And you know what? I'm going to be fair about this. Some people wait for FNF. I'm going to post the poll there too. I want to consider their thoughts if people are waiting for FNF. Because there's a lot of people that are already that are very, very generous to this channel. I'm sorry for the delay. Sorry for also the fact that I'm just typing. Guys, I'm really torn. I'm really torn on this one. I love being able to explain law to a lot of people. Okay, let's go on with Sally Smith for a bit.
All Children's Hospital, it says a staff appointment from 1990 to present.
No. Well, my active medical staff, yes, has been 1990 to the present. I was employed by the hospital from 1990 to 2002
Okay.
in the general pediatrics division.
So you went residency for a period of time, then you left, then you came back and started with ACH?
In 1990, when I moved back to Florida, I took a faculty position with what was then All Children's Hospital, yes.
Would you agree with me then that you do not hold yourself out as an expert in pediatric psychiatry?
No, I do not.
Would you agree with me then that you do not hold yourself out as an expert in pediatric psychology?
I do not.
Would you agree with me then that you do not hold yourself out as an expert in pediatric neurology?
No.
I mean, you're agreeing.
I do not.
Would you agree with me that none of these, none of your training has involved an in-depth analysis of the diagnosis and treatment of RSD or complex regional pain syndrome?
I agree.
Now, at the very bottom of 33, the next to last couple lines is, the purpose is to solicit the medical director's opinion first, and then the statewide medical director's opinion, only if this is not sufficient. See that?
You're asking me if it says that?
In Maya Kowalski's case, was the medical director's opinion, was that you, or was there somebody above you, a medical director, whose opinion you could seek? Now, at the very bottom of 33, the next to last couple lines is, the purpose is to solicit the medical director's opinion first, and then the statewide medical director's opinion, only if this is not sufficient. See that?
Yes, I see it.
And who's the medical director there?
That would be me.
Okay. And then the statewide medical director's opinion.
Yes.
Was that ever, in Maya Kowalski's case, did you ever seek the statewide medical director's opinion?
I did recently, but I don't recall if I did at the time of the evaluation or not.
Tell me about who that was recently or is recently and what opinion you sought.
Dr. Bruce McIntosh reviewed the file. And I didn't personally seek his response.
Let me find your report here real quick. Page 8?
Yes.
All right. So, Johns Hopkins All Children's electronic medical record. What does that mean?
Well, as an active medical staff member for Johns Hopkins All Children's Hospital, I have access to the electronic medical record. So I reviewed that many documents from that medical record in compiling my report and reviewing the case. I did not print everything, so what you received of my medical records that have Johns Hopkins All Children's headings on them would be what Dr. McIntosh received.
All right, so Dr. McIntosh, according to you, received the medical records of Dr. Kirkpatrick, is that right?
Yes.
Dr. Hannah,
Yes.
is that right? Dr. Barr, is that right?
Yes.
Dr. Wassenauer, is that
Yes.
right? He did not receive records from Dr. Chopra, is that right?
Not to my knowledge.
Or Dr. Cantu?
I was never able to obtain records from Dr. Cantu, so I don't have them and did not have them to provide to him.
And so you were familiar with the fact that Doctors Hannah, Kirkpatrick, Barr, and Wassenauer all diagnosed or concurred with a diagnosis of complex regional pain syndrome, right?
That appears to be correct.
Tell the jury whether you believe that every mother that fails to remember to tell a new treating physician the entire medical history is committing an act of child abuse.
No.
Tell the jury whether you believe that every mother that fails to follow the directions of the doctor or the prescription to the letter is committing an act of child abuse.
No.
But in this case, you believe that Beata was.
Upon review of all of the extensive medical records, review of all of the observations of the child in the hospital, review of the, let's say, unconventional treatments, including hyperbaric oxygen treatment and high-dose ketamine treatment repeatedly, it was my opinion that there was ample evidence to support a diagnosis of medical child abuse. And it appeared most likely that Mrs. Kowalski was the primary one who was resulting in, or I don't know what the term is. It's not probably instigating, but initiating.
How much more can you parse your words? How much more can you parse your words?
Or whatever, the child abuse, perpetrating the child abuse. Let's put it that way.
Just the prednisone issues, the stuff we've been going over the last hour. Do you think that was an act of child abuse?
There was an element combined with everything else of child abuse in the prednisone utilization and administration to the child. Yes.
Other than this case, have you ever testified in court or by deposition in a case involving CRPS?
No.
Expert in pain management?
No.
Okay. Did you ever have a conversation with Dr. Kirkpatrick at any time in 2016 in which he offered to have you come over to his office?
So what was everything else? What was everything else? They deposed her multiple times. They are proceeding with Dr. Sally Smith by deposition. The reason why is they want to constrain her testimony to the things that are favorable to the plaintiff's case. The plaintiff's case in chief is the opportunity for them to do, well, what I think they did, which is to basically put in the mind of the jury a thought process that is so convincing to the jury that they are viewing everything that's being brought up by the hospital after the plaintiff's rest as skeptical. They have an eye towards everything there as being, well, not what they just heard in the plaintiff's case. So you want to control the evidence that comes in because you want to have that impression left with the jury so that when the defense starts going, the defense is climbing up a hill that you have created. And if they called Sally Smith in person and live, well, then you can't control what she's saying. The defense can cross-examine her and open the scope to different things. And then when you rest your case, the defense has, or the jury rather, has not just your narrative in their head, they have the hospital's narrative there as well. You've undermined your own case. So there was multiple depositions conducted of Sally Smith, as there has been for every one of these witnesses. And they stitched together the depositions. Deposition designations are basically when you want to present evidence to the jury by deposition, you video record the depo and then you submit the parts of the depo that you want played for the jury. The other side gets to object, and the judge goes home at the end of the day after his long day in court, goes home and reads through and says in, out, in, out, in, out. And then the attorney that's presenting the depo has to go back and cut the video up. Well, sometimes cutting the video up means increasing volume, decreasing volume, stitching different elements if it's too much video. So this one was just chopping up like 5 videos. So that's an explanation of the process there. So. Oh, come on, spinny wheel. Behave.
Office, and he would demonstrate to you with Maya or with another patient the testing that could be done to objectively determine the degree of pain a patient was in.
No.
You never talked to him about that?
No.
Okay. Did you have a conversation with Dr. Kirkpatrick in which he told you not to move forward with Munchausen by proxy or another allegation of child abuse?
I do recall that he made some such recommendation to me. I don't recall the exact words.
Did he express to you that there was an organic basis for this child's pain?
I don't remember specifically that he, spelled that out. I remember, at least in general terms, that I asked him about incongruities in the child's presentation, and he reported that that was a manifestation of allodynia prior to touch, conditioned to expected pain from human touch, and that there was a fear of pain component that explained the child's way that she was moving around and touching things and doing things, but then couldn't do those exact same maneuvers when a physician or a therapist asked her to do so, or things were touching her skin, and then when somebody had a light touch on her skin, that she would scream in pain when a similar amount of touch was not triggering that kind of response. So I remember that he and I had some discussion about that phenomenon. A fear of pain component can be explained, and therefore it was my impression that he was telling me that information as a way to indicate that there was no other possible diagnosis in the case, perhaps.
Video number 3. The microphone has one victory this evening, by the way.
I do.
Dr. Kreisman, a physician at Johns Hopkins All Children's Hospital.
I'm not going to lie. I don't hate the shirt. I hate the background. Like, the background is brutal. I will tell you what, I tried to use some of the blue background depo footage. What kind of monster puts a blue background behind someone they're deposing? This is horrible. Like, be nice to the person. My God. Give them one of those filters or something. This was... Celine, come on. Celine is the keeper of the score of the microphone and whether I mute myself or not. Blue background is nightmare. So, going on.
Examine Maya and note that she is not in any pain.
That was his assessment that day, yes.
And that she is not moaning, she is smiling, she is interactive, she is very engaged. Is that what he found? Is that what he found?
That's what he has documented in this note that references his examination of her when she was at his office on May 11th with her father.
And at the bottom of that narrative, he says
the voice shaking is weird.
Extremities show no clubbing, right?
That is correct.
What is clubbing?
So that is an abnormality of the distal fingers, essentially the area of the fingernails where the nail bed gets enlarged, and the fingernails often have an enlarged size across the tip of the fingers, typically related to chronic hypoxia or respiratory insufficiency.
I want you to keep in mind her voice here. Put that in your brain. Put it in your brain, right? Keep in mind your voice here, her voice here. When we get to the last depo, I want you to compare that in your brain with what you're hearing right now. Compare the two. Okay, please.
It's also a specific
Reading it back up though.
symptom of RSD, complex regional pain syndrome, is it not?
Not to my knowledge.
But you're not an expert in it, right?
I'm not an expert in complex regional pain syndrome.
And then he says she moves spontaneously in her wheelchair without incurring pain, right?
Yes, as was observed on other occasions.
Do you consider tachycardia to be an abnormality in a child this age?
It can reflect many, many different conditions in the child.
Well, what is tachycardia?
A fast heart rate.
Okay. In last deposition, you said that a fast heart rate would be an indication of somebody being in pain, right?
It could be.
But you put no abnormalities noted on her exam. That's not really true from the actual record, is it?
Again, you probably should ask the person who made the documentation. They may be referencing that, contrary to most cases of complex regional pain syndrome, she did not have any color change of her extremities, sweating abnormality, deformity of her extremities that would provide objective evidence to support her reported diagnosis.
Let me show you what's been marked as Exhibit 10.
Trying to find a date on this. 10/7.
And I'll reference you to, and I folded it over, the physical examination found on page 6 of 9, which is PLT 4074, and I highlighted under cardiovascular. Can you identify what that is first? What 15 is?
So this is the emergency center physician notes. I don't know, probably dictated by Dr. Bahar Posey in the emergency room. I'm sorry, what was the question?
Under the physical exam, does it note that under heart rate, she is tachycardic?
It does, and it states that her pulse rate was 134.
That's
So the testimony was basically these were manifestations. Now you're starting to see cross on this issue. Anderson does a good job in these depots. Very good job in these depots. 134 is high. Listen to her answer.
very high in a child of this age, is it not?
Well, 250 would be very high. It's elevated at 134.
Okay, that's not normal, is it?
Probably not.
Why did you put here in your report there were no abnormalities noted on her exam if she had an elevated heart rate that it can be associated with a child in pain?
I don't know.
Okay. So if you've got, if she's tachycardic, if she has problems with her eyes from the light, if she has her knees flexed into the abdomen, if she has allodonia, meaning she doesn't want to be touched, and she has lesions, you've got 5 symptoms of RSD right there, do you not?
No,
Okay. You're saying allodynia is not a symptom of RSD.
it is.
You're saying that, what do you call it when you're light sensitive? You're saying that's not a symptom of RSD?
No, I'm saying she was wearing eye covers. Was she photosensitive? I have no idea.
Okay. She did not want to be touched.
That is correct.
It's a symptom of RSD.
It could be.
All right.
Holy shit. She has gone full bull mode in this. Like she is. Oh, good point. This is a good point. I don't know. I don't know the heart rate stuff. When I heard 134, I was freaking out. I don't know, Michael Stahl, if this is right or not. I'm going to trust your judgment. I'm going to trust you guys. I'm not a doctor. I am just saying that, like, her posture, everything about her, completely closed off. I told you. I said this to Spidey. I am waiting. This is not just leaning. This is not defensive. This is attack. This is offensive attack. This is a defensive attack. She is sheltering abdomen, but also leaning forward, attacking. Look at how she juts. Look at everything there. I will run this by Spidey, but I can tell you right now, she is in attack mode. How quick she answers the questions. She does not like being questioned and doesn't like the fact that the person questioning her has the power to keep questioning her. She hates that the person that is asking her questions, she has to answer. Kevin Oak, Who is Spidey? Spidey is a friend of mine who has the channel called the Behavioral Arts. He is a he has background in psychology, psychiatry, and does a lot of body language analysis. I'm friends with the behavior panel as well, Scott Rouse, Chase Hughes. Spidey is my go-to on this stuff, and he and I talk about this kind of stuff. Mostly just to kind of say, is my gut telling me something because I'm crazy, or is my gut telling me something because this feels odd? This is like a linebacker entering to try and take out a running back. Defensive, but aggressive AF. Yeah. Yeah.
Could be a behavioral manifestation.
Okay. And she had a fast heart rate, right? Which supports being in pain, does it not?
It could.
Knees are flexed up into the abdomen. That can be an indication, right?
That's a positional description. I don't know what that has. I don't know if that has anything to do with CRPS criteria. It certainly isn't Budapest criteria, to my knowledge, that positioning yourself with knees up to the chest is confirmatory objective evidence of CRPS. I'm there to evaluate whether there is evidence to support a diagnosis of medical child abuse. I'm not there to complete my evaluation unless I have to by saying, I don't know, this is all the information. It could be either, you decide. My task as the child abuse pediatrician is to evaluate all of the medical records, look for every piece of objective evidence that I can, evaluate all of the information in context, look at objective observations both in the presence and in the absence of the alleged perpetrator, and try to put all that information together to assess whether or not there's sufficient evidence to support a diagnosis of medical child abuse.
Do you swear affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Doctor, this letter was faxed to your office on November 3rd, 2016, correct?
Yes, I think we established that.
This is the depot that drove me nuts. This is the depot that was like, if that last depot was the one that like pushed the jury a certain way, this depot is the one that, if Sally Smith takes the stand, she's doing so behind the 8-ball.
Why did you not mention Eagle's Wings history of treatment of Maya to the court on November 10th, 2016?
I don't know if I was asked about it or not.
How is it there's not a single mention of Eagle's Wings in your December 5th, 2016 report?
I don't know.
Again, your role and your stated goal was to be thorough, objective, and comprehensive in providing your report to the court, correct?
I provided this report in my role as the medical director for the child protection team. I believe it was eventually, presented to the court. At the time that I did this deposition, the report wasn't completed. So I don't know. I mean, I'd have to read the whole thing.
Listen to the voice. Listen to the voice. Just focus first, like for a little bit. Listen to the voice.
To see what, if any, discussion there was about Eagles Wings Counseling Center in that. If somebody asked me about it or not, I don't know.
All right. Table 6.2, the last bullet point, recommendations for confirming infectious disorder by proxy. Consider covert video surveillance. Did you, in fact, consider covert video surveillance?
There was, I believe there was a day or so that there was some videotaping of the child in her hospital room in an attempt to document the amount of movement that she was and the activities that she was undergoing in her room when people weren't present or when doctors weren't present.
Who directed?
Can I ask you guys a question? You saw the plaintiffs put up the notes beforehand. You saw them put up the notes beforehand. There was a discussion about videotaping at some point in time. That's a whole lot of vague. You saw the notes. You saw the notes. There was a discussion. Really, Dr. Smith? Really? You don't say, because now I have your notes from the risk management file. And the no order on the notes. There was a discussion, no order, okay to do when no one around. Need to see if she can walk without. You saw them. I couldn't freaking. This was the depot that killed me. This was the one that killed me. The defense has arguments. They do. I will get there. I promise you, I will get there. But this depot, if I'm the plaintiffs, every word of this was savage. Every word. Okay. As I promised, it's 8:30. I need to make the call. I need to make the call. I know this is going to disappoint people. I know this is going to disappoint people, but I know this case backwards and forwards. I have put too much time into this. It's too important to me. With 2,361 votes in this particular chat, 80% say stick with the recap, 19% say go to FNF. In the other chat, there's 300 votes. 38% say FNF, 61% say Kowalski. I have to make the judgment call based on, here's what I'm going to do. I have to make the judgment call based on the case that I know the most about, the case where I can give you guys something, the case where what I'm doing with these recaps, I hope it matters. FNF is great because it matters and it's great, but I'm sticking here. I have to. There's too much. I'm sticking here. Maybe that's bad luck for Friday the 13th, but I have to stick around here. I do want to thank Dawn Burke for gifting 5 memberships in the FNF, waiting for FNF. And Dawn, I am sorry. I am sorry. I am sorry. For those of you that are waiting for, I apologize. I sincerely apologize. I just really need, I need to cover this case. Shit. I'm really sorry, guys. FNF will be back. I promise you. I promise you. I tonight I need to make sure I'm doing the proper coverage of this one. So I apologize. I privated the FNF so that it's not there, so that you guys don't keep seeing it and redirect to it. Let me go ahead and correct this stream so it doesn't try to redirect to that. I was ambitious with a lot of this stuff. I knew that, but I thought I would be able to make it through. But now that we're on Sally Smith, there's no way. And this is way too important. I will find a way to make it up to you guys for the FNF. I will. I promise you, I will find a way to make it up. TGQ, I don't think you understand how much how much that show FNF means to me, and how much it means to me to be able to break stuff down and enjoy and laugh and have fun. It really does mean a lot. It does. So I'm not trying to be overly dramatic. It's just this case is really important. So we're sticking with this. All right, Dr. Smith, we're all in. Let's go.
To the video surveillance.
I guess I don't know, they have, a setup at the hospital.
Who directed the video surveillance?
I had discussion with the hospitalists. I don't remember exactly which one it was at that point in time about the possible benefit of that activity.
What did you find with the video surveillance?
There were numerous instances during the video which were comparable to numerous observations of the physical therapists, the nurses, the child life staff, the music therapy staff, etc., of the child moving around in bed, putting her feet in normal neutral position, using her upper body, her lower body in various movements that provided concrete evidence in support of all of the observations that were made.
Listen to her damn voice during this. Listen to her voice during this. Listen to this shit.
That activity.
What did you find with the video surveillance?
There were numerous instances during the video which were comparable to numerous observations of the physical therapists, the nurses, the child life staff, the music therapy staff, etc., of the child moving around in bed, putting her feet in normal neutral position, using her upper body, her lower body in various movements that provided concrete evidence in support of all of the observations that were made by numerous hospital staff.
Can you struggle anymore while trying to get that explanation out? I'm serious. Can you struggle anymore while trying to get that explanation out? Also, shout out to Emily Baker and Kurt and Ian and all my friends. Thank you for encouraging this. Thank you.
How does any of this indicate child abuse?
How does any of what?
The concrete evidence of her video of Maya Kowalski in her hospital room.
That was related to, she's 10. So as the children get older, there can be a component of the child having been sort of participating in the medical child abuse. One of the ways that this occurred in this case was that the child
had very inconsistent patterns of movement and reports of pain in response to certain movements, and numerous other observations that were made by the hospital personnel. So this was an instance in which there was specific objective documentation that could be presented if necessary regarding what was being described and reported by numerous treating providers at the hospital.
How much involvement did you have in Maya's care from the time of her admission throughout her sheltering at Johns Hopkins?
This part's pretty important. This part's important because she tries to, the gaslighting. I need to pause for a second because a lot of you guys have been like really generous in seeing how conflicted I was on this. Thank you. Teresa Morrow, Rob, we appreciate your dedication. It means a lot to patients that have been mistreated and treated like money, making opportunities instead of patients. All patients deserve to be treated with respect and kindness. Maya and her family were not. Teresa, I'm a lot of what the hospital did here was fucked up, like really messed up. I'm not saying they don't have defenses, and I'm not going to lie to you guys about the law or how the case is how the case is developing. I'm going to give you a fair articulation of the very big burden the plaintiffs have and how well they did in their case in chief. And I'm going to give you my best bet on what the case is going to do going forward, what the defense is going to do to try and combat that. I like this case because it's something that people never think they're going to run into, ever. They never think they're going to run into this. I have said how many times everyone is one bad day away from being on the wrong end of a system, a process, or an agency, or something that they are incapable of battling in that moment. This is a hard case because it's trying to explain a slippery slope in real time. But it means a lot to me to try and do that. And to do it respectfully in a way that doesn't make light of the arguments or thoughts of everyone involved. So, Teresa, thank you for that. That means a hell of a lot to me. It means the world to me. And right when I need to laugh, my friend on Civil jumps in. Let's try a joke to lighten the mood. Why did the attorney Carpenter have the most solid arguments? Because he knew the ins and outs of framing. That's a really good one, Kurt. I'm going to keep that one. It's a really good one. Casey Cat, remarkably generous. Thank you. Thank you, friend, for sticking with this for us. We're here. What does Emily say? God, you just put it on a mug. We live here now. We live here now. But we're not going to, when I say we live here now, this case might not be the easiest thing in the world, but I promise you, I'm not going to let you feel we're going to handle this right. Dawn Burke, this case matters. Thank you, Rob. Thank you, Dawn. Thank you. Megan, thank you. Thank you very much. Very, very, very generous. All right, let's go ahead. Sally Smith. God. These depot designations were brutal. This part gets really fascinating because now we're gonna start arguing about English language.
So as of October 13th, you mean? I talked to several physicians. I think we've talked about that already. I reviewed information as I was preparing my report.
And beyond October 13th, up until the time of your report, how much involvement did you have in her care?
I was not a treating physician.
That's not my question. How much involvement did you have in her care?
I had conversations with some doctors.
Did you direct any actions?
I had discussion with several doctors at various points in time regarding things that could be considered to improve Maya's safety and her And the effort to have her have a more effective.
Dr. Smith, would you like some more time to think of the words that you can not step in it? And you think the jury's not watching this?
Separation from her mother. There were a lot of times when she was Skyping with her mother, even though she was sheltered in the hospital. And so there were some discussions related to ways to minimize effects on her safety related to that.
Beyond discussions, did you direct any actions?
I don't believe so
That's a good
specifically. No.
Did the hospital look to you for direction?
I had discussions with several treating physicians at points along the way while she was admitted.
All right, let's look at what we'll mark as Exhibit 7. Dr. Smith, this is 2 sets of text messages between yourself and Dr. Major and Dr. Deese. So let's turn to the 3rd page of the exhibit.
She is not a state employee. She's
And-
privately contracted.
These were produced from your phone, correct, Dr. Smith?
Yes.
To orient the jury, as we look down through these text messages, we see, for example, in the 2nd text message, reply from SS. Who would SS be?
Me.
And reply from PD. Who would PD be?
Paula Deese.
Paula Deese.
Okay. So you have her number in your phone?
Yes,
She's a saved contact?
I believe so.
Let's look at the 2nd text from the bottom. This is a text from you to Paula Deese where you state, we may need to try to monitor what she's doing online. I wouldn't put anything past her mother.
I'm sorry, where are we?
Page 1 of your text messages.
Oh, okay.
So when you called Cindy, what did you learn?
I don't know.
No independent recollection?
I went there and I talked to some people. I don't know if Cindy was one of them.
All right, so we rolled past that one way quickly. You guys remember the text messages, right? Because the jury does. I can almost guarantee it. Let's go ahead. And what we're going to do is, for those of you who are tuning in and wondering, why the focus on whether she directed something? What's going on? What are we talking about, Rob? My gosh, this is confusing. The jury probably doesn't remember a text message from some point in time that they heard. Well, I can guarantee you they probably do. Let's do this, present this part of the screen. We can do this without making things look really ridiculous. Oh, we just did. We failed in that regard. This is the text message, November 5th of 2016, from Sally Smith. Fortunately, at 10 years old, she can't perform the charade effectively 24/7 and doesn't even know if she's making physiological mistakes. I'm coming to take some pictures of her, quote, affected, end quote, legs for court on Tuesday. The date of this text message is November 5th of 2016. I think the dates are wrong. I think there's an adjustment that needs to be made. Oh no, November 5th. That makes sense. So shelter order was October 13th, November 5th. Yep. Oh, the jury remembers. They probably also remember this part. These were her notes. October 7th, admitted. In the PICU, no video. Okay. Transfer requested on the 15th of October. That didn't go through. October 18th through the 20th. This is the 48-hour period. Video only, no audio. To see if she can walk on her own. These documents are in evidence. So, Sally Smith, you're saying you didn't give direction. The jury has seen these. Fortunately, at 10 years old, she can't perform the charade effectively and doesn't even know if she's making physiological mistakes. For example, like when your heart rate goes up, or you have an asthma attack and actually have difficulty breathing. Mm-hmm. Mm-hmm. So please, Sally Smith, after the jury has, and this is the other part about why you don't call her live. You have these queued up. You know what you're going to get into. You know what you're presenting. You have the order lined up. You know that once you get these documents in, they see the documents and they hear this testimony, and it becomes that much more impactful.
And I vaguely recall looking at some of the stuff. I know we had some discussion about what they had seen and what they had, captured on the video in terms of whether I really looked at any long review of that. I don't believe I did, but I think that I did have a discussion.
How many people are calling bullshit? I may have known about what was on the video, but I can't recall taking a long look at that. How many people are yelling bullshit? Oh my God.
With, excuse me, the people in that office about what they had observed, which, as I said earlier, was essentially documentation of many of the things that were being observed by the physical therapy, occupational therapy staff, child life, music therapy, in terms of inconsistencies about what Maya said she could do. And the pain that actions would cause, and what she would do when she was just acting on her own without somebody asking her to do something.
Doctor, do you also intermingle the professional life and personal life in your personal email address?
I don't use email related to patient care. I do receive email from, for example, the medical staff office on my personal email.
Okay. The medical staff office of whom?
Johns Hopkins All Children's Hospital.
All right, doctor, we've spent some time discussing your use of...
All right. Back up for a second. Look how defiant she gets. Look at that freaking posture. Are you kidding me? So one, bulldog, that's not turtling. That's fighting.
Without somebody asking her to do something.
This part.
Doctor, do you also intermingle the professional life and personal life in your personal email address?
I don't use email related to patient care. I do receive email from, for example, the medical staff office on my personal email.
Okay. The medical staff office of whom?
Johns Hopkins All Children's Hospital.
All right, doctor, we've spent some time discussing your use of different devices and technology. I'd like to direct your attention now back to the text messages. Was previously marked as an exhibit. The response to the fifth request for production from August 30th, 2019. And I'm on what's at the bottom, page 2 of these text messages. There's a message from October 21st, 2016 at 12:50 from you, doctor, to Dr. Deese. It says, "Hey there, just a few things about Maya. Do you have a minute for me to call?" Do you recall what you wanted to discuss regarding Maya on October 21st, 2016?
No.
Do you recall how long the call was?
No.
You were in close contact with the hospitalist, Paula Deese?
I had a number of communications with her during the time that the child was in the hospital.
Is that an answer? No.
All right. It looks like an hour and 9 minutes later at 13:59, perhaps after discussion, you write, also, probably already in progress, but maybe get her off as many meds as possible.
We're going to pause before she answers. Does that sound like a suggestion regarding care? Does that sound like someone that is influencing the care of Maya Kowalski? Not for, so her role right now, what she is trying to hide behind, what she is trying to portray is that she was acting in the capacity exclusively as an investigator. I'm going to bring this question up because it's a great question. Wheezy, can you take a second to explain what this lady's role was? In a word, well, in several words, we don't know. We don't know. And I'll explain that further. This is Dr. Sally Smith. Dr. Sally Smith was contracted. She was directly employed by Suncoast, who was contracted by the Department of Children and Families to perform a very special task. DCF needed doctors to essentially help them to evaluate which cases they need to investigate. DCF has trained staff, but it's expensive to directly train staff. So they will contract that out to third parties. They'll hire a doctor to say, can you go in and evaluate and see in the medical context, whether it's evaluating a bruise, a set of symptoms, actual Munchausen by proxy, can you go in and evaluate whether we need to take action? And again, DCF does not have authority. They have no role until they are brought into the case by phone call, report, or something else. Dr. Sally Smith also happens to be a member of the staff of Johns Hopkins All Children's Hospital. She's also on several of their committees. So she's already involved in the hospital. She's privately employed by Suncoast. Her role on the committees is voluntary, and she's contracted by DCF. So Wheezy, it's not just a second to explain what her role was. It's like the case to explain what her role was, because that's a big issue. The hospital is, well, let me walk through the plaintiffs, what the plaintiffs are alleging. The plaintiffs are alleging, and the facts seem to support, that Dr. Sally Smith, before any phone call was made to DCF, was contacted by a doctor in the hospital. And Sally Smith, before any involvement by DCF, pulled up Maya Kowalski's file using her staff credentials at the hospital. So she accessed her confidential records using her staff access to begin an assessment, and then began taking notes and relayed those notes and suggestions to different hospital staff and doctors to begin inquiries and push back on release and do these different things. I reiterate, before DCF was contacted. Then DCF gets contacted, but has not yet filed a petition. So DCF is contacted and Sally Smith continues. Now we don't know what her role is. Is she an investigator or is she a treating doctor? Treatment means you're diagnosing, you are administering medications, you are essentially directing care, or you are a part of the discussion that directs the care of the patient. Sally Smith right now in this setting between October around say 8th to October 13th, we don't know. She is trying to say that everything she is doing was in her capacity as an investigatory agent on behalf of DCF. That's what her argument is. That's what she is saying. That's what the doctors are saying. That's what the hospital's saying. The hospital needs to say that. They need to say that because the hospital doesn't have authority to do a lot of things that they do from October 7th to the 13th. Most importantly, if you want to walk out of a hospital, the hospital cannot detain you. They are not allowed to detain you or your minor child without a court order. That is called false imprisonment. That is called arrest. You are not allowed. The hospital does not have arrest power. They cannot just seize your person, deprive you of your liberty to walk around the planet without a court entering an order that says they can. That's the allegation of what they did. And the allegation is that they did that on the instruction of Sally Smith, who prematurely began an investigation that might not have existed had she done it properly. That's the plaintiff's argument. The defendant's argument is that everything Sally Smith did was in furtherance of her investigation, which was for a legitimate purpose on behalf of the Department of Children and Families, and that DCF is immune from prosecution, or not from prosecution, from lawsuit in this regard, because they are serving an important government interest in safeguarding minor children. And whatever inconvenience is bestowed upon the citizenry is outweighed by the benefit of the state protecting children that are potentially at risk. So now we have the tightrope that we have been walking in this case. That is Dr. Sally Smith. Sally Smith, Kathy Beatty, these two are Dr. Majors. These three are at the very center of this, because it is in what capacity are they acting? Are they serving a legitimate state function where they should be protected and immune? And I say should be because the legislature says so, not me. Or are they going beyond the scope of their authority and put it this way. If a cop arrests a bad guy before they have grounds to arrest a bad guy, is that something we want? If the cop breaks into a house without a warrant to search the house and then discovers that there were drugs in the house, do we want to encourage the cop to break into houses? Is that what we want? Medical records. I mean, now you can see the slippery slope we're on. This is where we are. And a lot of the rulings in this case so far, well, prior to the trial date, I was going, how did this get to trial? Then we get to trial and the rulings start to have this argument of whether this is an action done in furtherance of the investigation and therefore should not be presented to the jury, or whether it's done for diagnostic purposes or at the instruction of the hospital and is properly considered in a medical malpractice claim. And the judge noted yesterday, 2 days ago, that when the hospital said that the plaintiffs are presenting stuff that creates a mush, I think it was the word, a mush for the jury. They can't understand and parse the roles. And the judge said, well, Hopkins is kind of, J-Hatch is kind of responsible for that by having Sally Smith on staff at the same time that she was serving in this investigatory capacity. See, J-Hatch could have said, Dr. Smith, we're not going to have you on staff because you are an outside party. You're an investigator. We want neutrality. We don't want to create confusion in what role you're serving. And the judge is like, I'm going to let the jury hear a certain amount of this because it's a legitimate question with some of these things, whether she's acting under lawful authority in her capacity as an agent for DCF, or whether she is an agent for the hospital exceeding any authority the hospital has independently. That is the crux of this lawsuit. That is the fine line these attorneys are walking through. So I hope that answered your question. I really do.
You're suggesting action to the hospitalist on the case at this point?
We were discussing elements of.
Sorry, I'm going to rewind for a little bit because we lost the question. We're going to replay the question, and I want you guys to think. I want you guys to think long and hard. Does her answer to this question and series of questions help or hurt her?
Of the case.
Oh.
And
all right, it looks like an hour and 9 minutes later at 13:59, perhaps after discussion, you write, also, probably already in progress, but maybe get her off as many meds as possible. You're suggesting action to the hospitalist on the case at this point?
We were discussing elements of the case and the care.
Do you agree with the characterization that you're suggesting action on the part of the hospitalist?
As it says, I texted to her, probably already in progress, but maybe get her off as many meds as possible.
Would you agree that's a suggestion to the hospitalist?
That was part of our text discussion regarding recommendations. So I guess it was a suggestion. I don't know in what context.
And it's a suggestion related to Maya's medications while she's sheltered at Johns Hopkins, correct?
I believe I just read exactly what it says.
Do you agree with that characterization? It's a suggestion related to Maya's medications while she's at Johns Hopkins.
It was apparently a proposal related to her medications.
Is the decision whether or not to take Maya off of medications an evaluation?
As a child abuse pediatrician that provides assistance to many doctors at Johns Hopkins All Children's Hospital, I sometimes discuss with them testing or treatments or things like that may be helpful for either the child's well-being or for some element of my evaluation or things like that. In my view, the things that you're talking about here were discussions that I had with a couple treating physicians on a few occasions related to things that would improve my safety and assist in minimizing the effects of the medical child abuse.
Oh my God. Like word salad. Word salad. What the hell? What was that answer? And thank you for there's a comment that I need to pin a message real quick about FNF. Hang on. Recap went too long. Apologies, but no FNF this evening. So again, I apologize, but what the hell was that answer? That's not an answer. We had discussions. Did you suggest? I mean, I think you can view it as a proposal. Doctor, is that a suggestion? It's a proposal.
Were they treatment decisions? Removing from medication. Is that a treatment decision?
That was just a discussion that I had with the treating physician in terms of whether or not she, how she responded to my discussion or recommendations or suggestions to her. That's up to the treating physician.
Is removal of someone from medication a treating decision?
If I had gone in and written the orders myself and directed exactly when a dose was decreased and what medication was discontinued when and things like that, those would be treating decisions. Having a discussion with this physician about a child that we were both providing medical care for and medical evaluation for is not, in my view, a situation in which I was providing treatment for the child.
Have you ever seen a witness that stares daggers more intently than this one? Daggers. I could not believe the aggressive eyebrows, daggers. Yeah, Daryl Brooks, but wow.
So a treating decision is only made by the person that undersigns a particular progress note and not by the team that consults in making that treating decision?
All of these things, we've talked about were something I said, maybe, something I said, consider, are you doing this, things like that. So I'm not directing them to do specific treatment. For example, with the removal of medications, that had already been ongoing and mostly completed when I asked the question. So clearly that wasn't based on something I told them to do. That was
Oh, please reread the text. Reread the text.
just based on all of the treating physicians at the hospital, the pain management team, the hospitalists, and whoever. I said something about maybe get her off as many meds as possible. Yep, last med coming off today. So it's not like 7 minutes later, they had removed all of her medications based on.
Hold up. Hold up. Hold up. Who buys that load of nonsense? This is someone who sits on the committees at this hospital, who's still a staff member at this hospital, who everyone at the hospital knows serves this role as investigator tasked by DCF. And she says, I don't know, maybe you're already doing this. One, that sounds like a suggestion. If you're not, you should be doing it. Two, but if you haven't, maybe consider pulling all the medications gone. Does anyone read that as anything other than an express directive? Who's been in an employment position where they've had their boss say, well, I'm thinking of Office Space, the freaking movie Office Space. The guy goes over, so, if you could come in on Saturday, that'd be great. You know, we've got a lot of work. Come in on Saturday, just saying on Saturday, my name is Dr. Sally Smith. If you could, maybe if you haven't considered it, just saying maybe start taking her off meds. Just, yeah, that'd be great. That'd be great. Oh. These depots were saved for this moment in this trial
on my
for this
recommendation.
damn reason.
My question is very simple. Is removing medications from someone a treating decision? Yes or no?
I don't know.
You don't know if removing someone from medications is a treating decision.
You know, it depends on all the circumstances and stuff in terms of whether that would be considered treating and, you know, that kind of thing. I mean,
are you out of your Are you out of your fucking mind? Removing someone from medications, is that a treating decision? I don't know. What if it was antipsychotic? What if the medication we're talking about was an antipsychotic? Someone who suffers from bipolar or something really serious, a psychosis where they need an antipsychotic. Would you then say that removing someone from medication is a treating physician or is treating them? Well, I don't know. And I'm sorry, I am still saying the hospital has arguments in their defense that there's a lot of, like, there's stuff that makes people uncomfortable about how Maya was being treated prior to admission to the hospital. But this, shit. Yeah, Emily, I'm with you. Hey, doctor, you actually a doctor? I don't know. You've been prescribed the medication. If I say that you've been prescribed the medication by another doctor, prescribed by another doctor, and I say disregard that prescription, in what fucking world is that not me treating you?
And certainly that would be one thing that a treating physician might do.
Doctor, raise your right hand.
Tone shift. Remember I said listen to the tone. I said listen to the tone. Listen to the way she speaks. Ready for the tone shift?
Please. Do you solemnly swear the testimony you're about to give will be the truth, the whole truth, nothing but the truth?
I do.
Has your position insofar or role with Johns Hopkins All Children's Hospital changed in any way?
I continue to be a member of the active medical staff. That's my only relationship with Johns Hopkins All Children's Hospital. I don't really know anything about
Going 1.5.
how people at the hospital have some sort of employment or relationship or title or anything.
Who would you say was the person that you had the most contact with during the period of Maya's placement at Johns Hopkins All Children's Hospital? Which doctor? Would it be Michelle Smith? I mean, who would it be? Teppa Sanchez? Would it be Malik?
Her browser.
Who would it be?
My recollection, I spoke to Dr. Teppa Sanchez about the child once. I spoke to Dr. Vos about the child either once or twice. I never spoke to Dr. Malik.
After Beata's suicide, did you receive a call, text, any other communication from Dr. Major?
She's allowed to check her phone. Side note, this was likely what we call a deposition ducis tecum, where we essentially we issue a deposition. We say we are going to depose you. We want you to answer questions under oath, but we don't want you using the excuse that you don't have your documents in front of you. So we're going to ask you, compel you rather, to bring the documents that you need to answer these questions with you. That's why I say it's likely a deposition ducis tecum, where they said you are going to need access to your medical files, to your phone, to your records, and to your credentials.
Dr. Major and I exchanged a few text messages on January 9th and January 10th of 2017, all of which I believe have been previously produced for you.
I'm wondering, when was the last time you worked on a committee other than the credentialing committee?
When is jury? Jury goes to lunch on 2:52, so another few minutes. I'll go to the favorable attorney, to whom she answers quite differently. I will do that now. She was on committees, so let me see.
Participating in committees during time frame that I was, an employee. But since November of 2002, I have not received any compensation of any sort for being on any committees.
So it's fair to say, since around approximately the turn of the millennia, you have not been employed by All Children's Hospital.
Not since November 2002.
This Fifth Avenue Pediatrics listed on your CV from March 2003 to the present.
This is Mr. Hughes. So we're going to back up another second or two, because he's going to lead her down the yellow brick road of salvation. Or he's going to try. We'll slow down to real time so you guys can hear the voice change, or the change and shift in her speed and cadence.
In briefing, I believe there's also a claim that you took a faculty position at Johns Hopkins All Children's Hospital. Is that true?
No, again, I worked for All Children's Hospital, not affiliated with Johns Hopkins in any way, from 1990 until, from July of 1990 until, I believe November of 2002.
Have you ever been employed by Johns Hopkins All Children's Hospital?
No.
Any claim to the contrary would be untrue?
Correct.
How does it work? It seems like, from what you've testified previously, that you were medical director of the Child Protective Team, but that you were both employed by Suncoast and Department of Health. Can you kind of explain that dual employment arrangement?
Yeah, so as the medical director of a child protection team, I received direct compensation from the Department of Health for some components of my responsibilities. Typically, that has been about 17.
Did you notice the shake is gone? The shake is gone. She feels safe answering these questions. There's still the hesitation. There's the hesitation. There's the pauses, the ums, the uhs. That's her baseline. Her baseline is the ums, ahs, etc. But the quiver, the shake, whether it's an angry shake or a confused shake or a deceptive shake, I don't know. That's why I texted Spidey. But the shake is gone.
1.5 hours per week for the last, I don't know, 10 or 15 years. And The Suncoast Center Incorporated holds the contract for the Pinellas County Child Protection Team. I believe they have done so since 2008. And so in addition to the direct compensation that I get from the Department of Health, I also am in the role of the medical director for the Child Protection Team under Suncoast Center.
Over the years, my understanding is you've served on some committees with both All Children's Hospital and later Johns Hopkins All Children's Hospital. Is that correct?
Yes.
Okay. And pertaining to the times that Johns Hopkins All Children's Hospital, strike that, were you ever compensated by Johns Hopkins All Children's Hospital for any committee service?
No. Back when I worked for the hospital, I mean, obviously I was participating in committees during time frame that I was, you know, an employee. But since November.
This is a good point. Someone made this comment about how she has anxiety. Anyone that answers questions has anxiety, which is why you hear a little quiver. You will hear a little quiver in her voice. Compare what you're hearing now, tonality wise. You have anxiety, you're answering questions, with how much quiver was in her voice answering earlier questions about choice of care. Just compare it. Because the funny thing about this, people always laugh about body language, etc. Y'all, we do it every day. You do it every day. You ever feel like someone is spewing lies to you? That gut feeling you have, that's your assessment of their voice, eye contact, body posture, language. That's your assessment, and you get a gut feeling. Now, it's not a science. No one pretends for it to be that. But I guarantee you, here's the thing, I guarantee you, ask any attorney who's a trial attorney. Emily is a good example. I bet you for a fact, when she had a witness on the stand, she could tell you like that when the person was lying to her or not. Every freaking red flag was going off in her body, her being, because she knew. You can pick these things up. If you do trial work enough, you do depots enough. And the reason why trial attorneys are good at this is because we do the deposition and we get the testimony and we do it several times. So we get to see them. Then we get to see them when we call them out on a lie and how they respond and lie their way out of it. Then we get to see them again. So we see them enough that we're going, huh, okay. So that's your tell. That's your tell. That's rude. My mic is fine. Very funny though. But
November of 2002, I have not received any compensation of any sort for being on any committees.
Yep, Michael, perfect.
So it's fair to say, since around approximately the turn of the millennia, you have not been employed by All Children's Hospital.
Not since November 2002.
This Fifth Avenue Pediatrics listed on your CV from March 2003 to the present. What is Fifth Avenue Pediatrics?
That's the current name for the private practice that I'm a partner in.
Is that private practice affiliated in any way with Johns Hopkins All Children's Hospital?
No.
My understanding is you were first contacted by a Johns Hopkins All Children's Hospital physician in this case on or about October 8 of 2016.
This is about to be disproven. Well, no, October 8th. This is right. This is right.
Do you recall that conversation?
October 8th.
Generally, yes.
At the time that you were reached out to by Dr. Tepa Sanchez.
Side note, Tepa Sanchez, Dr. Tepa Sanchez, that's the corporate designee who is sitting in court. So Dr. Tepa Sanchez is there in court with the attorneys. She's at the front table, far side, who's sitting next to the other attorneys. That's their corporate designee.
Were you receiving that call as an independent medical staff position?
If I understand the terminology correctly, yes.
Okay. We want you to explain the difference between when you get involved in a case as a CPT versus if a doctor who needs a consult just contacts you?
Well, technically the child protection team can be involved in a case if there is a report to the abuse hotline. And
We're going to rewind a little bit because this is a whole lot of, I don't want to answer this question, and I'm going to answer it very, very, very carefully. This series of questions is really important.
yes.
Okay. We want you to explain the difference between when you get.
I'm sorry to keep pausing. I'm sorry. Bobby Graham, why are we looking at white screen? Because they're having a look at a document that's not in evidence. So that little notepad screen that's up, that's on the attorney's monitor that's playing the video. Because in the depot, they had a screen share that had something that's not an exhibit yet. So the attorney's like, I need to block this out so the jury doesn't see it. That's why. And I will pause the second we stop with Dr. Smith, and I will go over questions and super chats as quickly as I can. Smith's face. Let me see if I can't pull the banner down so you can see. I can't control where she is on the screen. I'm sorry.
Involved in a case as a CPT versus if a doctor who needs a consult just contacts you?
Well, technically the child protection team can be involved in a case if there is a report to the abuse hotline and either an investigator with child protective investigations or law enforcement requests for us to provide a medical evaluation. There are some cases over the many years I've been involved with All Children's and now Johns Hopkins All Children's, where that may or may not have occurred as yet, but a physician, knowing my expertise in child abuse pediatrics and my capacity as an active member of the medical staff, will contact me directly to ask questions about a case that they are seeing and seeking some guidance about whether or not there may or may not be abuse or neglect in the case.
Holy shit. Okay, let me recap that 15-sentence answer. Let me recap the answer. Oh my God. Here's the punchline. We're not supposed to be involved until we're called. On occasions, even though we're not supposed to be involved, some physicians with whom I have a personal relationship will contact me when they think that my expertise might eventually be needed. And at that point in time, I will discuss with them the particulars of their case, again, before I have been called and given any authority to do investigation. That's her answer. That's her answer. So all of that was the long-winded way of saying what I just said.
Case.
Is there anything wrong or unethical about a physician who has suspicions reaching out to a child abuse pediatric such as yourself for some insight?
I can't imagine why there would be. For example, if somebody, if a doctor thinks that a child might have a heart problem, but they don't know exactly how to proceed with further pursuing that, they wouldn't be unethical to consult a cardiologist.
Pardon me while I fucking scream. This depot was so critical to the plaintiff's case because and this is my hat off. Cheers to the plaintiffs for organizing your case in a way that when this depo was played, we had heard all of the other evidence beforehand. That's the point. We had heard all of the other evidence beforehand. Why does that matter? Why did I do a goat scream? Because what she just said is that 1, she doesn't have authority until she's called. 2, sometimes she fields calls from doctors that ask her for an opinion, even though she's not tasked to that assignment. 3, even though she's been called for an opinion, when the opinion is given, she is somehow acting in the investigatory capacity that she does not yet have because a call has not been made. And she argues that she most certainly does not act in a treating capacity. 4, we heard earlier that Dr. Hannah, who had been treating Maya, sought and requested privileges to enter the hospital as a guest, not even a treating physician, and was denied and was said that she had to be credentialed. She submitted her request to be credentialed, and they said no. Well, the Hospital Bill of Rights says that that patient can seek outside consults, and those consults shall be granted. But Dr. Hannah was not allowed to even speak to her patient, or friend, or client, or buddy. What Dr. Smith just said here is that she's special. She can bypass all of those other things, be treated not like Dr. Hannah, Dr. Kirkpatrick, or anybody else, and that it's okay, and how she couldn't see anything wrong with the treating physician contacting her. The problem is that all the evidence that we heard before this deposition, which is why I tip my hat to the plaintiffs, everything we heard before this deposition was that was not the norm. So Sally Smith just verified that she was special, which also goes to support the plaintiff's claim that she was able to direct treatment. So yeah.
That's on the active medical staff for guidance. I think consulting an active medical staff member with expertise in child abuse pediatrics, in my view, would be the same thing.
Is it fair to
But not anyone that's not medical staff or active medical staff. You can't look at anyone else who has a medical degree or expertise unless they are credentialed by this hospital. You cannot consult with them ever at all till the end of time.
say that when you were rendering services to in this case, that you were exercising your independent professional judgment?
Yes.
I guess my first question for you is, did you have a customary practice back in October 2016 and into 2017 as to how you would introduce yourself to a family where you're doing a CPT investigation?
Yes, I would state that I was Dr. Sally.
Sorry, funny trial moment. This is an oh shit moment by the attorneys. This is oh shit. This video is playing, and watch how fast, and you can hear the voice in the background. While the attorneys are like, oh no, this is up on the screen. This is a pleading / affidavit. Oh shit. People can see this.
Would introduce yourself to a family where you're doing a CPT investigation?
Yes, I would state that I was Dr. Sally Smith and I'm a pediatrician with the child protection team.
Do you recall doing that with Beata Kowalski?
Yes, I've testified in depositions before that Mrs. Kowalski knew exactly who I was. The timing of the meeting with her, et
This is
cetera,
important, by the way.
was arranged a little bit ahead of time so that I knew she would be there and she knew I would be there. And I believe there were people from Protective Investigations that were present during the interview.
Do you actually recall introducing yourself as the medical director of the child protection team to Beata Kowalski?
Yes, I do.
Okay.
Oh, there's a
And do you recall the
caveat
same with
here.
respect to Jack Kowalski?
Yes.
You introduced yourself at that time as the medical director of the child protection team?
I may have introduced myself as a pediatrician with the child protection team. I don't know for sure that I said specifically medical director.
Sure. But you would have said something about your role with the child protection team
Absolutely.
earlier this year. Did you ever represent to Maya Kowalski that you work for All Children's Hospital?
No.
Did you ever represent to Beata Kowalski that you work for Johns Hopkins All Children's Hospital?
No.
Did you ever indicate to Jack Kowalski that you work for Johns Hopkins All Children's Hospital?
No.
Did you ever prescribe medication for Maya Kowalski?
No.
Did you ever enter a progress note in Maya Kowalski's medical chart?
No.
Okay, to the best of your recollection, were you wearing a white lab coat with Johns Hopkins insignia on it when you met Maya Kowalski?
I don't have and have never had a lab coat with the Johns Hopkins insignia on it. I definitely wasn't wearing any such thing when I saw Maya Kowalski on either of the two occasions that I saw her.
Did you direct anybody with respect to Maya Kowalski's care and treatment at Johns Hopkins All Children's Hospital?
In the course of her hospital stay, there were times that I spoke with, I believe, Dr. Deese and Dr. Major with regard to the issue of medical child abuse and some things that could be considered in terms of demonstrations of movements that she was making that weren't consistent with the reported diagnosis of RDS, or what they're calling now complex regional pain syndrome.
RSD.
I had discussions with people
RDS.
about her course in the hospital, but I never was directing any treatment for her.
When you're working as the medical director of the child protection team for Pinellas County, is it common for you to discuss aspects of a patient with the patient's treating providers?
Yes.
And to your knowledge, did Johns Hopkins All Children's Hospital ever hold you out as Johns Hopkins employee or agent while you were rendering services as the medical director of the child protection team in Pinellas County?
No.
Okay. And at some point, I understand you talked to Dr. Anthony Kirkpatrick. Do you recall doing that?
Yes.
What do you recall about the conversations you had with Dr. Kirkpatrick? Generally speaking.
So what I recall,
Hang on. Pause real quick. Chat had a question. I'm going to answer the question. Here's the answer to the question. It's old. That would be Dr. Sally Smith in an all children's hospital lab coat. Old photo. Old photo. Well prior to this. But do you remember when she says, I do not even own? I do not even own.
was that I think he called and left a message and I called him back, and the one thing I definitely remember was that he told me that I should not evaluate the child for Munchausen syndrome by proxy because that was not a problem in the case.
Okay. And did you consider his advice?
Well, I certainly heard him, but if I had heeded his recommendation, I would not have been doing my job. And
What do you mean by that?
well, my job in this case was to respond to the request from the investigators and law enforcement as to whether there was medical evidence of child abuse or neglect in the case. And the only way to do that when the concern is Munchausen syndrome by proxy or medical child abuse is to gather extensive medical records as much as one can, review all of those medical records, put that in the context of information that may be directly obtained, such as the information I got directly from Beata. Ordinarily, one would consider one's physical exam, but in this case, I was unable to conduct a physical exam on the child, and then put all that information together to try to determine whether there's medical evidence of child abuse. So if on October 11th or 12th, or 13th, when I spoke to Dr. Kirkpatrick, I had just said, oh, Dr. Kirkpatrick says there's no Munchausen syndrome by proxy here, so there must not be, I would not have been doing my job.
Do you know who Dr. James Lewis is?
Yes.
Who is he?
He's a neuropsychologist. At the time Maya was admitted to the hospital, he was a consulting neuropsychologist for the child protection team, and he provided a neuropsychological evaluation of her as part of the evaluation under the child protection.
La Petite Morte. Exactly. It's because she's saying she doesn't have Johns Hopkins specific from before the partnership with Johns Hopkins. This is part of the parsing of words that to juries feels dishonest. It feels dishonest.
Team.
And he's not a medical doctor, is he?
No,
I believe he's a PhD.
correct.
Is it common for people like Dr. Lewis to perform a psychological evaluation of a child who's the subject or whose parents are the subject of an ongoing investigation?
He was doing so probably about 20 or 25 times per year at that time.
Well, do you know who he was employed by back when he consulted with Maya Kowalski?
He was contracted with the child protection team, and so when he would provide a neuropsychological evaluation for a child who had been, referred to the team for assessment, I believe he would just submit a fee-for-service type invoice or something to Suncoast Center.
To your knowledge, was he employed by Johns Hopkins Children's Hospital?
To my knowledge, he was not.
Other than the grand rounds that you've discussed, do you have any evidence that you received any compensation from Johns Hopkins Children's Hospital?
I have not.
Well,
this is their argument. Their argument is she wasn't paid. That's their argument. Their argument is that she wasn't paid. And Lorraine, that was a 5-second Google search. I guarantee you they have a photo like that if she's on the stand. Guarantee you. So, Anderson questions, and we have a tone shift.
That you were well, you never even told her that you were investigating her for allegations that she committed child abuse, did you?
Well, based on Mr. Hughes's
Doctor, would you like a longer pause to answer the question?
report of her email, I think we could, have a discussion of what she understood about what I was doing. But
No, this is
I
about you.
introduced myself as a pediatrician with the child protection team. I did not go into major detail about what that meant.
And you did not do that with Jack Kowalski, did you? In
I
that
did not
first
go
interview
into
with him, let me finish my question. In that first interview with him, you did not tell him that you were investigating him for possible allegations under allegations of child abuse of Maya, did you?
I introduced myself as with the child protection team. I did not go into detail about what that meant.
And you did not tell Maya Kowalski in your version that you were investigating her parents for child abuse, did you?
I was taking a medical history from the people in terms of
Answer
instructing
the
them
fucking
about that I
question.
was an investigator or something. I did not do that.
Just out of curiosity, what were you wearing when you interviewed the Kowalskis?
Business casual street clothes and ID badge.
Well, okay. And what does the ID badge say on it? Does it have your name?
Yes,
And it has Johns Hopkins on it.
it had a logo for the hospital as an ID badge would.
And what field of expertise did you hold at the time that Dr. Tepa Sanchez contacted you on October 8th?
Child abuse pediatrics.
Okay, and you had active staff privileges on October 8th?
I did.
You had privileges at Johns Hopkins?
Yes.
Is that the last one?
Oh my God, the tone. That depot, those depots. First of all, so to those non-attorneys in the chat, when we're doing depositions, we 100% that the person we're deposing is lying to us. We 100% believe and know that to be true. We still ask the questions because we know that we're going to find information later that's going to contradict the statement. but we want them on the record. We want them on a recorded statement, and in this case, hopefully videotaped, saying something that has you looking up at the sky and saying, no, that looks blue. It doesn't look green. It looks blue to me. Huh. Why are you telling me it looks green? It's that. It is something so audacious where you're like, you can't be doing this. You're not that. There's no way. There are so many people who work for CPS and DCF and doctors and treating physicians and school staff and guidance counselors who do the right fucking thing. That word salad, that's the same thing that I say about cops who go too far. No. This is not the ends justify the means. You do not get to step outside the bounds of what society has given you as authority and justify it retroactively. That's where my head goes with this. It is infuriating. I get angry. Yesterday's testimony made me mad. It was wild. It was wild. I have to catch up on a lot of super chats. A lot. And I can basically tell you right now, I'm going to prioritize questions because there's a lot. Thank you guys very, very much. Gifted memberships, Valerie, thank you. Dawn Burke, thank you. Thank you. Dawn Burke again, thank you. And Jay and Kat, thank you for gifted memberships, you guys. Amazing. Matt Bond. Ah, I knew it. G'day, my spiffy legal mumbo jumbo talkie brother from another mother. Yep, got to end the week with it. Well, Matt, I'm glad you're here. I'm glad that we got to replay that depo because I knew it probably drove you nuts. Nikki Lewis, defense tactics yesterday. On to a loser and try for a mistrial. I don't know. We'll get there. I promise you we'll get there. AG, cannot wait to see your take on the defense's blunder yesterday. We're going to get there. How did that happen? Do you think he won a strategic mistrial? I will answer that question. Susan Crespi, thank you for the gifted memberships. Kim, the Justice Junkie, thank you. Hi, Rob, is there a cap on the amount she will actually receive? From my knowledge, no. $220 is what she asked for. That's the max they can give her, I think. Casey Cat, friend, you are blowing up in every chat covering this case. People are loving your recaps. As always, thank you, Robert, and you know why. Thank you, Casey Cat. Thank you. These recaps mean a lot. Again, I practice in this area of law. I deal with this on a weekly freaking basis, and I have there's a lot of nuance that people are just taking hot takes on. Family law, if there was black and white, which is you either did a criminal act or you did not, family law is the gray. This is family law. Ange Torres, EDB shenanigans, welcome. I'll tell you what, that text, she texted me separately, and that text I got to keep doing this was meant a hell of a lot. It meant a hell of a lot. And it wasn't just her, it was a couple of friends that texted me and said, stick with it. And that's why I had a little pause there for a moment because it was very reassuring. Flora Nudie, having a son in and out of hospital for 15 plus years, I have seen my fair share of arrogance, ignorance, and mostly negligence. I am keeping a non-biased mind and cringing through it. Fiore Nudie, me too. I am trying to remain unbiased, but there are so many cringe moments that I'm like, this is hard. Horse welfare, are there phone records for the call-in evidence? I'm not sure. Grant Nassett, regardless of testimony regarding whom is talking, can the jury go, we have heard these people speak, and I believe it's Miss Beatty? Yes, they can. They are allowed to. Nikki Lewis is a parent of a child with special needs. This case terrifies me. I would not be a silent advocate for my child. I would be. Would I be deemed a pain in the ass? Everyone is one bad day away. Everyone. I'm not saying that's this case. Everyone is one bad day, one curse word, one kick to a tire, one frustrating comment to somebody away from being on the wrong side of a process they don't want to be on. Aaron Delport, Murdoch, was found guilty just because of a voice on a phone, which placed him right on the scene right before the murders. That was found by the jury. Karen G, hello. After being a longtime silent follower, maybe Kathy had a fixation with Maya, wanting to be her mother. Maybe she was the one with a psych issue. I'm not going to speculate on that. I'm not. I think Sally Smith had a lot of a role to play here that we don't really get to. And Torres, next week will be fireworks. Oh yes. Oh, it will be. It absolutely will be. AG, how's the level of misrepresentation of a memory refresher not sanctionable? It is sanctionable. I explained the ruling when it happened. It's sanctionable, but Anderson didn't ask for a monetary sanction. He kind of pocketed the goodwill with the judge. Like, I am telling you, judge, this is going to happen again. And when it happens again, I want more serious consequences. Sometimes that plays well. You pocket the judge's goodwill where you're like, I'm not asking you to do something you're uncomfortable with. I'm just reminding you or telling you I'm going to bring this up again. So it is sanctionable, but lawyers do that stuff a lot more than you think. Formerly known as, thank you for the gift membership, D Novo, freaking great name. This is Gary Case, but for the grace of God, go. Maya could be any one of us. So much manipulation for why this trial is technical and emotional. It's very difficult. I have been invested in trying to explain it the best I can. Ange, the questions we have not heard has pushed it towards this level. Ari Shapiro, kind of de novo. Thank you for gifted memberships. Ben Shapiro fabricated what the note said. Not denying that. Net Woman, thank you for joining. Nancy Joe Mo, I think Shapiro did it on purpose to plant the seed. We'll get there, I promise. Matt Bond, I didn't want to shine more light on it. I think that was probably the right move. Not Cupcake, since the plaintiff declined the motion for a mistrial. Can they bring this up on appeal? Should they not get the outcome they want? Realistically, no. What he said was, I'm making a record of it. That basically means that when I make my next motion, I want you to know that I have raised this issue before. That's what that means. So it's a complicated issue. I don't think we'll get there ultimately. So Sadie Jane, I may have accidentally bought 2 memberships. Can one of those be given to someone else as a gift? Sadie, I don't know. I don't know the answer to that question. That's a YouTube answer, and I'm not. I wish I did. You can contact YouTube. I don't know. Jessica MCFC. No way. 14 months. That's mental, but it's worth it. Been a lot. Krista Gibson got a copy of Buzzed today. Buzzed, the book written by my aunt. Thanks for the recommendation. I can already tell it'll be recommending it to colleagues. That's awesome. Thank you, Christy. My aunt's name is Cindy. I have another aunt named Christy. That's awesome. Who is Mr. Elegant? Mr. Elegant is the attorney on the plaintiff's side who has handled the appeal and is handling the jury instructions. KC Cat, full stream ahead on Kowalski. Love FNF. Can't wait till next week. FNF can wait till next week. Hey, Rob, we'll be late to FNF catching up on your recaps of this trial, but looking forward to it. I will bring it back. I promise I will make a special show when I can. I promise. Does she have a team of flying monkeys on her shelf? Says Mary Coppola. I don't know. Girl Scout, thank you, Rob, for the hard work on the case. Thank you. Valfield, do you think this will actually end in a mistrial? I don't think so. That's my gut. That's my gut feeling. Okay, I'm going to get into testimony again because I don't want to be here. We're already 2:48 in. We haven't gotten to day 2. So we are going to go to Dr. Newberger. And one of the funny things was this was a reading. This was a reading. So the attorneys are reading the questions.
The whole truth.
Yes.
Okay. You told me that there's some modifications and maybe supplements, if you will, to those opinions, and you gave me in a broad stroke format a couple minutes ago. Are those the sum total from a broad stroke standpoint of the additional opinions you've arrived at in this matter?
Do you want to hear them?
Well, you gave them to me in a broad stroke. My question is, what you just gave to me based upon these additional materials you've looked at, the modified opinions, the supplement opinions, however you want to phrase it, you gave them to me in a broad stroke already, and I'll get into them in a bit more detail in a moment. But were those the sum total of the broad stroke additional or modified opinions that you have?
I don't understand. I will tell you what those opinions, those supplemental attributes of the change of my opinions, if that's what you want to hear. Is that the question you're posing to me?
Let's go with that. Go ahead. But please, I'm asking you if you could just give them to me in a thumbnail version, and we'll take one at a time.
Sure. Well, Dr. Smith, from these new materials, it was evident to me.
Okay, so why is this being read out loud? Here's why it's being read out loud. So we have Dr. Newberger, who was one of their all-star expert witnesses. And early in the trial, we covered a moment when the judge called counsel up to the bench. It was just Anderson and Hunter. And he relayed information that clearly made Anderson upset. And I think it was the information that Dr. Newberger was in the hospital. So he could not testify live. He's hospitalized. So what they did was they had to scramble and go back through his depositions. Well, they didn't have a lot of videotape on the depots. They had depots that were transcribed by just transcript. Just transcription. So when you have a transcript and you don't have a video and you have an unavailable witness, you can read it in. This is what this is. So Mr. Whitney is playing the role of, presumably, Mr. Anderson. Mr. Anderson is playing the role of, presumably, Dr. Newberger. And they read the deposition in as if it were live testimony. If it sounds boring, it is boring. They take a break because the jury is about to pass out. As you can see here, 10-minute break because the jury is about to pass out. And they continue reading. And then they get to the video. But before we play the video, I want to play this part because the jury questions are my favorite. Side note, stretch break. Oh, Emily, they stole your phrase, stretch break. I'm giving that to you. That's yours all the way.
Okay, 5 minutes, no more than 5 minutes,
No,
okay?
5-minute break.
So do not discuss this case amongst yourselves. Do not do the investigation and receive no information.
I for jury questions.
And members of the jury can stand and stretch.
Where's the question? I need the question. I need the question. Oh, Jules. There's Jules. For those of you who are wondering who Jules is in the chat, I like the color. That's sorry, not gonna do like that. I'm gonna do a better pause game here. So, Jules, with whom the chat is engaging in the moment, has been a great resource for kind of how the jury's perceiving the case. And that's Jules sitting right there talking. She's the brunette with the hair clip talking to the other person back there with the pink, lovely shawl. I also love the color choice. Just a big fan. So that was there's Maya Kowalski. We got a jury question. Yeah, Kyle did get a haircut. Looking spiffy. The dad has remarkable choice of attire. I like his suits too. Come on. I'm waiting for one question, folks. One question. Guys, it's one question. We're not in the 5-minute break already. No, it's still sidebar. One freaking question. Come on, guys. Spinny wheel, spinny wheel, spinny, spinny, spinny wheel. Yes, Matt, you're rubbing off on me because the questions of Spiffy. It is at the end of the witness. This is the end of the video depot because they're having the sidebar for the jury notes and questions. You see that? That's where the judge reads the question. So in 1837.
Conclusion of hearing all of the evidence from all of
Not that question. Come on.
mind the jurors that there's still
Chanley
experience.
is there. This part. Judge. Stream. It is not my internet. It is not my internet. I promise you it's not my internet.
Perfect.
I'll do better next time.
It's not my internet. I will play Newberger's testimony in just a second. And then we're going to bypass Jack and Maya and go to the experts. The legal cat lady. Rob, you said it's family law. Isn't it personal injury? It overlaps. Family law is usually about divorce. No. Is it family law because they took custody of a child? Yes. That's the area of law that I practice all domestic relations litigation. This area of law is exceedingly complex. And where I have a lot of clients stuck in very complicated situations. So even though this is personal injury, this has a very significant overlap with areas that I cover, rather I practice in quite a bit.
Appreciate the note. That was
There you go. Ready?
perfect.
Make sure that I'm not at 1 point. Okay, good. Normal speed. Here we are.
Do better next time.
I think the jury wants to hear the question.
Okay. Mr. Anderson and Mr. Whitney, in the future, when assuming the role of different people, may you please use unique and different voices and project your voice out into the audience so we have a better experience. Wigs may also help. Signed by A Little Levity. I appreciate that. Now, let's turn back to the other notes that also got.
He can't answer them, but it was the break in the trial. This jury is, I would say, just a dream jury for plaintiffs, like a dream jury for the plaintiffs. Why do I say the plaintiffs? Because they're really attentive early and they are starting to form opinions. And if you don't believe me, wait till you hear the first jury question after the economist testifies. It's been a wild ride. Dr. Newberger, I'm gonna play about 3 minutes of him and we'll go forward. Dr. Newberger's music is on YouTube, Spotify, etc. Seriously? Value the okay. I believe you. Whiskey Sour, Rob, how do you deal with hard trials and keep them from eating your soul? I make things. I make a lot of things. I go in the shop and build, and I make pens and desks and tables, and that's how I do it. I make things. I wanted to catch a question real quick. Scroll. Matt Bond, thanks for the comment for a swear pillow. My spiffy legal mumbo jumbo talkie brother for another mother. You got 2 since we missed last night. Thank you, Matt. Swear pillow was for Dr. Sally Smith. Where was your comment / question that I wanted to get to? It was relevant. It was regarding the trying to cause a mistrial. And if it's with regard to that, I have to wait a minute because I have to get to the other part of the case. So Newberger first. His actual video depo. Because the video, he's a spicy witness. Spicy witness.
I understand there's a video of deposition 3 coming. So I get to turn the lights off. I am told this is approximately 30 minutes. Is that correct, Ms. Lawrence? Thank you.
We're going just a few minutes.
Just what you want, dimming of the lights, right? Yeah. Okay. Mr. Reyes? Yes, Your Honor.
Will you raise your right hand, please? Do you solemnly swear or affirm the testimony you're about to give today be the truth, the whole truth, and nothing but the truth?
Yes.
Thank you.
Okay. Doctor, since there's been an objection, let me just ask you, to date, how much have you been paid for your expert services in this case?
It's approximately 69 plus 78, plus $98,000.
Okay. So 68 plus 99,000?
69,000, as I understand it, plus the recent submission of 98,000 that I've been paid.
That's approximately a total of what, $165,000 thereabouts. Can you please tell us what those opinions are?
Sure. Third line up at the bottom, the evidence
Mr.
of
Reyes.
multiple references to team decisions and abrogating personal responsibility.
Just a moment.
Sorry, just a moment, folks.
Bless you.
Bless you.
$65,000 thereabouts. Can you please tell us what those opinions are?
Sure. Third line up from the bottom, the evidence of multiple references to team decisions and abrogating personal responsibility and deferring virtually all principal diagnostic medical judgments and decision to Sally Smith. In addition to this opinion with regard to team decisions, I intend to opine that this so-called team represented a group of individuals who together agreed to commit an unlawful act and to harm other individuals. Second,
Why did you not put that into your report initially?
actually, it's something that just occurred to me within the last few weeks that this aggregated into a much more serious concept than just the multiple references to quote unquote team decisions that you can see on the 5th page of this opinion.
And what was your second opinion you were going to get to?
Okay. The second one had to do with Dr. Smith's, Sally Smith's, being observed by one of her colleagues, Dr. Kilgore, to have actually affixed a copy of her report to the hospital medical record. An action that, in my opinion, would typically be done by a member of the hospital staff to conform any and every person who picked up the paper medical record of her opinion. This went beyond the self-identification of this woman as an outside consultant, as an internal operator, for the same reason I just gave you. I've been giving this recently a lot of.
So this follows what we heard from Sally Smith.
As I re-reviewed these documents and saw how these individuals interacted with one another in order to harm someone and to commit an unlawful act.
Okay, doctor, are there any other opinions other than the ones you just disclosed here today that you intend to offer outside of your report and outside of what you just disclosed today?
Objections form.
I'll go ahead. So outside of your report, outside of the two opinions you just disclosed here today, do you have any other additional opinions that you intend to proffer at trial?
Yes.
What are they?
That Smith's and the members of the team, including Major's, medical approach diverged from the accepted standard of care for hospital treating physicians to conduct a systematic and rigorous differential diagnosis in which all alternatives were seriously considered and honestly represented. Third, oh, wait a second, that's 3. So this would be 4. That the careful attention to this child's presenting complaints, past history, and current hospital course with regard to her pain and distress, ruptured family relationships, and her request for analgesic medication with opacity of sympathy, with a propensity to blame not only the mother of the perpetrator, but the child as a willing and intentional collaborator, rather than to understand the child as a suffering individual supported by loving and caring persons.
Dr. Newberger, do you have any other opinions outside of what I believe are the 6 that you've addressed here today?
I do.
It's like the 6th time he's asked that question. Newberger has all the opinions, but again, this dude invented the field of like child psychiatry. His credentials. The reason the plaintiffs were so devastated they couldn't have him testify live, this dude invented the criteria behind what it means to be a child psychiatrist or psychologist. I wanted to see this guy live so bad after hearing his credentials.
And that,
Can I interrupt you for just a brief second, Dr. Newberger, and ask why none of these opinions appear in your February 2022 report?
Because I've been thinking about this recently. And
Doctor, can you please be brief and let me know what other opinions you intend to proffer? Because I have several questions for you, and I'm really not getting anywhere. So please, just in a succinct fashion, tell me if there's any other opinions you have that you're going to address at trial.
Yes.
That aren't in your report.
The separation test that these conspirators proposed was based on a flimsy notion that this child could be hospitalized and weaned from some of her treatments, having her port removed to administer ketamine, and for that matter, immune serum globulin for her serious asthma attacks, and medications that allayed the pain of her neuropathic syndrome, pain which was excruciating. But Elliot specifically proposed continuing the weaning from gabapentin, which is one of the neuropathic pain medications. The separation test, in my opinion, was preposterously.
Side note, I was on gabapentin for a while. My brain would not stop working the end of the night, and the doctor tried it on me. Okay, I understand this. Okay, we're now in a field. Sure, keep going, doc.
Conceived and cruelly executed.
Doctor, have you ever treated pediatric conversion disorder?
Actually, it's interesting that you mentioned that, because I've had a long and deep experience in treating Munchausen syndrome by proxy. And when Munchausen syndrome by proxy occurs in the eyes of some experts, sometimes children are seen somehow to collude with their parents. And sometimes they're labeled as having a form of conversion disorder. This notion was mentioned by several individuals here, never systematically assessed by a child psychiatrist in any of the places where it was addressed, including this hospital, where the psychiatrist basically made occasional rounds, but never really conducted a systematic child psychiatric evaluation.
Doctor, I'm going to have to interrupt you here. My question that was asked was, have you ever treated pediatric conversion disorder?
The answer is yes.
Okay. What is the standard of care treatment for pediatric conversion disorder?
The standard of care is doing a full mental status examination, often supported by psychological studies, and attends to the standards articulated in the Diagnostic and Statistical Manual of the American Psychiatric Association and to the counterpart standards of the American Academy of Child Psychiatry, where I've published extensively over the course of the years and participated in their local and national meetings. This requires a rigorous and careful approach. It's not a diagnosis that you make casually because a mother has been accused of something and a child has been accused of something. And in this case, for example, among the preposterous accusations having to do with conversion disorder was that somehow when she had an asthma attack, she was actually faking the contractions of her intracostal muscles because
this part,
she'd learned how to do this to accommodate her mother. This was a paperback notion of conversion disorder, which was preposterous on its face. First of all,
a paperback version of conversion disorder that was preposterous on its face. When I say that I wanted this testimony in person and live, this guy would have been wild.
Well, children can't do this. This is an autonomic response when you're gasping for air and you're trying to do all possible to open your lungs and pull air in. That's where you see intercostal contraction. So
please finish telling me what the standard of care therapy is for pediatric conversion disorder without talking about anything in this case. I just want to know, generally speaking.
Mr. Hughes, the attorney, I have been there, my friend. I apologize for laughing because I have been there, where the witness just wants to go off on 9 million tangents. Side note, me too. Squirrel, got it. You are not going to get a straight answer out of this, Doc. No way. Oh. Dr. Newberger, if you could please, just please, I beg you, just answer the question I ask. Please, God. Please just do it.
What the standard of care for pediatric conversion disorder is?
The standard of care is to address the underpinning personal conflicts and their surround in expression of symptoms of compromised social relationships and family relationships, and typically involving dynamic psychotherapy. This was not considered here. It was not done here. There was nothing rigorous at all among the various professionals who suspected a conversion disorder, but did not conduct a rigorous assessment of it.
Okay, doctor, again, just please focus on the question that I asked.
I've given you my response.
Okay, thank you. Okay.
Doctor, focus. I'm sorry, but it's just like same. Doctor, same. Focus. Sorry.
Have you ever used ketamine to treat a pediatric patient?
No.
What is your understanding of the standard of care therapy for pediatric complex regional pain syndrome?
I'm not familiar with the current standard of care regarding the use of ketamine in children. As we're probably aware, recently, and I'm talking within the last year, ketamine has been seen to be of enormous value in treating, for example.
He just, like, that question was there and he was like, I'm going to go to the next exit. I don't want to be on this exit. I'm going to go to the next one. Like, we're just going to go right past that to the next question. No answer. But Doc, man, You got this.
Post-traumatic stress disorder, severe depression. And it's begun to be used in adolescents as well as adults under controlled circumstances. I am not, however, a practicing psychiatrist, so I do not know what the current standard of care is for treating any condition with ketamine.
Okay. Well, my question, right.
Oral or parenteral.
But my question was, do you know, what is your understanding of the standard of care therapy for pediatric CRPS?
For pediatric CRPS, also, it's my understanding that this is evolving, that there are minima that are specified as acceptable in the United States, very restrictive with regard to how much ketamine could be given, where now it's understood that this is an issue of titration. And that's what my colleagues at Boston Children's Hospital in the anesthesia department have noticed
Also,
and published about. But I don't know
not
precisely
an
what that
answer.
standard is now, Mr. Hughes.
Have you ever treated pediatric CRPS?
No.
Does ketamine cause withdrawal, doctor?
As I understand it, from my reading of the current literature, there are some symptoms after the use of ketamine, but it is not a withdrawal in the sense that an opioid,
Not an
alcohol
answer.
can, for addicted people, cause withdrawal symptoms. These are transitory memory losses, occasional odd and intrusive thoughts, which go away in short periods of time. That's my understanding of whatever may be associated with the stopping of ketamine for its prescribed uses.
Have you, and I think you indicated you reviewed records from Lurie Children's Hospital, is that correct?
I've reviewed some records in which there was speculation about a conversion disorder. It was,
Do you recall anything else from the discharge summary from Lurie Children's Hospital?
I have it here in this huge pile of information, but I don't recall anything else.
Dr. Newberger, have you reviewed any records from Tampa General Hospital?
I have.
Again, Dr. Newberger, the question is, what is your understanding of the discharge diagnoses that Maya Kowalski received after her care and treatment at Tampa General Hospital in 2015?
I actually don't remember the discharge diagnoses.
Have you ever reviewed Dr. Hana's medical records?
I have.
Did you see a prescription from Dr. Hana dated October 5, 2016 that references malnourishment?
I do recall his concern about her growth, stature, and progress of weight, but I don't recall that particular 2016 notation. His file is very thick, as you know. So if you want to show me something, I'm happy to entertain it.
Doctor, what is your understanding of who referred Maya Kowalski to Johns Hopkins All Children's Hospital for the October 7, 2016 hospitalization at issue?
My understanding is that she was having excruciating pain, and they came to the emergency room hoping to be able to get urgent pain relief.
Do you know who made that referral?
No.
Is that a no?
Is
that a no?
I said no.
I just wanted to clarify. Did you ever take any licensing board examinations to have a child abuse pediatrics board certification?
The answer is no.
I'm gonna get to his answer. I want to pull this up because I pulled this up out of order. Christine was saying, "Did you see my earlier one?" This is the earlier super chat. The judge stating the evidence of the defendants is very relevant, and J Hatch created a mush. Do you think he's starting to see the plaintiff's side more? What I think is he's making evidentiary rulings on the evidence that has been admitted in court so far. The expansive view of evidence that he's allowing in is based on the evidence that was allowed in prior to that. I know that's a weird way of saying it. You don't know if something is relevant now unless you heard information 5 minutes ago that would give context to what you're about to hear. Everything is a developing story. People have said, why are they calling things out of order? Why are they pausing? Why are they not telling the jury the whole thing? And I said, they're storytellers. Let them tell their story in the order of the story. The same thing goes for evidence. The arguments being made now about the mush would not be as impactful if they hadn't been able to present information that showed what a mush it was. So I hope that's the answer. But let's get back to Dr. Newberger, because his answer to this question is one of my favorites.
Oh, but it requires a bit of deeper explanation, which I will now give you, which I don't believe I testified to previously.
Hang on. The audacity. This doctor goes, No, I'm not board certified in that, but it requires an explanation that I will now give you. You don't have to ask me for it. I will now give it to you. And it's different than what I've testified to before, / it goes beyond what you asked me before.
In the
This is the
Was that
question.
a no?
I said no.
But I just wanted to clarify. Did you ever take any licensing board examinations to have a child abuse pediatrics board certification?
The answer is no, but it requires a bit of deeper explanation, which I will now give you, which I don't believe I testified to previously. In the late 1990s, under the aegis of the American Academy of Pediatrics, a group of physicians, including people like myself, founders of the field, met to consider whether we should have a subspecialty.
This dude is about to break down. This dude is about to break down how he met with the founders, the forefathers of child psychology and created the fields. He is literally about to say, I went up to a mountain and carved into stone based on what we viewed as a consensus. And they try to cross him on, are you board certified? Are you board certified? He's like, son, I created the board and the certification
In this field. And there was discussion about what this might be called and what would be the foundations with regard to clinical practice and behavioral, social, and medical science. And it was a very productive conversation among people that I knew very well over the years, because I taught at their institutions and they'd read my publications, and some indeed had served postdoctoral fellowships in my in the 17-year pendency of my federally funded training program at Boston Children's Hospital, which trained some of the leaders in the field. The discussion was around what we should call this specialty, where someone to be approved by the American Board of Medical Specialties. And the consensus at the outset was we should call this child abuse pediatrics. I objected for the following reasons: that if we were to call this child abuse pediatrics, what it would result in would be a small field of people who would be assigned the task in.
Did you guys catch that? This is the doctor. This is one of the doctors that was behind giving the fucking title that Sally Smith now holds. This is the doctor who was in the room discussing, what do we call this field of medical study? And Sally Smith's like out here going, I'm a doctor in this. And this guy's like, nah, I created this field. I heard this man and I instantly understood why Anderson was so upset that he could not testify in person. I only hope that the jury gleaned from his depositions any percentage of the information this man had to convey. He was a phenomenal witness.
Hospitals, a thumbs up or thumbs down, this is child abuse or not. And that was an overly simple technical function, and further, couldn't be based on any body of science which would justify creating a new specialty with this name. Rather, I argued, it would be far better to call this specialty, taking cognizance of the fields of forensic psychiatry, forensic pathology, to call this forensic pediatrics, which would have as its foundation child development, family development, behavioral science as it manifests in relationships and in violence in relationships, biodynamics in regard to the transmission of various vectors and forces and flames and the like that impelled injury, which would be understood in those frames. But where the objective, as the other forensic medical specialties would be, to inform decision makers in the legal sector with authoritative opinions about the science that was important to their decision making. Anyway, I made this point, there was some consideration, but the consensus was to call it child abuse pediatrics. And ultimately the sub-board had an exam and a certification process. And I decided, as one of the founders of the field, that I would not take this exam. Instead would apply to the peer reference group, the Ray Helfer Society, to be an emeritus member. And they happily accepted me, and I've been an emeritus member ever since. And I do this every year.
Oh my God, that was amazing. Oh, that was so great. Hughes tried to cut him off like 10 times. Oh, oh, that was fantastic.
Okay, thank you, doctor. You're not a pediatric critical care physician, are you?
Who gives a shit after that spiel? That's the point. Who cares about what quote unquote credentials this man holds? Did you not just listen to everything he just said out loud? You think the jury cares at this point? He's like, I am the father of this medicine. But are you certified? I'm certified to be your father and I will smack you down. He was one of I love this guy.
You don't have board certification in pediatric critical care medicine? You're not a pediatric anesthesiologist, are you?
No.
You don't have board certifications in pediatric anesthesiology?
If it helps you, I can say my only board certification is in pediatrics.
Okay.
He doesn't give a shit about the certifications. And you know what's funny? No one on the jury does either. And the more that they highlight board certified, and the more that they hear witnesses testifying to how much knowledge they have in the field, and the cross-exam question is, but you're not board certified. Do you think anyone on the jury thinks that board certification means jack shit right now? No. Because the plaintiffs hired expert witnesses that would break that mold, that literally would make the jury say, board certification is a rubber stamp. And it's important. I'm not discrediting that. It's important. People that are board certified go through a lot of testing to get there, and they have an expertise. But to say someone who's been practicing in the field for 30, 40, 50 years is not quote unquote board certified when they've been practicing in the field for that period of time. Dr. Newberger was like, Mr. Hughes, if you wouldn't mind taking a seat, I'm going to school you a bit.
Even though I have two subspecialties, behavioral and developmental pediatrics and child abuse, but my only board certification is in pediatrics.
Do you know when that port was surgically removed?
I don't.
Were you aware that it was surgically removed?
Yes.
How did you come to know that?
It's in the records somewhere, and she certainly doesn't need it now if she doesn't need either immune serum globulin because her asthma risk is lower than it had been, and her ketamine because her CRPS is in a favorable condition at the moment.
Did I forget if I asked you now, doctor, and I apologize if I already have, but do you know when Maya last received IVIG?
No.
Do you know what I mean when I say IVIG?
Yes.
And what is IVIG?
It's a protein that's composed of immune-rich serum that operates to enhance one's ability to fight the allergic concomitants, the immune concomitants that precipitate asthma. And it's demonstrably a very valuable preventive for possibly fatal asthma. And this child, without question, had very, very severe asthma.
And do you know who diagnosed Maya with an immunodeficiency disorder?
No.
You know when she was diagnosed with an immunodeficiency disorder?
No. No.
How many times have you spoken with either Dr. Kirkpatrick and or Dr. Hanna?
0 in both.
Do you know what Dr. Kirkpatrick's board certified in?
Yes. The depot's going to hurt.
I forget. He's a distinguished professor of critical care or something like that, but I don't recall exactly what his very high honorary degree at
Honorific,
University of
I think
South
is what they
Carolina,
call
but,
them.
I recall it was a very serious scientific certification and a great pertinence to mine in this case.
Doctor, do you think that a reasonably prudent pediatrician should read consult notes from consulting physicians?
I think it depends on the circumstances, and it depends on the setting in which the physician is seeing a patient. So if a patient comes in, as this child did, to the emergency room of a hospital, which has a general competency, advertises itself.
All right, we're gonna end the good doctors. I apologize for the unfortunate pause game, but we're gonna end the good doctors testimony here because it's fantastic. Rhineman YYC, so Pythagoras, you're not actually a licensed engineer, are you? Jordan Patterson, the equivalent of, do you have a driver's license? Sir, I invented cars. Jermaine Down. Dr. Newberger reminds me of number 1.0 of the central bureaucracy in Futurama. I co-chaired the committee that reviewed the recommendations to revise the color of the book that regulations are in. You know what? We needed a levity, and the good doctor provided it. He did. Sarah Noble, see, the doctor's a gem. I watched the full day 14 replay today. Missed my emotional support lawyer. Thanks for the recaps. Glad that you're here. MK and New Yorkie, so appreciate you recapping this trial. Have learned so much from you. Break it down. Love your style, except go heels. Nope. No, scream. No. Nope. This goat's broken. This goat is broken. Where's the other goat? I have other goats. Where's my other goat? Where's my other screaming goat? There it is. No, that's bless your heart. That's bless your heart. Anyway, screaming goat. That's bless your heart. Nope. Where's the goat? No, Tar Heels. No Tar Heels. NC State. I will find a goat and I will make it scream. That is not how that was intended to sound. I'm angry at the Tar Heels comment. I'll get over it. XCDA. I think it's amazing that you may hit 200K during this case. XCDA, thank you for reminding me to do something that I don't do a lot, which is to say, if you guys like the content, please hit the like button. If you like what you're hearing here, I'm doing recaps of this trial every day that I can. I am a practicing full-time lawyer, so I can't do it all the time, but I do dedicate a fair amount to make sure that the recaps are accurate and that I give you guys a good understanding of where we are in the case. So please consider subscribing. And if you do, hit the little bell that lets you know that we're going live. So almost all of my content is live streaming. And I try to give people a heads up when I'm doing it, but it's almost all live streaming and doing recaps of this stuff. Canonical Heat, darn you, Rob, you got me hooked catching up to hear Dr. Smith's depot. Well, stress ball is probably advised during that. Snazzy trinkets, jewelry. How the attorney rudely questions this doctor is extremely disrespectful and disgraceful. I understand the doc is long-winded, but no to being rude. I think it comes back and bites him in the ass because I think the jury is hearing that. JM, I think Chopra, this guy, and the hospital admin have made the case. Maybe Cantu also. Your thoughts? There's a lot of trial to go. There's a whole lot of trial to go. So I will say that. Let's go ahead. Roro, JMU fan. My daughter just applied. I have nothing wrong with JMU. Good school. Uncivil still in the chat. Clemson, go Tigers. Today is this might be a year when, and to Kurt and Kristen M96, two of my diehard Clemson fans in the chat, it's just not Clemson's year. Just not their year. Go Pack. So let's move on to, we're not going to do Kyle Kowalski. We are going to go to today's hearing because I want to get through some of the more pertinent parts. where do we start? Let me see. Pull up the stream. You go bye-bye, you shrink. We go to the actual live feed because we remember how to do these things. Because as Emily reminds us, we are professionals. Now, I am a professional attorney. I'm not a professional live streamer. So there's a caveat there that I think should be appreciated more than it often is. No, no, don't do that. Don't do that. Do this. Give me 1 second. All right. So we start off today. So we are now on today. We are now on Friday. And where we begin with today is motions. I love motions. Some people don't like emotions, but I like motions. Motions, here we go.
Okay, the only possible thing that could come in is that first, or what does this mean? Also, Patty, the security guard who confirmed 2 weeks for me is Doug. Because the date here is October 31st, which is
Right.
certainly after, substantially after the pendency court sheltered Maya.
Yeah.
So even 2 weeks prior to October 31 would still be at a time after the shelter. So
I understand. We can withdraw.
Okay.
Thank you, R.
234.
What am I looking at here?
Looking at further internal documentation in the risk management file about the false imprisonment we've alleged over the course of 48 hours. That's why you see on the fourth entry there, it says about 48 hours. You see who's involved again, it's confirmed by the text. Holidays, Sally Smith, Cindy Jenkins, all are mentioned in the text messages. You're seeing what these physicians, and I'm not sure who Ms. Jenkins is, were doing to, I don't know, weaponize that video or whatever they were doing with that video. 5 to 10 minutes, 5 to 6 samples. I think it says on server, everything. I don't know what that says. I don't know if that's erased. I don't know what that word is. And when she left the room, we stopped recording, can see her leave the room, or in a flash drive to put on OneDrive. So Mark, as to what Dr. Sally Smith looked at. So she was directing I believe the hospital's position is that this video was for care and treatment of Maya Kowalski.
I remain befuddled, Mr. Hunter. How is it that risk management continues to talk about this if the EEG room was actually for the care and treatment? I'm just.
The question being asked is the EEG room was used to surveil Maya for that 48-hour period. Remember the notes from Sally Smith? This was the surveillance room. And what Hopkins is trying to say is they are trying to say, Your Honor, this is for treatment. This shouldn't come in. This was for treatment. They're trying to draw an improper connection. And the judge is like, nah, this kind of looks like investigation that you didn't have authority to do. So explain.
There are 2 tracks this is on, Your Honor, and there is an explanation for it. But I would suggest to Your Honor that what's happening here is he's putting these in without a predicate and inviting the jury to speculate and put a burden on us to furnish the predicate for his evidence. That stands the whole process on its head.
Judge, they could have called Dr. Smith if they wanted to put these documents in so that they had some sort of
So can you, but they're party admissions. You can call her to explain them, but they're party admissions. They are hearsay with an exception, which is that of a party admission.
context for the jury. Instead, they're just putting random documents in and then obligating us to do that, to explain their exhibits that they're putting in.
Well, it seems very highly relevant to me. And this is a statement by Johns Hopkins All Children's Hospital. So it overcomes the hearsay exception. Parties had already agreed to the authenticity of all these documents. So I think it's fair game. Court will receive 2277-2. Is it 34?
Yes, sir.
Yeah, 234.
I'm cognizant of the time. Do you want to continue or?
There's only 3 more left of the risk management. Let's just do that and then go to the jury.
Sure. Well, I have.
Unless the next ones are going to be huge. Letter to the doctors or to Deborah Sells.
Yeah, let's skip that one. That's probably going to be a big discussion. Maybe 248. All right, this is a risk management file reflecting treatment discussions involving Jennifer Katzenstein.
Okay, well, the first three all are DCF related matters.
This is going to be the judge threading the needle and kind of doing what's good for the goose is good for the gander. So listen to the explanation.
Well, 6 lines down, Maya feels we, ACH, is lying to her about her mother, that doctors are lying about her parents. And then Maya, since this past weekend, has taken a step backwards since father can visit unsupervised now. Heard this from multiple persons involved in the care of Maya.
This is all DCF related.
Well, if the hospital knows that Maya Kowalski feels the hospital's lying and the hospital hasn't done anything, that is outrageous, honestly. So that is.
Well, this goes, okay, go ahead.
We're going to play that real time because it sounds a little sped up. So
Hugely
hang on.
relevant.
Her mother, that doctors are lying about her parents. And then Maya, since this past weekend, has taken step backwards since father can visit unsupervised now. Heard this from multiple persons involved in the care of Maya.
Judge, this is all DCF related.
Well, if the hospital knows that Maya Kowalski feels the hospital is lying and the hospital hasn't done anything, that is outrageous, honestly. So that is
Well, this
hugely,
goes, okay, go ahead.
hugely relevant. It also is talking about that she's taken a step backwards, which is contrary to the theme of the defense, which is she did better when she left this hospital. So that's relevant there. So I would tend to agree with you if we want to redact out this top part of the note. I am probably should do that.
Just
Judge, if you're gonna put it in, put the whole thing in, but with all respect, I think Your Honor's misapprehended our position with reference to the step backward thing.
Judge, we also requested.
Okay. Let me explain. No, that's too much. Let me sum up. To summarize, to sum up what we're talking about here, if the hospital is engaged as an agent of the DCF, Department of Children and Families, if the hospital is engaged at their authority to do an investigation, they are authorized to do so. They are protected by Chapter 39 immunity. If the hospital is treating and what they are doing and what they are suggesting is in conformity with the usual and typical standard of care for the treatment of that condition, then they're protected. They're acting within the standard of care for that condition. If the hospital sends a file to risk management, and risk management's like, so risk management for hospital, by the way, that's essentially the division of the hospital going, oh shit, we might be liable. That's the oh shit department. If they send a file to risk management, the oh shit department, and the oh shit department says, let's do A, B, C, D, or E. That's not in the course of treatment. That's in the oh shit department. That could be outside the standard of care. If the oh shit department gets a note that says the child during the course of treatment believes that she's being lied to and that we are doing the lying, that shows knowledge on the part of the hospital that the child has expressed that they are lying, and this is now part of the risk management file. So it's in the oh shit department. For a medical malpractice claim, that becomes very relevant. Very relevant. When the risk management department, which is the oh shit department, gets the document that says the child just said we're lying to her, what do? The plaintiffs get to say this note went to the oh shit department because it shows that the hospital was notified there was a possible issue. And no, they're not protected by DCF immunity, just by nature of the fact they were contacted by DCF. So the judge is like, I don't see how you get around this. Now the judge threads the needle because On the top of the note, there was contact about DCF being involved. Then there was the oh shit note, which is Maya thinks we're lying. And then the bottom was DCF contact. So the hospital's going, because it's bookended by DCF, all of that should be protected. The way the evidence is playing out, I am feeling less and less comfortable by the DCF protection. Rather, as that's applied to the hospital in this particular setting and this particular case. So what the judge has explained throughout this trial, as the evidence comes up, is the judge is becoming less and less comfortable with this whole Chapter 39 immunity shield behind a lot of these notes and things that one could describe as colloquially that bullshit. So you're not going to hide that bullshit behind this immunity that's bestowed by law. And in order to parse what is immunity versus that bullshit, we're going to trust the jury to determine what's that bullshit. I hope that translation helped.
And I can't remember now why, because I did this days ago, that if you put this in, 249 needs to go in for clarity because it's the second page.
Yeah, 249.
I honestly don't remember why I wrote that.
And if they want this in, I don't know what to say to that, but the reason we didn't is because
It's
we
more
made this
DCF.
in the continued treatment team and the second K Rhodes pain management suggestion. The rest of it looks to me to touch on the DCF.
Well, here's.
Yeah, Judge, I'm sorry.
No, go ahead.
I was going to say, Judge, these notes are started and bookended with DCF issues, and they want to snip out the middle. If this goes in, we believe the whole thing goes in, because you can see at the second page, it says Michael Kelly apologized for making certain comments to Maya and gave Maya the wrong impression in doing so, which goes back to the fact that Maya thought we were lying to her.
Kind of.
You want this second page in and not redact the first half, but I'm being very clear. Just by this note coming in does not mean we are opening the door to dependency action. That is not.
But we're not looking to do that, Judge. That's why, frankly, I object to most things, is because I'm concerned about agreeing to things without the court viewing them first.
It just points out that there's a line that's trying to be drawn here that's virtually impossible to draw.
Well, but I get paid to draw the line. I'm drawing the line.
I understand.
Whether I'm right or wrong,
And I
that's
just
someone
make
else's
comments. So.
Your Honor,
I have said it before, balls and strikes. The judge calls balls and strikes. That's actually a kudos to a justice that I don't really care for in the Supreme Court. But if he's wrong, he's wrong. The Court of Appeals tell him that. But he's making the decision. So, ergo Iron Fist, no, Suncoast did not. Suncoast settled. They settled.
clear on something. There's a distinction between what goes on inside the 39 proceeding and that context of this. It is very, very difficult. And frankly, you have added to the suicide thing now a substantial factor test. And I know for sure they're going to ask for both of these tests now. Well, a substantial factor is a factor in an overall.
Look at the
So
smirk
when we put
on the
our case, we're
judge.
gonna have
He's
to,
like,
yes,
keep
there's a
going.
substantial
That's
factor.
fine.
Trying to show the whole context. Some of their experts have also talked about the whole context. So the fact that there is that proceeding and that she was at a proceeding when she got upset and decided to commit suicide and all that's all going to be very relevant in this case. And trying to explain the supervision of the visitation and all of that, we're going to have to put on evidence.
And then let me just push back a little bit on what you said. I needed to understand where Florida law was on the issue. And I think I told you back, I don't know how many days or weeks ago, that when I was doing that analysis, I was just, what is the status law? I did not couple it with the pleadings or anything like that. I think I made that clear. So I'm not saying that they pled it or anything like that. I just, in my mind, had to understand, because obviously this is not something that comes up every day or week or year under Florida law. And so I had to do the deep dive to understand it first.
And I understand that. And of course, I'm in the posture where they're about to rest. I'm going to have to make a PV, and I don't quite even know what the standard is. I'm going to have to argue on intentional infliction for wrongful death. So it's a difficult situation for both sides now. Just trying to point.
DV is directed verdict. That's they're going to argue it. It's going to happen whether they win or not. Different question. But DV is directed verdict. So they're trying to understand what the standard is they're arguing under. Well, rather, they're trying to make the judge reconsider his position 9 million times. I understand why, because this is horrible for my case. I get that part. I get that part. But and do you guys gather how many attorneys make the arguments? I'm now kind of like done with it. One horse, one rider. And I made the comment that previously that when you're making a ruling on law, that you want to get the information from all the attorneys because you want to make the right choice. You want to make the right choice. But at some point in time, it becomes argument by filibuster. And now what I will say, here's the thing. One caveat. This judge will let them all argue, but I truly feel like it's not the last person to speak doesn't win. He makes his mind up and he's pretty good about sticking to it. So even though he lets them all go, when he makes a decision, he makes it. Now, at some point in time in the trial, he's going to be like, no, I'm not hearing this. So I'm starting to get frustrated with it. I wonder if he is starting to get frustrated with it. I really do. Because I can't imagine that he can keep this going for that much without finally saying, shut up. You've made the argument. I'm not hearing anymore. But then again, the judge also went off the bench earlier this week and was like, I need a break. I need time out because I'm going to yell at somebody, and came back out. So that argument goes on, and let's go to Christy Kirby. Where are you, Ms. Kirby? We're not going Maya. I know that people want to hear Maya. I'm not doing it today. Ms. Kirby. And I don't. So summarizing her testimony, she testified. She's the economist. So what she does is she takes the life care plan. Let me make this a little bigger. She takes the life care plan that was proposed by the doctor. The doctor then says, this is what the cost is right now to do the things that I think are in her best interest. And she's the economist, and she says, I'm going to go ahead and take this and extrapolate this based on today's present dollar value and what it would be required today if I invested that to pay out what would be needed for the lifetime of this award. So what she does is she gives the present day dollar figure of what the total award should be. Economist. With the economist, they testify to life expectancy tables. Very uncomfortable, but they do. It's a reality because Maya Kowalski was cut short on her own life, and she did that. She did take her own life well before it should have been taken. So life expectancy tables are a part of this. And Maya Kowalski has certain what we call comorbidities, things that might shorten your expectancy one way or the other. So you end up using an economist to take those tables and crunch the numbers. So you're not putting the jury in this position where they're going, I don't know what to do. You explain it to them. Yes, I saw that Peter used this economist. He and I do I dare say, I have extensive chats with a certain lawyer of Greek heritage in Florida about this particular trial. And he and I joke and laugh and talk about things from side to side. There are things I can say that he can't. He practices in front of this judge. I do not. I'm allowed to give critiques. He has to be really careful. So I get to chat with him quite a bit. But Ms. Kirby, while the information is dry, testifies to quality of life and the diminishment of quality of life and how that quantifies, how you make that into a number. How is the jury supposed to reach a number that they can attribute to loss of a parent, loss of a friend, loss of the ability to enjoy figure skating or piano playing? So it wasn't really her direct. It was her the jury questions. And I posted. No, she's not staying for that long. Is she? Does she? She's not after lunch. Okay, no. Here, I posted the question posed by the jury, and I immediately circulated it to all my friends. One of my friends, who may or may not be of Greek heritage or Canadian. I don't know. I'm not going to let you guys know one way or the other. Actually, they all kind of said this. At this point in time, this is the jury saying, how many zeros would you like me to add to this? Just whatever you were asking for, how many zeros would you like in addition to that?
You have a good jury with good questions, but I have.
Oh no, I went too far. Oh, it was every lawyer I talked to that said how many zeros. Every lawyer I sent this quote to, every single one was like, how many zeros?
Her pre-injury earning capacity. And based on my review of his report, he will defer, or he will explain that later, how he has allocated the 97,000. Let me find it. Sorry, I've got too many reports here. Okay. The $97,916. I did do research on the same data that he provided, because the data he provided was from 2019. And the current data, same data, is now would equal $108,316 or $316 per year. So 108,316. I haven't included that higher value. I've just relied on the figures that are provided in Tremp's report, as he indicated when he gave an updated assessment in August of this year, that he didn't change any of the opinions in his report. And part of that question also referred to the stock market. And so I'm not sure if they're inquiring about the interest earnings on safe government investment.
All right, first question, the one that she just answered. You have assessed Maya's earning potential essentially as if she were a stock that was traded at average value. But from everything that we know, Maya was exceptionally smart. She was great. She had all these things going for her. If I were picking a stock and the stock was Maya, Maya would be a blue chip stock. How do we not factor that in? That was the question. And what she was saying is we pick the safe estimate. The safe estimate. The next question is the big one.
But that data is standard data
this is a
that
question from a
economists
mother.
use.
Aaron,
It's
to
the
you,
most
question from a mother.
risk-free investment, as this money is not supposed to be placed at risk. When you invest in other avenues, you may yield a higher return, but you also have a greater risk of losing that money, and it's not guaranteed. So the economists in my field routinely will rely upon the interest earnings on safe government investments. I haven't made any adjustments to the vocational assessment that Mr. Tremp has provided and the figures that he outlined.
Next question.
Okay. So not to be crass, but get ready for the defense butt pucker question of the trial.
Ms. Kirby, I may have missed it while scribbling my other question. Was the possibility that Maya's PTSD affects her ability for possible relationship, then marriage, family, children, and all the quote things, end quote, that her past family enjoyed, but now will never be able to continue? She now may not be able to enjoy quote motherhood, end quote, like her mother did. And if Maya does have children, was there any quote monetary value, end quote, placed on the added stress Maya would have when her children went to a hospital for something? Or should I add, if able to, additional quote monetary value, end quote, to your figures?
You have a good jury with good questions, but I have.
Oh my God. Do you need to hear anything else? Or should I add, if able to, quote, monetary value, end quote, for that essentially calculation error? Holy shit. I am sorry, Ms. Kirby. I did not mean to do you wrong by that. That was rude of me. That was a bad pause game. It was bad pause game. So for those of you who want to see that written out, hang on, I actually transcribed it. It was too long for a Twitter post by itself, but I was so enamored by that question that I actually wrote it down. I wrote the damn thing down and I posted it on Twitter, but I'll pull it up now because the question itself is a kind of question. If you are defense counsel. So let me do this. Stop sharing that screen, share this screen. This was the question. Judge, reading the jury question, was the possibility that Maya's PTSD affects her ability for possible relationships, then marriage, then family, children, and all the, quote, things that her past family enjoyed, but now will never be able to continue. She now may not be able to enjoy motherhood like her mother did. And if Maya does have children, was there any, quote, monetary value, end quote, placed on the added stress that Maya would have when her children went to a hospital for something? Or should I add, if able to, additional monetary value to your figures? Here's the thing. To be fair, here is the thing. We are still at the end of the plaintiff's case. We have not heard the defense information or evidence yet, but what this tells me is that there's already a juror whose mind is so made up that juror is basically saying, I'm already there. Just tell me how many zeros. Once you get a juror to that place, it is very difficult to win them back for the defense. Like the odds of getting a juror who's already there, like, tell me the zeros. Tell me the zeros. Getting that juror to reverse their position on liability? Good luck. So, Jasmine, this is a question I get every night. Why is the jury even allowed to ask questions? This varies by jurisdiction, with the jurors being the ones that are tasked with being the finders of fact. The judge gets to read them the law. The jury gets to find what is true or not true. Some jurisdictions view that the jury should have an input on whether they need clarification of the information provided to them. They have a sidebar where the judge reviews the questions with the attorneys beforehand to determine whether any of the questions are objectionable. The judge has repeatedly said, the rest of the questions I can't ask this question, I can't ask this question. The judge has told the jury when the questions they have asked have been outside the evidentiary bounds of the trial. So there is a constraint on what questions are allowed. But the jury in this particular case is not only very interested, but a lot of them are very well informed. You have questions about recording and whether recording was lawful. You have questions about medical treatment that suggests that there's one of the jurors who has very, very, very good familiarity with medical treatments. Then you have questions like this, which are, even though you have given me a number and you have told me that number matches up with this system, if that number does not match what I believe the loss that you're describing is, can I go beyond that? It's a very informed question. It's a very good question. The jury has been asking very good, pointed, direct questions. honestly, with most of the witnesses, the jury has been asking the questions that I had wished the attorneys would have asked. A couple witnesses, the jury asked questions where it was very clear that the attorneys were skirting an issue and they wanted the witness to give only part of the answer. And the jury asked the witness the question that actually let the witness give the full answer. And you would see the witness just like do a deep sigh and like a comfort, like they were finally able to explain what they had wanted to explain the whole time. I have personally, I've never seen this tactic at this level. I cannot imagine that you would find a better jury. Every person who's come against this jury and asked and had the questions asked has been like, this is really remarkable questions. They're very good questions. Really good. Like, I don't think lawyers are getting better questions in than this. And the thing is, the lawyers don't have the balls to ask the questions that the jury does. Hell, the jury even makes jokes right now. Counsel Anderson and Whitney, if you wouldn't mind, the next time you're reading a deposition, if you could please project your voice into the crowd and choose different voices from your usual voices, and maybe wigs might help. Signed, a little levity. This jury and the dynamic they have in this courtroom with this judge, this is kind of restoring a bit of my faith in the jury system. So I'm here for it because I think this jury, when they hear evidence from the hospital, I think they're going to have opinions. They've asked questions that are not favorable to Maya's case. So I'm really curious. So we go to lunch, come back, we have argument. Then we bring on a witness the hospital hates. We are now in a part of the case that the hospital really, really does not want. They hate this part of the case because this is the summary. This is summarizing and assuming liability. This is you assume liability, therefore, how much money are you going to give the plaintiffs? And the hospital hates this part of the case because all of it assumes liability. So we got some argument over the Chapter 39, blah, blah, blah. Then we get to this witness. It was the cross of this witness that I found most fascinating. And Shapiro does it, I think. So did they have their argument over whether the witness could be heard yet? I think that might be now. Or was it before? They go to lunch. Kirby's on the stand, off the stand. The witness then takes the stand. On the stand. And then sidebar. More sidebar. Was it the next doctor and they tried to exclude? No, it's this doctor.
Yeah, again, it speaks to the absolute importance of treating this early on and to see what you can do. And so, again, I think
okay, well, give me a cross. Hang on.
An extreme
9 through, where does it end?
Birth, right? She was just a freight train going towards college. There's no worry there.
Freight train. So listen to this. Freight train going towards college. Listen to this guy.
And so I looked at the wage data for that at the $1,883 in 2019 as a weekly wage for that. It's basically the maximum based on the government data.
And what does that come out to annually?
It comes out to the 97,000 range that Ms. Kirby talked about, and then the 108 that she annualized.
All right. And so that seems a little, isn't that low for someone with her potential?
Yeah, and so again, the methodology that we're bound by as voc rehab counselors is what does, the government analyzes all of our jobs, right, across the board, and they come up with medians.
So he's a vocational rehab counselor. What that means is that his specialty is training people to get back into the workforce. What do they need to get back into the workforce? We have these experts come up when we are saying that a spouse is voluntarily underemployed. You have the doctor that's working at McDonald's and trying to say, I can't afford to pay support. So we have to bring these experts in to say, oh no, they can pay. They can pay. And you have to have the expert that comes in and testify. This is what they can do. This is what they can earn. Now, what I thought was most curious was the tactic taken on cross-examination.
Technology, it's no problem to predict that she, again, was just this almost 40.
I can tell it's Anderson by
because
the
of this note.
As of 2022, she was
Here we
figure
go.
skating, playing the piano. True?
Fair.
And she's driving.
Yes, she's driving now.
She has a boyfriend.
Yes.
She had a job.
Well, I'll let her speak to that.
Yeah, I don't.
I'm not going there. She can answer that.
She had a job at Cracker Barrel.
Yeah.
She did you ever get her school records?
I don't recall.
You don't know what her school records say?
I'd have to look. Well, I got a lot of records. I mean, not much to really see. She's doing pretty well.
Yeah, I mean, I guess not to belabor it, she was, may still be, but at least for a while, she was number one in her class.
I believe she's number two now.
Okay. She was president of the Junior Honor Society after she got out.
Side note, I hate this fucking argument. I'm sorry for being so profane. I have personally represented at least 2 children who were victims of very serious abuse. And I know that. I know that they were. And the argument that was made was that, well, they're excelling in school. They're doing well in school. I've talked to too many child psychiatrists who have expressed that certain children, when traumatized, will cut off from the world and they will put everything they have into scholastic study or books, reading, writing, etc. I know way too much about that subject to buy this bullshit. I hate this crap. I hate what's being argued right now. I understand the point that Maya did very well in school. The fact that someone does well in school after experiencing a traumatic event does not mean that they did not experience the traumatic event and that the rest of their life is not altered. That bothered me quite a bit.
Out of all children's true.
Was. Yep.
She was a member of several clubs.
Used to be. Yeah.
You in order to prepare your vocational report, you had to interview Maya and Mr. Kowalski, right?
Yeah, several times, yes.
Okay. You noted that Maya developed CRPS on July 4th, which gradually worsened, necessitating significant and prolonged medical care from multiple providers. True?
That's true.
You noted in your report that Maya had taken the SAT.
Yes.
You noted, at least at the time of your report, she had already gone to Stetson College in DeLand and participated in the science program.
That's true.
You noted in your report, when you asked her about her career thoughts, she was thinking about becoming either an orthodontist, a private investigator, or maybe going.
Bro, the fact that people like dive into a subject, I don't know if it's called trauma dumping. I don't know what it's actually called. y'all have expressed to me, how do you deal with traumatic experiences? How do you deal with traumatic cases that you cover? I go into the workshop and I build stuff and I put every fucking ounce of myself into that stuff. And I couldn't make half the shit that I make if I didn't have the reason to be in that shop. Imagine that times a million. I deal with things. I'm an adult. I deal with that stuff, and I go in the shop and I create stuff to make to get myself out of that, and I put all of myself into it. Imagine being a child, and you go to the books, and that's what you know. I don't like this argument. I hate this argument. I hate it. I hate it. This is an argument made by someone who doesn't practice family law.
Going to psychology, is that right?
That's what she said then. Yeah. Now she doesn't know what she wants to do.
I'm still thinking about what I want to do.
No comment.
Yeah. You interviewed Maya. This is as of February 10th, 2022. Did she tell you that she started her days at 4:30 in the morning and working out?
Yes.
And she was going to school?
Yep.
She would come home and help with chores?
Yep.
You saw where Maya had said in her deposition that she's physically doing better now than before she went to All Children's.
Yes.
Let me ask you a couple of your opinions on, well, let me ask you this. Were you aware of someone applying for Social Security disability benefits for Maya before she went to All Children's?
I don't recall.
You mentioned work is therapeutic.
Yeah, very. Yeah, absolutely. I hope she works.
Were you here earlier when Maya testified?
I was.
Okay. And you saw that she is going to seek out therapy, hopefully when this trial ends.
Well, I found that interesting because she wants to get better. She wants to see doctors and trust them again. And when I was listening to that, I'm going, when I've talked to her and her dad, the distrust is the big problem. And that's why I'm so guarded about her future, is because she's smart. She knows she needs help, but can she get out the door and go get it? And that's the problem. Is it just going to keep re-victimizing her? Secondary to the trust issue.
Does you do concede, do you not, Mr. Tremp, that at least looking through her prior records, there were prior diagnoses of anxiety and depression prior to All Children's? True?
It's fair. Yeah.
Okay. Did you read the report of Dr. Jim Lewis in terms of what?
This part's going to piss a lot of people off. This part's going to piss a lot of people off. I will explain why it's being made, why the argument's being made, but this part's about to piss a lot of people off.
What he thought in terms of pre-existing anxiety, depression, and potential trauma.
Refresh me.
Oh, you want to see it?
Sure.
Or do you want me to tell you what it says?
Whatever you want.
Maya had extensive clinical interview evidence of DSM-5 adjustment disorder with mixed anxiety, depressed mood, moderate to severe.
And this was by which doctor?
A neuropsychologist.
Employed by who?
Not employed by my hospital.
Okay. And what date was that?
That was on October 20th, 2016.
It's fair.
Okay. One moment, please. Appreciate your time. I don't have any other questions at this time.
You bet.
Thank you.
Sure.
One thing.
All right, I apologize. It wasn't that part. It was earlier in the cross. So, and I'll summarize what his argument was. What he argues is basically that you heard the testimony from this individual that Maya was like a freight train going to college. Maya was a freight train on the right track to college and a good job and a good life. It was Maya's a freight train going towards this. And Shapiro starts going through how much Maya's life sucked, even prior to being admitted. Maya was in a wheelchair, right? Maya couldn't do this, right? Maya was hurting, right? Maya was this, right? Well, how would you say she was a freight train going to college? Wouldn't you say that her life was just as bad back then as it is now? And in my head, I was going from a legal argument, from the pure legal standpoint. There's merit to the argument because it basically says if her life was not good before and not good afterwards, then what's the quantifiable damage? That's the pure legal argument. Legal. I didn't say moral, I said legal argument. How do you compensate someone when there is no degradation in quality of life? Because their life sucked before, their life sucks after. The problem is the quiet part that everyone, well, you don't say that shit to a jury. You do not say that shit to a jury. Like you save that argument for your appellate brief. You save that argument for the appellate brief. On appeal, you said they did not demonstrate that there was a change in her lifestyle from before her admission to after her admission. What you don't do is you don't cross-examine a witness and say her life sucked before, didn't it? It sucks after, doesn't it? There's no change, right? K-Pick, I know she hasn't filled out a college application. I get that part. I get a lot of this part. I'm criticizing the strategy here. You just heard a juror ask a question. I'm talking strategy, only strategy. You just heard a juror ask the question, dear sir, or dear ma'am, it was to Christy, dear ma'am, how many zeros should I add to the end of this number to account for damages that I think your calculus doesn't add to? You just heard the juror ask that question, and you decide that the very next witness, you are going to take the strategy position of your life sucked back then, it sucks now, it's not compensable. Like I said, I understand the legal merits to the argument on an appeal. I get it. I get the facts line up that she had not filled out an application and that she wasn't able to do these things before. I understand how the facts play out. What I'm saying is that the jury has sat here this whole time. What you didn't hear, what I skipped over, was that Maya, prior to this witness taking the stand, Maya was up there testifying about the things that she cannot enjoy right now. So the jury had a whole morning of listening to Maya Kowalski testify about her life and how it's different now. Maybe from a trial strategy standpoint, you don't go in front of a witness and say, her life sucked back then, it sucks now, you can't compensate. That's a legal question. That's one you make to the Court of Appeals if you lose. What you do instead is you say, for example, that this wasn't a significant disruption. She's still doing well. She has the capability. Look at her in the courtroom today. She says that she needs therapy, but that's therapy. She can still function, go to school, make a good living. You bring the number down. You let the jury make the connections that you decided you were going to make out loud in front of a few jurors that might not like you. This was hard. This was hard. I was going, my brain right now is going, what are you doing? What are you doing? It was just, it made no sense. And then we had argument over the next witness. Share screen. No, go to the stage. You there. Last witness that we have is Dr. BiFulco. Like it's pronounced bifocal, but it's BiFulco. It killed me. It's pronounced bifocal. He's Dr. Bifocal. So we have, or no, sorry, this is Dr. Bifocal here. We have him take the stand, and then all of a sudden you get a very, very quick objection. Here we go.
Basically, every piece of factual information which counsel can disclose to me, I ask for and I review. That's the first thing I did. Then I asked to evaluate Maya Kowalski. I wanted to have an opportunity to see her in my office, but that was not possible. So I had 4 telemedicine visits with Maya, her father, her brother, but I only evaluated Maya. But I wanted her family involved so I can get an accurate picture. In addition to those telemedicine visits, I spoke with her treating physicians on a number of occasions. I spoke with them, I communicated with them, I reviewed their records, I reviewed their updated records, their reports, I coordinated my opinions with Mr. Tremp. So essentially, when I say factual information, it's all of that. And then I apply my training, my education, my experience, and my knowledge so that I could start to now move from facts to opinions. And those opinions are, does Maya have a permanent injury? Yes. That's the first criteria. I can't move to writing a life care plan unless she has a permanent condition. Then I have to ask myself, does Maya Kowalski have a permanent treatable condition? Because if she doesn't have a treatable condition, then a life care plan doesn't make any sense. So she met that criteria. So I start now to move on to opinions. If she has a permanent injury, and if she has a permanent treatable injury, I start to then formulate what are the categories of care. And I do that not just by relying on my own training and education, experience, and knowledge, but I reach out to, and I read all the medical records, and I specifically asked her doctors on multiple occasions, tell me what Maya Kowalski needs because of the trauma she sustained. So it's clear, it's important to understand the care plan is not to treat her complex regional pain syndrome, which she had before the trauma. It's to treat the condition and the conditions that she now has as a result of being traumatized. And that's the...
And we have a freak out. So we have a freak out and the jury gets excused because this was a planned objection. This was planned. This was planned. It's a fucked up strategy, but it's planned. While we're waiting, Feral Dragon, thank you for the very, 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 very generous super chat. 11-year-old Dee Dee had pain and symptoms dismissed by specialists. She became angry. The docs were avoidant. At 15, new ortho offered help. Oh my God, burst ugly crying. She had similar feels. Brachial, nerve hit bone, kneecaps dislocated, never complained. She didn't trust her own pain signals. I'm very, very sorry to hear that experience. That is remarkably sad. I hope that she's doing well. I hope that she's recovered. And I hope that that experience helps teach everyone about, look, everyone's situation is different. You can't approach it as being, this person's lying, this person's not. Listen with a critical eye, critical ear, please. Feral Dragon, thank you for sharing. That's very generous of you. Whiskey Sour, thank you. Rob, my mother and I were abuse victims. I felt so alone and that the world didn't have a space for me. I joined the army, ended up with a TBI T-bill. I understand where Maya is coming from and how hospitals lose the plot. You put enough bureaucracy in front of treatment and you create an issue.
Go back to the room. Do not discuss this case amongst yourselves. We're not doing investigation and receiving information.
Doing well now. While we're waiting for the jury to exit, I will be pulling up super chats. I have a backlog of about 70 that I have to get through. I'm going to start pulling up super chats that are not questions. I thank you guys for being here, for encouraging me to continue this coverage, for being here for 4+ hours as we do a breakdown of 2 days straight of recap. Thank you for being here. Thank you for the contributions. If I don't get to your super chat, please know that I value your contribution to the chat and you guys being here. If you weren't giving this input, I wouldn't be covering this trial. Not with the dedication that I am, because it's finally a case where it really matters to me and it feels like it matters to a lot of you too. So thank you for continuing to support this. I really do appreciate it. It means the world to me. I will be pulling up some of those super chats just so that we're not here until 2 o'clock in the morning doing them. I want to continue hearing the evidence and argument and commenting on it. So if you don't want to send a super chat, please don't. I never ask for them. I never do. The only thing I ask for is hit a like button, subscribe if you like the content. Those are free. Thank you guys for being here. I really do appreciate it, but I do need to make sure that I can continue covering the trial and again, not be up till 3 a.m. Seafair. Thank
Jury's
you.
out of our presence. Doctor, if I could have you step outside, please. Yes, Your Honor. Everyone, feel free to sit down.
We live here now.
Okay, the doctor is outside of our presence. The jury is outside of our presence.
The defense would like to make a motion to strike his testimony. I took his deposition. I asked him this question 3 times, starting on page 41. Quote, in terms of what Maya was going to need, irrespective of encountering Johns Hopkins All Children's Hospital in October 2016, you have not developed an opinion. True? Answer, that's correct. And just to make sure I wasn't missing something, I asked him the same question at page 46. And so whether Maya Kowalski was going to need attendant care, regardless of the treatment at All Children's, you're not making that determination. This is only based on what her needs are now. True? And
I predicted that this was planned. They knew this was going to be an argument. Listen to how fast he's making the argument. They knew this was a problem.
And his answer was, so I think you've asked me this question a few times. I have no opinion. I'm not going to speculate about what Maya would have needed but for the subject tort. And there was no discussion with her treating or consulting physicians regarding what she would have needed had this not occurred. Same question with regard to her psychological needs. Are you making a determination of what she needed but for the treatment at All Children's, or is this, again, just what she needs without any reference to that discussion? Answer, there's no determination, no speculation on my part is occurring about what she might have needed had it not been for the events in 2016 at All Children's Hospital. I couldn't have confirmed this more with this witness. I was never notified that he was going to show up at court and say, all these treatments, my life care.
The fact that you're making this argument right now suggests to me that you kind of anticipated that this might be coming. And I think the judge calls you on it in about 45 seconds.
The plan are a result of, mistreatment, whatever he wants to say at All Children's Hospital. It's a surprise opinion. I moved to completely exclude his testimony. I moved to strike his life care plan. If he's going to proceed at all, I would like the questions to be very clear that his opinions are only, this is what she needs now, but I'm not alleging it's due to anyone's negligence. This is completely unfair.
Your Honor, those opinions and those questions and answers strike me as the inverse of.
Side note, this is the plaintiff's entire case. The entire case by the plaintiff is that damages were sustained and that based on those damages, there is an estimated life plan that exists now that's consistent of corrective action. Things that she needs that she would not have needed but for what had happened at the hospital. That life plan has a dollar figure attributed to it. It is where all of the calculations and money is. If the life plan is stricken because of this argument, then the plaintiff's case is bye-bye. And Shapiro knew that this witness was there. This was the life plan witness. Gets up and says, we are shocked. We are surprised. Now, the good point is he does ask the question quite emphatically. And this is a good point. Where Shapiro wins points for me is that there was no assessment of what Maya's life before entering Johns Hopkins would have required monetarily. Because with CRPS, before entering the hospital, we all know CRPS is chronic. It's not going away. It's a lifelong condition. We don't have a quantifiable dollar figure for what care she would have required, even without the hospital's intervention and conduct. So how can we compare what the life plan is now, which just says this is what she's going to need from now on, unless we know what it would have been without the conduct of the hospital? That's Shapiro's point. He makes it rather inartfully, and it should have been the subject of more motions practice. Because it's a good argument. You cannot tell the jury that they must award $220 million or $10 million for Maya's care only if you didn't know that that $10 million was attributed to Hopkins. If Maya would have required $2 million in care because of her condition before Hopkins, then the proper figure would be $8 million, right? You should be able to offset that to understand that the increased damage by the hospital was $8 million of damage. That they tried to pin that down by deposition, but they never got that clarification. They never forced the issue. And Shapiro now, because they weren't able to get that issue clarified beforehand, Shapiro is, let's call it sandbagging. Throw the whole guy out. Throw all the money out. All the money. Because I didn't get the answers at depots that I needed. And the judge is like, well, that's not really what we're going to do. So that was me doing the let me explain or let me sum up version of this argument.
The positions defense counsel is taking, those sound to be responses that Dr. BiFulco
Yes, I do.
has not formed opinions as to
The only
speculate
Latina,
as to
thank you.
what she would have needed prior to All Children's. He's confirming in those answers that his opinions account for the trauma at All Children's. That's how I understand those answers and those exchanges.
Not only that, we provided them with an opinion, with a report in this case, which stated, and a disclosure, which stated that he was going to testify as to all of this.
Let me see the report that
When
was.
was that, Dave? I got a report last night. There's a report dated August 29th, 2023 that I was forwarded some additional materials last night around 7, if that's what it was included in. I moved to strike.
We sent it to you.
Well, it's dated August 29th,
Let's
2023.
go with
Thank
something
you,
that
Yellow
was
Pill. Hope it's
timely
well.
produced under the court's order, not something that was given to them a couple minutes ago.
Sure. And we did have, there was an order from this court that we could provide supplemental reports of our life care plan or voc rehab. And so there's a specific order on this.
So is this?
And this is the one that would have
Is
been.
this timely under that order?
I need to go back and look at
The order, though, was because their numbers were going to change. Sorry.
I just, first off,
One horse, one rider, damn it.
is the report that's in Mr. Anderson's hand, is it timely under the court's order?
I'm going to look at the date of order.
Okay.
Thank you, Marcia. Very kind of you. And Ryman YYC for all of the encouragement throughout the evening and through these streams. Crazy Cat Queen, you owe me a DM. I owe you a pen in makeup for Ian's mask that did not make it to you. Please DM me. As an MD, I can tell you 100% that Smith was clearly a consult in the inpatient team looked to for a treatment plan. Doesn't matter what Jay Hatch intended her role to be, it is what she did. I think that came across. Thank you, Allie, for the gifted memberships. Mata, bruh. They did the video to see if she could walk. That failed.
see that.
Reframe that as they successfully found position shifting in
While
bed.
they're looking,
Yeah.
I would note for the record that his rata sheet is empty, so he didn't attempt to change his opinion either.
Well, I mean, if it was in his original report, then it's a question of impeachment.
Thank you, baby Gator. And Selena.
As original, or if it's not in a timely disclosed report, then we might have a different issue.
And Canonical Heat. Is the entire chat now members?
Can I make a comment?
That's why it moves so fast. I'm sorry.
The reason they were allowed to give new
Crystal,
reports
thank you.
because they said the numbers would have changed given the fact that the trial had been delayed, not because they have new opinions or expanded opinions. And so the court
Thank you,
allowed them to
Catherine.
do for the life care planner and the economist new reports because of the delay of the trial and new numbers.
Thank you, Larissa. Larissa for gifted memberships. Thank you. Fiona, you too.
Line of disclosure. I'm confident, because that was the entire purpose of the witness, Your Honor, that we provide disclosure.
That's why I'm saying it's sandbagging. This is the whole purpose of this witness. They knew damn well what this witness was for. They knew what it was for. Anderson gets pissed here. I would too. Same with how Hunter got pissed earlier. Thank you, Sarah. And Trishy, thank you. Okay, when Anderson gets mad, he forgets where the microphone is. So if there's bumps, that's him. Lady Draconis. Lady Drake is one of my mods. This is a great opportunity for me to thank the moderators of the chat who have tolerated me while I have done nightly recaps of this case that went hours on end. They are within the chat, both promoting the channel and, well, making sure we stay on topic and that YouTube doesn't find something in the chat dialogue that's going to get the channel taken down. Because we're talking about CA, SA, unaliving, like we're talking about all the things YouTube hates. So I want to thank the mods. Thank you, mods, for doing what you do. Thank you. Thank you. Thank you. Lady Drake, I suffer from PTSD, anxiety, and depression from military service, currently a 4.0 GPA in a PhD. I relate to the putting everything into studies. For me, learning heals the brain. The number of people I know that feel that way or experience that is immense. I also want to take the opportunity to thank the people that are moderating elsewhere, in a Discord, in a YouTube chat, in my Discord, people that are moderating and making sure that the topic stays on discussion, healthy, and not like the chat that we've seen in Long Crime. The chat on these channels is terrible. Their moderators suck.
I've located our expert disclosure from 2021. I hesitate to bring it up yet because I'm in the den for it, but I can tell you the date of it.
Tell me the dates.
October
Kay
15th,
Stevens, that is
2021.
immensely generous. Thank you very much. Very much. Very, very, very
Well,
generous.
how about his actual report? If you're talking about the plaintiff's third amended expert witness disclosure, that's DIN 1912.
Oh, jury's
The only
at least some are in favor of mine.
I have received from them is the life care plan projections that are replete with notions in here that what is required for her is a result of CRPS, which was entirely consistent with his testimony.
Thank you, Kimmy.
For example, I mean, this is the one that was even provided to me, it was provided last night, but it was dated August 15th, 2023. Page 6 of his report is all about what he needs because of CRPS. None of this is about exacerbation. I received this last night. My point to the court is, I understand your point. I get it. I'm frustrated. I apologize.
Seems to me, Judge, that this is going to take quite a while. It would have been nice if we knew this was coming up. If counsel had some idea that this would be a major issue that we weren't discussing.
Oh, freeze game on point, baby. Oh, yeah. Look at Hunter and Shapiro. Excuse me, what? Wait, what? Side note, Anderson tried to pull this a while ago where he tried to bring in people that were like not listed and move stuff around. And Anderson has been on the receiving end of these whole, it would have been nice to know that this was happening. So Hunter and Shapiro right now are like, I am biting my tongue because you have pulled bullshit on us this whole trial. Oh God. Oh. Oh. Courtrooms are fun. I mean, they're not, but they are. Anderson pulled a whole witness that they prepped for, specifically that Shapiro prepped for until like 4 a.m. Anderson pulled him the day that they were going to testify. I get the point. It's a good point. It's a good point. You can't hit me with a motion to exclude my whole witness if you didn't tell me before. But to the same end, the defense made that point when it was like, you can't hit me with, you're not going to put this witness on, when I prepped the whole night for him. Oh, that's good. That's good.
4:45. 3:45, excuse me.
That's a ball.
We may need to go home
This
and
one.
look through everything we've got and find out what's up. But I am confident, because he's a life care planner about Maya Kowalski's condition, the only reason we would have him would be to comment on why she has these based on what happened to her at Johns Hopkins.
Sorry, Kristen.
There's no other rational conclusion in this. And so I question whether this is truly surprise and whether this is truly some kind of prejudice here, or whether we're the victim of a gotcha unprepared. Because if I had known about this, I would have gone through the entire history of the experts. This case went to trial, not to trial, but this case went 3 days, 4 days before trial a year and a half ago. And I know at that point we had made full and complete disclosures. I didn't hear anything at that time, and I didn't hear anything in the pretrial here. Now we are in this situation, and I'm certainly not going to give up on the witness's testimony. I suggest that I be allowed to complete the deposition, and then if we can't prove to the court's satisfaction and counsel's that yes, he was informed that my life care plan expert was in fact going to testify about a life care plan as a result of a tort, then we can move from there.
Respectfully, Mr. Whitney, who's a fantastic attorney, was at this deposition. And you can see the reason why I asked Dr. BiFulco.
Who's a fantastic attorney. Oh, it's late in the day in court, baby. This is what afternoon court is like. It is late in the day in court. It is late in the evening in this recap. We are silly here. What the hell is happening? My freeze game is on point right now. Shapiro looks like he just took a hit of a blunt. Someone was asking, what about the depot? If you don't get the questions you need answered out of a depot, you're asking the wrong questions, or you're not pushing hard enough. The witness is going to evade the question. For example, Shapiro points to the fact that he asks this witness, well, didn't this person have pre-existing conditions, and doesn't that have a quantifiable cost to it? And the witness properly says, I'm not a doctor. I can't opine. Because this witness was tasked with giving a full assessment of what Maya's prospective care would be. So you can cross him on the issue. And you can make the argument. I mean, they're going to have their own expert, so we'll wait for that.
This 3 times, to the point where the 3rd time I'm like, I'm sorry to keep harassing you about this. I want to make super sure you're really not going to come to court and say,
Oh, I heard
this is because of what your hospital did. You're just saying, this is what she needs. He couldn't have been any more clear. If they wanted to make a change to this, they could have done their errata sheet. They could have said, hey, Mr. Shapiro, he's reconsidered. It wasn't my obligation to tell them that their life care planner conceded to me at their deposition when respectfully Mr. Whitney listened to this and did.
No, but it was your obligation to hammer down on the question so that when you made the argument to the judge, there was no wiggle room around it. That's the point. Good lawyers take depositions and they can narrow a question in on a witness and put a witness in a box in a corner. Great lawyers create questions in depositions that are inescapable at trial. So the great lawyer in that deposition would have created a situation where that witness would have had to either give the figure for what he thought Maya needed, period, end of course, or could have gotten the question so narrowed down that it would have resulted in a motion in limine that would have prohibited testimony unless the plaintiff could produce a witness that also would give that number, because it would be unfairly prejudicial to the jury to hear this is what she requires for the rest of her life without knowing what she would have required for the rest of her life without any of these allegations. That's the difference between a good lawyer and a great lawyer. So this was a good shot. It was a good shot. It was worth the swing. It was worth the swing. But gotta have the backup.
Not cross him to try to rehabilitate him on the subject.
Yeah, I read the question. You change it differently. The report, the initial report is from February 5th, 2022. Our legal assistant is printing it, but we can display it for the court. Go to the next page. Can you enlarge it perhaps?
Just, and for the record, while you're reading this, I deposed him after this to ask him about these opinions, and that's when he conceded.
Well, that sucks for your argument.
This is not a subsequent disclosure trying to account for his testimony. I had this report. I had his life care plan.
My thought process, Mr. Shapiro, I first want to know is if some semblance of an opinion was disclosed in the expert report
about
Jenna, I committed
what he testified to here. And so just go to the next page. Are you going to be able to show me anything close to what we need to see?
Sure. Go to the first page again. The purpose of my evaluation, bottom here, the purpose of my evaluation was to assess Maya's current issues related to the incident that began on October 7, 2016, when she was separated from her family and retained at Johns Hopkins Children's Hospital for 97 days. He's been instructed not to get into the fulsome 97 days. But go ahead. Let's go down.
Shell, motion seconded and carried and approved. The stapler needs to be out of that courtroom. Musings, thank you. Already member, but self-bought because for some reason my account is registered in a way that can't accept gifted. Thank you, Robert.
Maya has suffered a traumatic event that will have a lifelong impact. He's describing there. His opinions again. Life care planning, certainly related to the traumatic event that began on October 7th, 2016. I mean, it's just inherent in this report that these are his opinions.
Well, that's what his report's about.
It's the sole purpose of the witness. It's the sole purpose of the witness to quantify in summation what damages are appropriate, to take all the doctor's assessments and compile them and say, if everything that you heard during the testimony was true, this is what that dollar figure is. And then give that to the economist who says, this is what that means prospectively. For Hopkins to say that they didn't expect this testimony is bullshit. It's bullshit. There's no way. There's no way. It's the sole purpose of the witness. Oh. Oh, God. Nanner, thank you. Popped in to say, as someone who has very personal experience with the hospital doctor malpractice, I can't watch this. I'm sorry, Nanner. Respect for bringing awareness to the question, everything. That's the purpose. I know people can't watch. I know people can't watch. I know people get upset. I know people, this is too close to home, but this is close to me. This is important. This is an important case to me. So I'm watching because I want to see how this plays out, because we are dancing a fine line of the law that so many people confuse. And I want to be there when it happens, because I am too nervous, given what I have seen with the media, that someone's going to report something that is such a fucking off take and so stupid that it's going to traumatize a lot of people. And I don't want people operating off of really stupid hot takes of someone's going to say Maya was awarded this even though, or the hospital skated free even though. It's not about the verdict. It's about people understanding what the law that was applied to the facts allowed the jury to consider or not consider. This is not a one article case. These recaps, they're not a 1 hour recap. There is too much to digest to do 1 hour. And I apologize for the duration, because I know I get long-winded, period. But Melanie, that is remarkably generous of you. Thank you for the very generous super chat. And thank you for becoming a channel member. I have seen you in the chat, engaged in the past few days. I very much appreciate it. Happy birthday, Hedgehog in Space.
Copy of the
Happy
court
birthday.
So on page 5 of this document, it does say the life care plan in this update outlines the minimum care Maya's needs within a reasonable degree of medical and life care planning certainty related to the traumatic event that began on October 7th, 2016, which would exclude the onset of CRPS originally. I agree with Mr. Shapiro that this deposition seems to be replete with opinions that might be at odds from this document that I'm looking at on the screen. The issue to me, though, is it a surprise? And if you had the written report, did you ask about, hey, your written report seems to be at odds to what you're saying?
Respectfully, the whole reason why this is so complicated and respectfully convoluted is because we have testimony in this case from people like Dr. Chopra and others who will say and have said CRPS is this lifetime permanent condition, right, that will never be cured and that Maya was going to need care for the rest of her life. So my plan.
This is a good point. This is a good legal point. It's a good point. If this had been argued before trial, I think he might have won. I really do. He might have won to the point where he could have excluded the witness unless they would have done an analysis of what the cost would have been without the hospital's intervention. This is a really good point. It's just doing it on the surprise argument. That's not the vehicle to bring the argument. You had the chance. You just said you deposed him over and over and over again. You deposed him. It's a really damn good point. But it should have been made and briefed a while back. The judge should have had the chance to consider it, to basically say, this is a good point. You know, he's testifying right now to what we need for Maya going forward to make her life normal, but Maya didn't have a normal life before. And there was going to be an adjustment that had to be made. She was going to require care at some point in time during her life. I want you guys to focus on the testimony from today, which was that there would be like a 10-year period within the next 60 that Maya would likely need full-time care. For those of you with parents that are older, you know that that's kind of true for everybody, right? There's a 10-year period where one of our parents is going to need damn near full-time care. It's a good point. Why is the hospital liable for that 10 years if it would have been required, even if the hospital never got involved? It's a good point. Make it in emotion. Make it in emotion. After you do the depo, make it an emotion. Make the point. Don't do it in the middle of trial, in the middle of testimony when this witness is testifying. I think Shapiro had the right of this argument. Shapiro had the correct reading of this argument. It was the timing. And it was how it was made. Shapiro had the right reading of the argument, just made wrong.
Plan coming into Dr. BiFulco's deposition was to try to get him to say how much ketamine, how much rehab, how much PT was she going to need as a result of her just having CRPS versus how much was she going to need as a result of whatever re-injury or whatever lapse in care that you're going to allege. But what Dr. BiFulco said unequivocally to me 3 times, and the reason I asked it 3 times because I was in a little bit of disbelief, but if he wants to say, Mr. Shapiro, I am not coming to trial to tell the trier of this fact that my life care plan is related to a trauma at All Children's. I'm just coming to say this is what she needs. I can't do any more than that. And that's why I asked him the question, not once as a gotcha, not twice, to the point where you can literally see in the transcript, I'm saying, I know you're sick of me asking this, but just to triple check. And this is exactly what the Bingham rule is designed to prevent, is an expert, after his report, I get his opinions, he says, I'm not going to testify to that. Mr. Shapiro, I promise you, under oath, my entire report is based only on what she generally needs and not based on what your client did. And now he's taking the stand at trial.
Well, what?
Phenomenal argument. Make the motion when you have finished your deposition. Make the motion back then. You did the depo. You just said you asked him 3 times. You were shocked because it's completely contrary to a rule that has a case that is named after the damn rule. That sounds like something that should maybe warrant a motion. Just saying. Oh, wait, Courtney, did you pass something? Courtney, wait.
You just said, are those words in here, or is that your interpretation?
Courtney went to law school because of experiences similar to this and just found out I passed the bar. So watching the recap to celebrate. Courtney, congratulations on passing the bar exam. It is about that time. You took the July bar. Congrats to you. Thank you for covering this respectfully. Too many forget these are real people. Yes. Courtney, you're going to run into a lot of scenarios in practicing law that are going to make you question why you got into it. They're going to make you question people and stereotype and do all the stuff. What I will say, keep your head up. Never sacrifice yourself. Don't. Be better than that. And the area of law that you find yourself in, find a way to do good. It'll make you feel really good. Trust me. Trust me. Like, people hate family law. I find it challenging, but I find that I can do good. So it's rewarding.
Those are his exact words in the deposition. I would encourage your honor to read it again.
Can we point your honor to page 30 of the deposition?
Leave that back up, please.
Yes, sir. At page 30, beginning at line.
I'm sorry for the multiple pauses. Dawn. You are banned. Never send another super chat. You have done a lot. I know this case is important to you. I know this is not what you should be making or you should make. Thank you, Dawn. I am covering this case. You don't need to. Thank you. Thank you. It's honestly you guys being here that makes me want to cover it more than anything else. But Dawn, that was extremely generous. $100 super chat. Thank you very much for that.
4.
And then you can see how it continues. But then I asked him, in order to take into account the damages that are solely owing to the incident at All Children's Hospital, you would have to determine what she would have needed had she never accounted for her visit. True? He says, that's not true. And I give him an example. And then I finally say, so are you going to come to trial and say, this is what she would have needed before, and now she needs much more after? He said 3 times to me, no.
Well, if the question is unfair surprise, when the witness at page 30.
I'm sorry. Please go. I apologize.
I'm happy to, if there's anything else you want to say.
Professional note. You don't have to tell the judge to please go on. When you cut off the judge and the judge says, excuse me, you don't have to tell the judge that they can please continue. It's the end of the day. Everyone's frustrated. It happens. I've stepped in it. I've stepped in it a lot. Like, I've stepped in it with judges. That was a misstep.
I'm going to listen totally to what you have to say. Then I would ask for the same courtesy of listening to me. So is there anything else you would like to say?
Only just again for the record, the questions after he initially said that on page 30, I asked him 3 times to confirm at pages 41, at pages 46, and at pages 47, the exact question that's at issue. Again, this is only based on what her needs are now, not because of what she went to All Children's. Same question for psychological needs. Are you making a determination of what she needed but for the treatment of All Children's? Or is this, again, just what she needs without any reference to that discussion? And his answer was, there is no determination. No speculation on my part is occurring about what she might have needed had it not been for the events in 2016 at All Children's. And so, again, I apologize for my demeanor, Your Honor, but it's very frustrating to me because now the witness is about to take the stand. I've had no opportunity to try to separate out what would she have needed before and what would she have needed after, because he can see it.
Yes, you did. Yes, you did. No, yes, you did. You had the chance. You had the chance. My guy, Shapiro, you deposed him how many times? Just because you didn't get the questions.
That's what he wasn't playing under. Thank you, sir.
The court has before it the defendant's motion to effectively strike the testimony of the expert, Dr. Santos Stephen BiFulco, on what the defense contends are
if you know the joke, you know the joke.
Disclosed opinions. specifically the opinions relating to the type of damages that Ms. Kowalski sustained at the hands of the alleged conduct of Johns Hopkins All Children's Hospital, and not the just general, hey, she has CRPS, and the type of treatment she might need in the future. There has been testimony replete throughout this trial about the exacerbation or activation of a defect. Latent defect is kind of the legal terms and what the jury instructions go to, about the conduct of Johns Hopkins All Children's Hospital has made and will permanently make Maya Kowalski's conditions worse. I understand where Mr. Shapiro is coming from, because, and I will totally agree, that there seems to be several passages where Mr. Shapiro did specifically ask that, try to separate out, or are you going to try to separate out, please keep that up, try to separate out what was the alleged conduct responsible for versus what she had just as a generalized condition. So the question is, was the defense surprised by Dr. BiFulco's testimony here? Now, the reason why I wanted to see the report, and this is going back to the original report from, looks like February of 2022, on page 5, it specifically says, the life care plan in this update outlines the minimum care Maya's needs within a reasonable degree of medical and life care planning certainty related to the traumatic event that began on October 7th, 2016, which excludes the beginning of her CRPS. When we look at Dr. BiFulco's deposition on page 30, at lines 9 through 17, the life care plan takes into account the incident that occurred at All Children's Hospital, and that being the major contributing cause for the need for future care. That is the major contributing cause. And as I spoke with her treating and consulting physician, that is the focus. In other words, what does Maya need as an individual, as a human being, now that that has occurred? So the question is this an unfair surprise? The court has to say no, because we had a written report and Dr. BiFulco said that in his deposition. Can the defense impeach him based on his statements, multiple statements? Absolutely. I'm sure they will, but it's not a unfair surprise.
This judge is fair as hell. Judge Carroll, you want to visit, just, do you want to do multi-jurisdictional trainings? Just saying. Someone like Judge Carroll, do you want to, we can have you up here to lecture. Every ruling, while it's controversial, while people disagree, while people will have opinions one way or the other, this judge weighs shit evenly.
Surprise. The court is going to deny the defense motion because it's evident, based on both the report and earlier in the deposition, that the defense was on notice that he was testifying relating to damages caused by Johns Hopkins All Children's Hospital's conduct, alleged conduct. So that's the ruling. Let's move on.
Recall Dr. BiFulco.
Let's go bring in the jury and bring in Dr. BiFulco. Is it BiFulco, or how do you say it? BiFulco. BiFulco.
I do like the closed caption cut as Dr. Buckle. That's kind of funny. The neurodivergent counselor, thank you for the generous super chat. Running into issues with the fact that medical CA and Munchausen's by proxy are not the same. So conversion. MBP is seen in medical conversion, but isn't necessary for conversion.
Okay, everyone,
it can be.
Members of the jury, I just want to confirm that you were aware you did not discuss this case amongst yourselves. You did not do any investigation, and you did not receive any information about this case. Is that correct? And that no one approached you about this case. Is that correct? And have you seen any media coverage since we were last together? Okay. The court is overruling Mr. Shapiro's objection, and Mr. Anderson, you may proceed.
Thank you, Lindsay. That's very, very, very generous of you.
I hesitate to ask for you to read back the last question.
It was 30 minutes ago, counsel.
You want me to just ask another one? It's right. I'll ask another one. All right. All right. Let me get to it.
So why was there the argument to block this testimony? Because it is fucking devastating to the hospital. Because this is what this witness is allowed to do. This witness, Dr. BiFulco, is allowed to essentially summarize the opinions of the other doctors. And if those opinions are viewed as being correct, he's allowed to quantify what the damages associated with those opinions are. So essentially, this witness gets to say, assuming, dear jury, that you believe the plaintiff's expert witnesses, this is the dollar figure that you should award. But it goes further. This doctor is allowed to testify because he has reviewed the records, because he can now testify to things that he reviewed in those records, because he's an expert, and you can refer to hearsay in making your conclusion. So he gets to throw a couple of extra jabs in there of assessing the credibility of the previous witnesses. And he does not shy away from that. There is a reason they wanted that excluded. He is damaging because he is the comfort witness. He is the one that is meant to explain everything to the jury and consolidate it into a package that says, dear jury, you've heard all these doctors. I trust them. I know them. I love them. They've told me what it costs to do what needs to be done. I'm going to put that into one short 10-page report, and I'm going to read it to you. So don't bother reconsidering any of the doubts you have. Just, if you believe the plaintiffs, here's how you reach the conclusion. That's his purpose. And he does a good job. He does a really good job. And they don't get at him with cross. They really don't. So here we go.
Opinions here. I think we were talking about the basis of your opinions and the fact that you had read a number of depositions. Which of the physicians, well, I'll ask you which of these physicians you relied upon in formulating your plan. Dr. Kirkpatrick?
Yes.
All right. Dr. Brewerton?
Yes, of course.
Dr. Henschke?
Yes.
Dr. Chopra?
Yes.
And Rebecca Johnson?
Yes.
Now, after that after reviewing these matters, I want you to, again, refresh a recollection about what you were asking about in these, what do you call them, telemedicine visits? Is that what they're known as?
Telemedicine encounter.
Yes. Tell the jury what you were looking for and what you found out in those.
I was gathering factual information as part of my analysis. Those 3 steps are facts, opinions, and conclusions. Before I could even move on to sound opinions and conclusions, I have to make sure I have all the factual information. And part of that is, as a physician, as a medical doctor, I have the capacity and the responsibility and the ability to evaluate Maya and to confirm that what the other medical providers have seen and done and heard is actually what's going on. So as a medical doctor, I did that. Now, I didn't have, unfortunately, the opportunity to examine her with my own hands. I did invite her to come to my office, but as you heard for weeks, she is cautious of physicians, and I understood that. And so we opted at this time to do a telemedicine visit. And I spent a lot of time with her on Zoom, face-to-face, interviewing her, asking her, confirming all of the things that her treating physicians told me, all the things that are in the medical records. I wanted to confirm that with my own eyes and ears. Is this true? Once I did that, and I was certain that I had enough factual information, then I moved to sound opinions, and I started to explain what those opinions were.
All right. If we could, let us go through your opinions. If you need to refer to your notes to begin with, I think this is at page 3 of your report, or you can direct me elsewhere.
So there are actually 2 parts to my report. There's a narrative report, which is just typed words, and then there's the care plan, the life care plan. Which would you like to look at?
Can we go through just very briefly the basic recommendations in your narrative and the support there? So we have some context for the life care plan.
I would refer you to the very last page. Well, so
do you guys remember when I covered the Murdoch trial? And so many of us covered the trial, and we said, we want a timeline witness. We want a timeline witness. Give me all of the information and put it into one package. That was this witness. What was funny about this witness was that after cross, 8/15/51, the jury, who has been so curious about everyone,
Members of the jury. Just the one or anyone else? Okay, can I see the transcripts, please?
didn't have much to ask.
The cost of Dr. That was a quick one. Okay, Doctor, the jury had a question on the cost you gave us. Have you taken consideration the cost of doctor therapist medication as time goes on, prices go up? That's what this Kirby did.
Not a good question for the defense. That sucks. If you're the defense, that sucks. Dear doctor, did you take into account the fact that doctors are more expensive today than they were yesterday? As in, should I add more zeros to the zeros that I was already adding when I asked Ms. Kirby the question about the zeros I should be adding? Mm. 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 Hmm. Will, the real Ray, please stand up. Have you adjusted for inflation, or I'm gonna continue that question, or shall I do it for you? That's the end of the question. Have you adjusted for inflation, or would you like me to do that for you? Because I, member of the jury, would be happy to. So there's one juror who is very, very not shy about how they feel. That was there's one juror who's like, I don't give a fuck. I want the hospital to know I am in my book. It's like, here's another three zeros. Oh, wait, you didn't mention that part. You didn't adjust for inflation. 3 more zeros. It is. I am bewildered by these questions because they are very wow. Wow. Jury is on point. They're right there. Holy crap.
I gave numbers that are based on cost research following a methodology that I must adhere to in today's dollars. Ms. Kirby then takes that and adjusts it to what they call present value. So the numbers I gave do not take into account the likelihood that things are going to go up and not down. She accounts for that.
Side note. Wait till this juror gets instructed on punitive damages. Oh God. Oh, this is bad. Oh, I'm sorry. I'm laughing because I saw this question come up. It was a great question. Is there a ceiling on punitive damages? Technically, no. Punitive damages are meant to dissuade the conduct in the future. They are meant not to compensate the victim for the injury they sustained, but instead to dissuade and discourage the defendant from engaging in such behavior in the future. So you will hear things asked such as treble damages. Treble are presumptive punitive damages. Treble damages are 3 times the actual damages. Actual damages is what this doctor is testifying to. This doctor is testifying to what the plaintiff is arguing are Maya's actual out-of-pocket costs or injury because of the conduct by the hospital. So in order to make her net even, right, to bring her back to zero, even, put her back on the plane with every other person in society, this is what you have to give her. Okay, that's what actual damages are. That's what this doctor is testifying to. So these questions are already suggesting that they think these doctors, or this juror thinks these doctors are estimating the bringing Maya back to everyone else is not enough. When this juror finds out that she or he can award punitive damages, the questions are suggestive of how that person might my vote. I'm just saying this juror has been today very spicy juror. Spicy juror. So, Apple Silver, good point. Rob, what happens to the award money when and while the defense appeals? It doesn't exist. There's a bond posted, but it does not exist. So the plaintiffs know that they're playing this. They know that the hospital is going to appeal. They know this award is going to be tied up for years, and it will. It will. It'll be tied up for years. But what do? You can't fight the whole system the whole time, all the time. Will the real Ray, can I just put something on the O key and walk away for a few hours? That juror would probably ask that question, to be honest. But the doctor answers and kind of says, hey, we're good. But we get to the argument later. This was the part I found kind of interesting. Let's see, because they start arguing, but it's not towards the end of the day. It's right about here.
My statement here, I think, is clear enough.
It is, Judge, and I was going to ask for some guidance anyway with respect to these
Oh,
witnesses.
wait, hang on.
Court order Dennis.
15th call. This is referencing a call on November 29th. There's been no.
Oh, hang on. There we go. This is where we're going to end it today. These exchanges. Bear's life, thank you.
So that's one page. So can someone put that back up, please?
The email.
Thank you, Karen.
Go ahead and give me your best shot.
Oh, do you want to take it?
Yeah, Judge, you heard
Thank you,
the
Bear's
conversation that is being recited here by Ms. Beatty in the November 29th, 2016 memo. We are trying to move into evidence. And in this email, she purports to describe that particular conversation. And other than
Bella Brat, they were
stating, well, you don't live in a prison camp, you don't live in a concentration camp, or words to that effect, Maya Kowalski was perfectly polite and stayed within the rules. And yet Ms. Beatty writes here to DCF and talks about things that simply never happened. It's a complete fabrication. Well, most of it is a complete fabrication. And so we want to put it in to demonstrate that at that time, Ms. Beatty was not only did not have authority based on the November 10th order, but Ms. Beatty was directly misrepresenting not only to DCF, but to my families and the Sarasota doc.
Let me give you the brief rundown. This is not coming in. This is after the shelter order. This is an email from Kathy Beatty to DCF. It's a report from the hospital about facts that were being observed at the hospital. It's a pure investigative function and it's protected. It's immune. It's not coming in. But now we're starting to see a little bit of the back and forth. And it's not this argument, it's the one that follows it, where you start to see where the defense is going to go with this. The only Latina, Rob, love your hair like that. Love. I can put the hat back on, but not going to. No, what's going on? It's late night. It's late night and I'm tired and it's been a whole week. I had hearing. I'm so tired. I'm so tired, but this case is really important. I've watched this replay like 2 days in a row. Going on.
Or outside contractors that Beata Kowalski was doing things she simply was not doing. Anybody who listened to that tape, that audio, and then compares this, It's just ridiculous. And so we believe that it is probative of the hospital's complete and utter lack of supervision and complete and utter lack of training. I don't worry about supervision anymore, but complete and utter lack of training, and goes to our our tortious, where's my brain? Our intentional infliction of emotional distress count. And so, and counts 21A through C. So this is for Ms. Beatty also a present recollection recorded. If that is indeed her recollection, there's something very wrong with this picture, because we have in writing what it is. Also, we move under 90.105 parent 2, and relevancy of evidence depends on the existence of a preliminary fact. The court shall admit the proffered evidence when there's prima facie evidence sufficient to support a finding of the preliminary fact. And the court had a dialogue with us over the admissibility of it. And frankly, at that point, I thought the court was going to admit it. However, the court was concerned as to whether Ms. Beatty had the authority to do this. And then it turned out that based on the November 10th order, Ms. Beatty absolutely did not have authority on that. And then the court heard, and I should be able to cite the court to the exhibit number of the audio, but the court heard that audio call with Ms. Beatty's reinteract. And so this would be used in conjunction with that. And therefore, we believe it's probative of issues in the case. And Ms. Beatty had absolutely no right to be making these comments.
First of all,
Because she shouldn't have been on there.
sorry, you're done. The audio that was played for the court is a November 15th call. This is referencing a call on November 29th. There's been no audio of this call put in evidence or heard by the court. For them to stand here and say that this misrepresents the call, there's no evidence supporting that. The only call that's been put in evidence is from November 15th. This is referencing a call on November 29th. So the redirect that they're referencing, which by the way,
Let me pause. Lisa, check. This was never coming in. This is way too close to the investigation to come in. The immunity exists. It's not coming in. It wasn't coming in. Before this argument, the judge looked at Anderson. This was their motion to reconsider. And the judge looks at Anderson and goes, okay, give me your best shot. I appreciated that because it was honesty between the attorney and the judge. I loved it. They have to make the argument. They have to try. That's what it was.
wasn't Miss Beatty, which we advised them of, and they went on and put two witnesses on to say it was Miss Beatty. It wasn't. It's Miss Laporte. Has nothing to do with this document.
Well, I'm not reconsidering my ruling. I remain convinced that this document should not come into evidence. This document is a request from the hospital to DCF and ultimately the dependency court to change the court order with respect to supervision and whatnot. I do not read this letter as any sort of admission that there was no authority, or it doesn't go to the question of whether DCF had delegated or didn't delegate anything to the hospital or Ms. Beatty. So I'm going to continue its exclusion. I will deny the motion for reconsideration, which is at 3466. I'm not going to do a standalone order, just orally enforced, and then the court minutes will reflect my ruling on that. Okay. I've got some notes on some other things.
Yep.
I see there's Madam Clerk, DIN 3489, DIN 3489. And for the court reporter, DIN is docket identification number. So DIN 3489, defendant's motion for entry of order authorizing guardian ad litem and Department of Children and Families to disclose and testify about confidential information.
Okay, before we get there, I'm going to catch up on super chats. I promise you. We're going to do all of them now, and then I'm going to play the last bit. I'm going to give my explanation, and we're going to say goodnight. Because it is almost 1 a.m. And I need sleep. The only Latina, one question: how did they get those text messages that doctor sent? They subpoenaed the phone. They did. How they know that people were messaging? They subpoenaed the phone, and there were contact information. They called her ketamine girl. Love the recaps. Thank you. Thank you very much for being here. Lori Ross, Rob, why did the Kowalskis settle with Sally Smith but not J Hatch? Simple answer: Sally Smith doesn't have money. J Hatch does. Do you know? I think what they all do to Maya is horrible. I have an incurable disease and no one believed me for a long time. The number of people who've been watching this trial who are afflicted with something that was misdiagnosed, ignored, disregarded, has been really remarkable to me. So I'm sorry that you went through that. The reason they settled with Sally Smith is she didn't have money. You're going to sue her into oblivion and spend the money to sue her, but not ever get any recourse. The hospital, however, does. So, and Sally Smith, you saw her depots played on live TV. I mean, it's kind of pretty significant injury. Amber C, did the hospital staff have a responsibility to report ketamine doctors if they suspected misuse or abuse by those doctors? Don't understand why only claims of mom. And that's part of the inquiry, because mom told Sally Smith in that first interview that everything was done under the care of a doctor. And I don't understand why you wouldn't contact the doctors to see if, because here's the thing, if mom was doctor shopping and going from one doctor, but not telling the other doctor that they had just gotten the dose from the other doctor, right? That might be reportable. But wouldn't you have to call both to confirm that? It's a good point. Happenings at Lomgo Farms. Thank you for covering this. I lost our boy to medical malpractice. Our lives were changed forever. I'm sorry for your loss. There's nothing that I can say that could ever heal the harm or the hurt that you are experiencing right now. I hope that, well, I hope that you believe and have faith, and I will certainly believe that your son's in a better place. I'm very sorry for that loss. Too many people are taken from this world way too early. And where we can prevent it, we should. So, to your son, who is haloed hovering above all of us, cheers. Thank you for sharing. Rob, thanks for your hard work on this trial. Greatly appreciated. Can you confirm how many hours each side has? The judge gives a recap at the end of the day, every day. A little unclear on RA's channel, Heart Law Tube. We can recap it. I'll try to get the last minute of the judge. If I can't, then I'll post it on a post later. Ginger Snaps, how is Sally Smith an independent investigator when she has a business relationship with JH? That's a very good question. So many potential conflicts for me too. And that's what the judge keeps bringing up. Noni Mac, thank you, Rob, for your dedication, diligence, thoughtfulness, and courage covering this case. A 14.5-year CRPS warrior. Noni Mac, congratulations on the continued survival and continued kicking the ass of a disease that can beat you down. I have a buddy of mine who he's been suffering since late 20s, so about 10 years. Cheers to you, my friend. Jonathan Duger, off topic, but there's a case working its way through the Atlanta area courts. It involves an OB/GYN internally. Oh, I can't read that out loud. I can't read that because YouTube will be very upset, but I will try to give the caveat. An OB/GYN who internally does something to a child while in the birth canal, and then after doing that act that resulted in the unsuccessful birthing of the child, the hospital tried to cover up that the unsuccessful birthing might have been caused by something that was not an accident. That was, that's a rough case. I have not seen it. I will try to look at it. I very much doubt that I can cover it. Just because this is about as sensitive as I can get without lighting up every flag on YouTube. Gil, thank you, Rob. I always appreciate your caring approach. Just curious, I always see Jules contributing too. Are these recaps somewhere that you'd ever talk together on stream about courtroom observations? I would. I really would. I would. Right now, here's the thing. Here's what's happening right now. Jules is waking up and going to court every day and spending all day in court. I am waking up, doing law practice and like catching replays of court at 2x and doing recaps at the end of the evening. I don't think either of us has a spare moment or minute other than during the recap to discuss anything. And I would actually just want to talk to her for a bit before, even ask her, is this something you want to do? What do you want to talk about? I owe Jules a call. I do. Her insight's been really fun. She has a perspective on how she thinks the jury should weigh out and come out. I don't blame her for that. She has a perspective, but I'm very curious on which jurors are writing which questions because my God, the questions are so good. It's good. It's a good comment, Gil. Thank you. The legal cat lady, as a Canadian lawyer, I was flabbergasted when I heard the depots, especially the expert doctors, coming a little later. Can't wait to hear your comments on it, if any. I had a lot of comments. I hope you heard them. LJ Peach, as a parent who had a special needs child, I woke up 2 or 3 EDMDs who refused to listen to me about her treatment. I also carried written orders from her neuro and primary and phone numbers on both. That's a problem. The fact that that happens is a problem. It's frustrating. Kathleen Tackett, please tell me what the defense has when they're up. They have law. They have a lot of law. They have DCF, and we'll talk about it in a second. Esme, Rob, are Bietta's personal notes able to come in? No. They are hearsay without exception. Analytical Blarney, we're the red and white and blue from, red and white. We're the red and white from state, and we know we are the best. A hand behind our back, we can take it on the rest. Go to hell. Oh no, it's not come over the hill to Carolina. It's go to hell, Carolina. Devils and Deeks stand in line. We're the red and white from NC State. Go State. But I appreciate the PC version. Bon, thank you. How many days, weeks the trial have left? 3 more weeks. Zachary's mama. Hi, all. Late to the game. Where's Ian tonight? Ian was out with the missus. LJ Peach. Hey, Rob. Speaking of judges, you go in front of how is Judge A doing? I've been in front of her in a while. I've been bounced around. So I'll let you know what I do. KC Cat, do you recognize the blonde? I swear I saw her testify in another case. I have not, but Peter said that she is known for being the economist expert, so I wouldn't be surprised. Maureen Griffin, one disadvantage I can see here is based on these questions. Why wouldn't the defense force a mistrial? I don't know. Kathy at odds, can JH settle, pay to avoid the extra zeros? They don't have the zeros to settle with. $220 million is not a small amount. Happy Annie, do you think Jay Hatch will try to force a mistrial if they don't think they can recover? Thank you again for another amazing recap. I was asked this question earlier. I think that we are in dangerous mistrial territory for what we're about to discuss in the next few minutes. And I'll explain that then. Will the real Ray please stand up? I've had depression since I was 12. In college, I would be on Dean's List on one semester and have 1.5 GPA in the next. Ray, me too. But they misdiagnosed my ADHD as depression. And until I was treated for that, but mental health, man, go. If you're struggling, go and find somebody and keep searching through them until you find someone that listens and hears you and you actually, please. LJ Peach, so they're trying pre-existing illness. They were and they would. They always would. Uncivil. Let's try a topical joke. Why did the hospital and the DCS agent pick up a pencil to sketch a caricature together. Okay, I get it. Is this working? Oh, I'll try. Kurt, your earlier one was better. Snazzy, trinkets, jewelry. If Maya wins the case, can the attorney's fees be included? That's part of punitive. Bringing this case forward, be reimbursed by the hospital through the courts/judgment. It's possible, but there's going to be a lot of appeals. OB Nurse Chelsea, as a juror, I would want to know the answer to Shapiro's question. What if it was just the CRPS that started before JHatch? That's what I was saying earlier. It's a valid question. I think Shapiro had an argument if he had made the motion. It's way too late to do it at trial when the witnesses started testifying. It'd be important for calculating true damages because CRPS was there before JHatch. That was the point I was making. And that's why I said Shapiro deserved a little bit there because he did catch it. It was just, he should have made the motion. Liam 007, Rob, given the liberty interest at stake, should courts be required to provide counsel to parents in a dependency action if they can't afford one? They are required. They are. They get counsel. Deborah Bates, your coverage of this is the only way I can watch this trial. Your compassion leading with your heart, creating a safe place. Without you, I can't watch. Genuine gratitude for you and your coverage and courage. Thank you more than I can say, Deborah. Thank you. That is a very kind remark, and one of the reasons I continue covering this. And one of the reasons I declined to do FNF because no one else is covering this trial, and I wanted to give people a recap. JM, I read that they didn't include CBD at all in this suit because they wouldn't be able to sit a jury if she/they were included. Please explain. I don't know the sitting a jury argument, but I do know that they settled out. I think part of it is the CBD didn't have any money. They weren't going to get anything there, ever. Mackenzie, have to go to work in the morning, so I will catch the rest on recap, but thank you for covering this trial. It is fascinating, especially when we don't ever really hear about these cases in normal news. So I have, at the risk of offending so many people, but I want to do this, Dr. Nurse, PHRN here, watching and sharing with my leadership students who are also interested in this case. Got to ask, are you single? Well, on that note, I'm going to deflect and not answer the question that I never answer ever, ever, ever. I'm going to bring in a friend of mine who I don't know if they've, where is it? How can I do this? Let me do this. Can you unmute yourself? You're muted.
How did I get muted?
I
was just going to say, bringing me in has nothing to do with the answer to that question.
No, it doesn't. Nothing to do with it. Nothing. I just wanted to.
How are you doing?
I'm 5 hours and 46 minutes into a 2-day recap of the most complicated case I've covered in a long time.
So you're looking for a coffee sponsor, is what you're saying?
Yeah, and Xanax / whatever like antidepressant people are out there because this case is wild.
I like the. I haven't been watching a whole lot, but I like the judge or the jury's question. That's one of those moments where it's like, "Oh, check please, check please."
You mean the one that I sent you? Hang on, let me pull it up. The jury question that was. Where is it? I think I have it up still.
The jury question that is like, make you go back to your office and cry if you're
a defense counsel.
If you're defense counsel.
Well, it was this one. Hang on. Where are my pictures? Oh, that wasn't the only one, by the way. There were several. And the window is here. The jury question being, judge reading jury question, was the possibility that Maya's PTSD affects her abilities for possible relationship, then marriage, family, children, and all the, quote, things that her past family enjoyed, but now will never be able to continue. She now may not be able to enjoy, quote, motherhood like her mother did. And if Maya does have children, was there any, quote, monetary value, end quote, placed on the added stress Maya would have when her children went to a hospital for something? Or should I add, if able to, additional monetary value to your figures?
Yeah, that tells us we're not talking if liability, we're talking amounts liability is what the jury is thinking.
And people were accusing me. They were like, when I made the comment that I have talked to other lawyer friends about this question, and they all said, "This is when you start punching in zeros." Everyone said, "You talked to Peter."
That was my quote.
I was like, no. People are like, "You talked to Peter." I was like, "No, I talked to everyone. I talked to everyone. I said this to everyone," and they all said, "This is when calculators come back to the jury room. This is when people are like, add zeros."
Well, yeah, I think my quote was, this is when you start get to check, start writing zeros, and you look at the other side and you're like, tell me when I can stop. So, yeah.
So we have a last bit of argument. Do you want to hear it?
I think so.
Good. So the last bit of argument for the day. 2 days of recap, Ian. It's freaking hard, man. Oh. Sally Smith depots. I'm going to play those separately for you sometime because that woman is, she's something else. But here's the last bit of argument
at trial. So who from Mr. Hughes?
Yes, Your Honor. You may recall we filed a very similar motion back when several of these individuals were regarding ad litem and
let me explain. We're going to do let me sum up. So a motion was filed for a comfort order. When you have a state agency coming to testify, especially when they are a state agency charged with the protection of sensitive information, that state agency will often require a comfort order. They need an order that says, "Judge, the judge saying, I'm going to authorize you, investigator, to testify because your information is valid, it's on point. It's even though it's confidential in normal circumstances, it's permissible here." So this motion is for a comfort order saying DCF agents, people from DCF are going to come and testify and say, this is what we were doing in the dependency action. Well, Ian, I've talked to you about this case a bit. There's a very fine line, dependency versus hospital. And we're kind of navigating this razor thin barrier. What was protected and immune because DCF state agency, and what was the hospital going beyond that? And the hospital's like, we want to muddy the water everywhere.
Of course they do.
Yep. This motion is saying to the court, we are going to bring in DCF to talk. And all they're asking for right now is a comfort order. So it's not really this motion itself. It's the preview of what's to come next week. So
DCF were to be deposed, and DCF specifically requested that we have the entry of this order or this motion in order reflecting the same when we did depositions. They've now circled back and requested the same to testify at trial. In the past, the guardian ad litem's office has also requested these types of orders, and while the guardian ad litem office has not specifically made that request here, the DCF has, and to just have an order which I did attach to draft orders exhibit A that tracks very, very closely, if not plagiarizes what we did previously when we did depositions. This is just really kind of touch all of our bases and satisfy DCF, and there are considerable concerns about confidential information under Chapter 39. They're sticklers for this kind of thing, so we were just having to work with enter an order to allow these folks to come in and discuss matters.
Now, just because I enter this order is not obviously an authorization that the scope of what is contained in this order is coming into trial.
And no attempt is being made here. This is just simply, we're going to stay within the confines the court has directed, but DCF still, they're going to take a stand, discuss matters if they want an order covering their basis, so to speak.
I thought there is no way that we'll be able to keep this within the guardrails. As I see it here, what they will bring out will require us then to counter that with further memos. And now we were getting into whether DCF can contradict or whether DCF can expand upon a court order. And clearly they're not authorized to do so, but in many instances here, the emails demonstrate that's exactly what they were doing. And so DCF did not have the force of law here. Yes, they were in charge of the shelter, but they did not have the force of law the way the court orders it. And I cannot see how, frankly, this won't get into a very confusing dissertation on who controlled what when. And we believe that that is for the court to determine at the time of the jury instructions on the order, which defines for the jury what's going on. To us, it's really irrelevant what DCF thought at that time. The only point I can see that them making is coming in and saying either secondhand, or I suppose maybe there's a firsthand, someone there who saw Maya and then said, oh, she seemed to be moving around like me. Well, that doesn't seem to be enough probative value given all the other testimony to outweigh the problems with this. And so the court is aware at the end of all of these memos, there's an email.
Have you caught how far beyond the motion he's arguing right now?
A little bit.
DCF is asking to testify. And he is like, he's a mile ahead of this, going, this is where this is going. And the judge is like, hold up. We knew this case was going here. So.
From David Silverstein, a summary of the case in which the final paragraph is in essence, we were wrong, forget it. And I intend to use that if they try to bring any of these in. And so that I think, I can't understand why they would want to have this, but I seriously doubt how they can keep this from going far outside the bounds and confusing the jury.
Well, I trust in your ability to stand up and say object. And I also trust in my abilities to rule consistently to what we've been doing. I see this as nothing more than a.
How much do you love a judge that says that?
Not much.
Well, it's like, I'm not going to be proactive. I'm not going to jump ahead.
But I
You
do
can
want
object.
a judge to be proactive in certain circumstances.
Say that one more time.
Sometimes you do want a judge to be proactive. So I don't know.
With
I'm
this
torn on
one,
that one.
with this one, I like this judge's ruling. So to kind of go where this is going here, people were asking me because DCF and the investigation is off limits. They're protected. Chapter 39 immunity protects them and the agency from being investigated or from any liability here. That feels wrong to a lot of people. They don't like it. And I tell them, I'm sorry that you don't like that. That's why we vote people into office to vote and make laws that can fix that. But just because you don't like it, I don't like it, doesn't mean I can change it, and doesn't mean the judge can change it on the spot, because that would mean the judge is taking over the law of the legislature. We can't do that. So the judge is bound by
I mean,
the
they
law.
do that all the time, but
Oh, they do. And that's one of the reasons I have liked this judge, is this judge has played it very much down the middle. I texted you, I think this week, like the judge has basically said, this note appears to be both a mix of investigation and treatment. And the hospital's like, but it's investigation protected. And it's just like, well, it seems kind of muddy. And the hospital's like, it's muddy. You can't let it in because then you're letting in the immunity issue. And the judge is like, but you kept her on staff. Like you made it muddy. Like you made it muddy. I'm letting it in. The jury gets to decide whether it was your bad or it's protected. But the jury can be confused. No, the jury's pretty good at catching that bullshit. Just like the question that I just read from the jury seems to suggest. Like they're pretty good at like being like, no, that's that bullshit. I'm not letting that in.
I mean, juries are better than a lot of lawyers give them credit for, which is also part of why a lot of lawyers don't like them. But I mean, I'm torn on all of that because it is tough. Juries are better and worse than lawyers give them credit for, I guess is the way I'll put it.
Yep, I would say that correctly. One of the things was one of the audio recordings got introduced by a detective, and the detective or someone on the jury said, did the detective announce that it was being recorded before the conversation started? It was a jury question.
And the thing is, it's not necessarily the greatest jury question because like the law may or may not require that. in a particular area.
Correct.
And so, you know,
Side
that
note.
may be the jury deciding something needs to have happened when it really didn't.
Side note,
Um,
the law requires it in Florida.
Good stuff. In Canada, no. Which baffles people sometimes because they're like, you didn't have permission to record me. It's like, great news. Didn't need it.
No need to. Yeah.
Like, not asking for it because we just don't need it. I got a case right now where the guy's like, this is an illegal recording because I didn't know I was being recorded. It's like, you didn't have to, because the person who was present who was recording you did know.
Yeah.
And yeah, I can see why that sucks for you, but like that does not help you here. So that's always fun. People don't like that.
No, it's interesting. This case has been really, I mean, Ian, I've talked about this case a lot. Like, this case hits close to home for me because this is the area I practice in. And
you mean
it's
sadness law?
It's sadness law, but it's also gray area law where there's a lot that's explained on both sides.
Yep.
I've been trying my best, and the support that I've honestly, the support I've had from you, Emily, Rick, Alita, friends, everyone in the chat, like keeping me focused on this case has been the reason I've kept on doing it, because it's also one that I think people need to hear, because it's pretty wild.
It's a good case. Like, it's an interesting case for what's going on. And I mean, there's arguments on both sides, but it sounds like the jury is starting to make up their mind.
Oh, they're there. I'm gonna see if I can't find the one part of Sally Smith's depo I wanted to play again. There's a part of Sally Smith's deposition where she literally was being asked, you told them that, you know, maybe you should take them off of medication. Did you suggest that to them? Like, well, we had discussions. Hang on. I think I got it.
Yeah, but did you actually suggest that?
Oh, wait. No. When you hear the text, fantastic. Let's see, inconsistent patterns.
Also, I'm throwing some of
unique
your
garlic,
favorite
my
hot sauce
favorite.
into my beverage.
My very, very favorite. Doctors. Well, here you go.
See, I got to figure out a way to get you a bottle of something so that you can have a new favorite.
Well, I have a pen heading your way.
It's I couldn't. The kitchen where this is made is not FDA registered, and they're getting some headaches about getting the registration, like just bureaucracy stuff, not like unsafe or anything like that, just bureaucratic headaches. So this round, at least, is not going to be FDA registered, which means I can't ship it to the States. That said, if you know people, they might. Yeah, I don't know.
We're not going to say that out loud on YouTube, but we can talk behind the scenes.
I mean, there's different legalities for a friend sending a friend something versus me doing it.
Okay.
So
yeah. This is Dr. Sally Smith. Dr. Sally Smith was employed by a company, Suncoast, who was contracted by the Department of Children and Families to be a child abuse medical investigator, basically. At the same time, she was also on staff at Johns Hopkins All Children's Hospital.
Oh, that's not good. Don't like
well,
that.
It gets better. It gets better. Maya Kowalski gets admitted on October 7th, and on October 8th, a person in the hospital, a doctor, calls Sally Smith and says, hey, can you take a look? Before any call to the DCF is made. So no investigation, nothing, no call. Doctor says, hey, doctor friend, we have this possible case. Sally Smith checks the medical records that she has by benefit of her staff position with JHatch. After checking the medical records, then encourages other staff to make a call to DCF. DCF then calls and gives her authority to investigate. In the course of her investigation, she also starts issuing thoughts, suggestions. We should take her off of the medicine. We should put her in a room and, you know, an EEG room and monitor her. Well, that sounds more like treatment than it does investigation. So in what role is she acting? So this is her deposition, and Mr. Anderson, or no, this is Whitney who's asking the questions. So first of all, when you see a witness looking at you like this in a depo, you know you're doing it right.
Oh man. I had a depo where the witness just looked at me like I was like they wanted to kill me.
Yep.
And right after that, the opposing lawyer was like, because what we wanted was we wanted to get our client out of the litigation, right? We wanted our client to not be part of it anymore. And so they basically said no deal. And then right afterwards, it was, they're like, oh, how about we just cut your client loose? And it's like, no, now you're cutting our client loose and paying them for the, you know, basically asshole tax.
The inconvenience.
And yeah. So, yeah, that was good stuff.
So this is Dr. Sally Smith answering questions about her level of involvement with the doctors. I'm going to let you hear at normal speed. Oh, no, not mute.
Did you direct any actions?
I had discussion with several doctors at various points in time regarding things that could be considered to improve Maya's safety and her and
has she answered the question yet?
Nope. She'll get there eventually.
the effort to have her have a more effective separation from her mother. There were a lot of times when she was Skyping with her mother, even though she was sheltered in the hospital. And so there were some discussions related to ways to minimize effects on her safety related to that.
Beyond discussions, did you direct any actions?
I don't believe so specifically, no.
Did the hospital look to you for direction?
I had discussions with several treating physicians at points along the way while she was admitted.
All right.
Answer the fucking question.
Yeah, and the thing is witnesses always think they're clever when they don't answer the question. It's like, you know, I can just keep asking, right? Until you actually answer the question, I can just keep asking you it. And I've literally asked a witness like the same question 20 times, just being like, but I actually need the answer to this.
Oh,
and
my favorite move. I don't know if you use this, but at trial, when I get the asked and answered, like I get it twice, and I look up to the judge and I say, Your Honor, counsel would have a point if there was actually an answer to my question. I have asked the same question verbatim 2 times in a row. It has not been answered. If his witness would simply answer the question, then perhaps I would move on.
Yep. And it's very effective. Like, just answer the question or I get to dunk on you. As a witness, your goal is probably to avoid me being a dick to you. Like to avoid me dunking on you and showing you up. Don't make it easy on me.
This is the face the jury saw today. Right here. That.
And that's the other thing is if you're in a video depo, mind your facial expressions, right?
Like recognize what you're.
Yeah. Mind your face.
All right, let's look at what we'll mark as Exhibit 7.
Wait,
Dr.
did she
Smith-
just
Along the
roll
way while she was
her eyes?
admitted.
All right, let's look at what we'll mark as Exhibit
She
7.
did.
Dr. Smith, this is two
And the other
sets of
thing I've
text
done
messages
in
between
trials
yourself
is ask a witness,
and-
did you just roll your eyes? And they're like,
Well, I've done that during depots.
and then
'Cause
it's
the
like,
transcript won't show it unless you.
you know that you need to take this seriously, right? This is a court proceeding. There's, is this funny to you? And you can make the witness look like a giant jackass.
Yeah. You don't need to go much further than this. This is what I want you to see.
Dr. Major and Dr. Deese. So let's turn to the third page of the exhibit. And these were produced from your phone, correct, Dr. Smith?
Yes.
To orient the jury, as we look down to these text messages, we see, for example, in the second text message, reply from SS. Who would SS be?
Me,
And reply from PD. Who would PD be?
Paula Deese.
Okay. So you have her number in your phone?
Yes,
She's a saved contact?
I believe so.
Let's look at the second text from the bottom. This is a text from you to Paula Deese where you state, we may need to try to monitor what she's doing online. I wouldn't put anything past her mother.
I'm sorry, where are we?
Page 1 of your text messages.
Oh, okay.
So when you called Cindy, what did you learn?
I don't know.
No independent
I
recollection?
I went there and I talked to some people. I don't know if Cindy was one of them. And I vaguely recall looking at some of the stuff. I know we had
You hear how her
some
voice
discussion
changes?
about what they
Yep.
had seen and what they had, captured on the video in terms of whether I really looked at any long review of that. I don't believe I did, but I think that I did have a discussion with
hear the
people in
weaseling.
that office.
Dude, I know that you hate the body language stuff. I'm not talking about that. What I'm talking about is just credibility portrayed by a witness.
Oh yeah, no, and I mean, there's a big difference between those two things. I'd 100% agree that she is creating credibility issues. Where I get into the body language,
Oh yeah. I'm
is
not
like
saying
where
that.
it's
I'm
like,
saying, I'm saying she has her voice went to quiver and then she coughed into her sleeve and then it's like it's all the things that give everyone the little feeling in the back of their neck that goes, this doesn't feel right.
yeah,
office about what they had observed, which, as I said earlier, was essentially documentation of many of the things that were being observed by the physical therapy, occupational therapy staff, child life, music therapy, in terms of inconsistencies about what Maya said she could do. And the pain that actions would cause and what she would do when she was just acting on her own without somebody asking her to do something.
Doctor, do you also intermingle the professional life and personal life in your personal email address?
I don't use email related to patient care. I do receive email from, for example, the medical staff office on my personal email.
Okay. The medical staff office of whom?
Johns Hopkins All Children's Hospital.
All right, Doctor, we've spent some time discussing your use of different devices and technology. I'd like to direct your attention now back to the text messages. It was previously marked as an exhibit. The response to the fifth request for production from August 30th, 2019. And I'm on what's at the bottom, page 2 of these text messages.
This part.
There's a message from October 21st, 2016 at 12:50 from you, doctor, to Dr. Deese. It says, hey there, just a few things about Maya. Do you have a minute for me to call? Do you recall what you wanted to discuss? regarding Maya on October 21st, 2016?
No.
Do you recall how long the
Whenever a
call
lawyer
was?
starts
No.
reading you your own texts, it's bad.
You were in close
It's bad.
contact with the hospitalist, Paula
bad.
Deese?
I had a number of communications with her.
A number,
during the-
huh?
And when you answer a question that direct, if you answer a question that direct, that stupidly, here's the thing. I've told people this before. Juries will forgive you if you say yes. I text her all the time. She's a friend and a colleague. Jury's can be like, I forgive you. No problem. I understand.
Yep.
You play this game.
I have had plenty of cases where I'm like, I actually hope that they start lying and weaseling, because you might even have nothing. But if you start answering questions like this, my nothing turns into something. That's how you can turn my bad hand into something that is actually pretty solid
Workable
by the end of it.
Not just
Yep.
workable, but when you do it like this, like it's about to come up.
during the time that the child was in the hospital.
All right, it looks like an hour and 9 minutes later at 13:59.
Here, this one.
Perhaps after discussion, you write, also, probably already in progress, but maybe get her off as many meds as possible. You're suggesting action to the hospitalist on the case at this point?
We were.
Yep.
Answer that question. Ian, answer the question based on the honest reading of the text. You are suggesting an action to the hospital at that point. Isn't that right?
Yes. That is the only answer there, because that is what she was doing.
We were discussing elements of the case and the care.
Do you agree with the characterization that you're suggesting action on the part of the hospitalist?
As it says, I texted to her, probably already in progress, but maybe get her off as many meds as possible.
Would you agree that's a suggestion to the hospitalist?
That was part of our text discussion regarding recommendations. So I guess it was a suggestion. I don't know in what context.
And it's a suggestion related to Maya's medications while she's sheltered at Johns Hopkins, correct?
I believe I just read exactly what it says.
Do you agree with that characterization? It's a suggestion related to Maya's medications while she's at Johns Hopkins.
It was apparently a proposal.
Is there any other way to read that fucking text message?
I mean, she very much hopes so.
Is she convincing anybody? Anybody
No.
in the fucking world?
Oh, sorry, I want to correct myself. She's doing a lot of convincing right now. A tremendous amount of convincing.
That is exactly
Just
what Whitney,
for the wrong
attorney,
side.
is saying it is.
Yeah. Yeah, they're convincing the jury that she sucks. Is really what she's doing.
Proposal related to her medications.
Is the decision whether or not to take Maya off of medications an evaluation?
As a child abuse pediatrician that provides assistance to many doctors at Johns
You're gonna get
Hopkins All
mad.
Children's Hospital, I sometimes discuss with them testing or treatments or things like that that may be helpful for either the child's well-being or for some element of my evaluation or things like that. In my view, the things that you're talking about here were discussions that I had with a couple treating physicians on a few occasions related to things that would improve my safety and assist in minimizing the effects of the medical child abuse.
You're gonna get
Were
very
they
mad.
treatment decisions? Removing from medication. Is that a treatment decision?
That was just a
her
discussion that I
face.
had with the treating physician in terms of whether or not she, how she responded to my discussion or recommendations or suggestions to her. That's up to the treating physician.
Is removal of someone from medication a treating decision?
If I had gone in and written the orders myself and directed exactly when a dose was decreased and what medication was
Oh, that's
discontinued when and
weaseling.
things like that, those would be treating decisions. Having a discussion with this physician about a child that we were both providing medical
Nobody
care
believes you.
for and a medical evaluation for is not, in my view, a situation in which I was providing treatment for the child.
But it's a treatment decision, not
So a
treatment,
treating
correct?
decision is only made by the person that undersigns a particular progress note and not by the team that consults in making that treating decision?
All of these things, we've talked about were
If she could have said yes to that, then she's in much better shape. But she can't. She's got a weasel.
She can't. She can't, because saying yes to that brings up a big problem.
something I said maybe, something I said consider, are you doing this, things like that.
So Ian, at this point in time with the chat, I went through the explanation of, remember Office Space, the movie?
Yes.
And the guy walks in, he's like, so yeah, if you could come in on Saturday, that would be wonderful. Just, Saturday, that would be great. Would you interpret that by a boss as being a suggestion or influencing your behavior?
So this is actually an interesting thing about communication, because that kind of comment or that kind of like order by suggestion is a behavior that you do with underlings only and not with people in and so people hate being spoken to like that, which is part of why you can only do it with an underling. You get a reverse similar behavior with underlings where they're like, I have a real concern about something, but they'll say something like, do you think this is an issue? Or and there's actually quite notably a plane crash where they've got the black box recordings and the underling is like, that's a lot of ice out on the wing. And from the underling to the superior, that's like hey, do you think this is something we should deal with? And the superior blows it off. Whereas if it was the superior saying that to the underling, what that would mean is go de-ice the wing.
So let me give you her credentials. She worked directly for the hospital until 2003, I believe, for the hospital. Then she was contracted privately through Suncoast, but remained on the hospital on several committees, including, I believe, the ethics committee, the badging committee, various committees for the hospital. She was on the hospital committees. She was on staff at the hospital. She had a teaching function at the hospital. She didn't volunteer. She wasn't paid, but she was there. At the same time, she had this function that was tasked and delegated by DCF to perform investigatory action. Would you consider a text message from someone in that capacity saying, maybe we should take her off medications?
I mean,
that's
clearly not
an instruction.
Yeah.
Like that's about as clear as you can fucking get. And her dodging around the issue, like, I didn't really, they were doctors and independent. We had discussions and maybe, and it's a maybe, it's a true maybe. Call me maybe.
So I'm not directing them to do specific treatment. For example, with the removal of medications, that had already been ongoing and mostly completed when I asked the question. So clearly that wasn't based on something I told them to do. That was based on all of the treating physicians at the hospital, the pain management team, the hospitalists, and whoever. I said something about maybe get her off as many meds as possible. Yep, last med coming off today. So it's not like 7 minutes later they had removed.
That doesn't help your argument.
Nope.
You got a message back 7 minutes later that said, oh no, we did what you said.
That, in fact, makes it so much worse.
Moved all of her medications based on my recommendation.
My question is very simple. Is removing medications from someone a treating decision? Yes or no?
I don't know.
You don't know if removing someone from medications is a treating decision.
Oh, that's terrible.
This sent me over the edge today.
Gee, I can't
posed the
imagine why.
question- I posed the question to the chat. Let's say hypothetically a physician, several physicians have placed someone on an antipsychotic because they are severe bipolar or they are severe submental psychoses. Let's say that after full workup, this antipsychotic, which requires a certain regime to be employed, for example, twice a day for 2 weeks before it becomes fully effective, is being consistently applied. If someone in a medical capacity says, stop taking that, and you're telling me that is not a treating decision, are you out of your motherfucking mind?
Yes.
I could not think of a more horrible example to give. So that was the dumpster fire that was yesterday and today. I have some super chats to catch up on, and then I need to go to bed because I've been streaming apparently for 6.5 hours.
Why?
I'm following this case and I can't let it fall by the wayside.
That's a lot of hours, though.
I know.
Just letting you know, because
I know I'm catching up on super chats. I'm getting out of here. Do you want to stick around? You want to jump? What do you want to do?
I'll stick around a little bit.
Okay.
I mean, otherwise all I do is play video games. So,
Black Cali girl, is there a preponderance of the evidence? Yes, this is preponderance standard. This is more likely than not. So it's a whole lot of work the hospital has to do. Michaela Haney gifted, thank you for the gifted membership. RK, I really appreciated your thoughtful coverage of the sensitive, important case. We're invested. Thanks for sticking with it today. FNF next week. Thank you. Thank you. And thank you for the people that supported that decision. Island plaintiff has 11:45. Defense has 40 and 15. So that's hours and minutes. So plaintiffs have 11 hours and 45 minutes. Defense has 40 and 15 minutes. That's not as bad as I thought it was going to be. That's still a lot of hours. So that's about right. Bright Fire, thank you for the coverage. I have a cousin whose daughter has TRAPS, a very rare genetic disorder. This case makes me very scared for them. This case is a lot closer to home than people think. Casey Cat, except it wasn't an internal decap, it was a decap. Oh, I don't know this case. The family only found out because the funeral hold told them. Oh my God.
Wow.
Lisa Stallings, thank you for the super sticker. By the way, I have trouble covering those cases. I have personal opinions that prevent me from really giving a fair legal assessment to cases like that, which is why I kind of avoid them.
Is your personal opinions F these people?
I can reach a conclusion on Sally Smith, but also understand where she's coming from in some respects, like the investigatory capacity. So when I say this person's not a good person, I feel comfortable doing that impartially without my own bias weighing in on it. When it comes to that subject and infants and children, I have trouble doing that impartially. And I don't think that's fair.
I think that makes sense.
Yeah. Don Burke, my dad had the first intestine cat transplant when I think he was 8. Ask what I saw when he was older. You can check. I will tell you my real name. My God. The first intestine cat transplant when I think he was 8. Dawn, shoot me an email, lawnlumber@gmail.com. Please.
For a while, my uncle was the most northern recorded Black Widow bite.
Oh my. Those are gnarly.
He survived it as an infant. So That's kind of tough. Tough stuff. And the hospital didn't think it could have been a Black Widow until they actually found the body.
That's the freaking problem. Like, you see necrosis. You see necrosis on the wound. It's there.
Black Widows, I don't think do necrosis. They do like systematic toxicity.
Is it toxicity? Does it like
So they're not. I don't think they're like a recluse. They're like a it's a venom. But the kid was super sick, and they had a bite, and they're like, "Oh no, that couldn't be a Black Widow. It's got to be something else." Until finally they were like, "Yeah, we found the spider. It's totally a Black Widow."
the Black Widow is a neurotoxin, but question on that. Is that the one that keeps bleeding and doesn't stop?
No, because it's a tiny little.
That's the one that's like seizes.
Yeah, I'm not an expert, so.
I don't get bit by one.
Yeah, no, that's
bit by one.
Good life tip. Don't get bit by venomous anything.
No. Feral Dragon robbed my PT about Dee Maya didn't have mom to help guide her. Plus, lifelong decisions often flare in puberty. Maya was betrayed, not guided. Feral Dragon, I really wish I could. Maybe it's my brain. This is my brain not catching this. Feral Dragon, please email me. I will try to email you back. I'm sorry if I am misconstruing this. It's 6 hours in. Horse welfare. I'm grateful you are covering this case. My life was destroyed by medical malpractice. This case is important to the harmed patient community. It exposes what these doctors and hospitals do and the tactics utilized to defend their egregious behavior. Well, horse welfare. 1, thank you for the very generous super chat. 2, it's not so much, quote, these hospitals. There are remarkable hospitals and there are not remarkable hospitals. There are remarkable doctors at bad hospitals. There are remarkable hospitals that have bad doctors.
And the thing is even a great hospital can have a bad day or a bad file. Like, things go wrong and tend to spiral out of control because one bad decision can end up causing huge issues. You look at things like the Donner Party. It's like just one or two bad decisions throws that in from like, we're going to have a nice trip from one place to another to cannibalism. So,
well, that was where you were. That's the Ian remark. That is what we expected. Donner Party.
Like,
but can I piggyback on that? Because Ian does a charity event every year for a particular hospital, the Stollery Children's Hospital, which is in large part some of the reason why you can see Ian sitting upright talking to you today.
Wasn't the Stollery that I went to as a kid, but I did go to as a kid, I had seriously bad asthma. So like my first childhood memory is being inside an oxygen tent, which sucks. I don't recommend it, but it's, hospitals do a ton of great things. Captain Corey was, his family has nothing but good things to say about his hospital care. They tried their best and it was just against an impossible situation. Hospitals do a tremendous amount of good work. And just, you can't throw out the baby with the bathwater on that one.
Yes.
I suspect even this hospital has probably done excellent work for other patients. It's just not everybody's going to get the same experience.
Yeah. And if there's a bad apple in the hospital, a consistent bad apple, not just someone who had a bad day, but someone that's a different story. That's that's kind of like the bad cop. And then you play the game of still a cop or not a cop.
Where
Still
there's
employed or
only
not
one
employed.
answer, and it sucks.
I know. But horse welfare, thank you. I still have a lot of faith in a lot of medical providers. I think a lot of them, most of them, a vast majority of them get into it and stay into it for the right reasons. Just like I think about lawyers. A lot of them are doing this for the right reason.
At least like it's got to be like at least 10%.
I mean, so much so that I happily encourage Ian on his 24-hour live stream that he's going to be doing in November
4th.
November 4th. For the benefit of the Stellar Children's Hospital, I'm going to donate both pens that I make and time to try and see if we can't outdo last year's. What'd you earn?
I think it was 52,000. I'll have to check the
$52,000.
total, but it was a little north of 50,000 if I recall correctly. So
yeah.
And I'm hoping we can do that again because that's just amazing.
It's great when a couple of people on YouTube can beat out like massive corporations.
There were corporations who were hurriedly throwing money at their donations going, who is this guy? And why is he beating us? Because we got to have a spot on that top 10 roster. And I got told by the stallery that they basically had a moment of going like, who the hell is he in Runkle? Because like they're sitting there going like, he somehow just outraised like everybody in Canada and we've never heard of this guy. So maybe we should find out who this is.
Not a problem. Where's the bear? Look over his shoulder.
There's the bear.
There's the bear. The salary bear. So all right. Here for years. Ian and Rob have coordinated their wardrobe color palette. Again, the bromance is strong. We texted beforehand. Don't you worry about that. Alex Martin, did you cover already the moment judge told the jury something within the lines of the trial isn't over yet? There's more evidence and more witnesses. Yes, that's a common thing to be said in these cases. Sarah Marie, would you or Runkle consider covering the Karen Reed case, associated case against Turtle Boy for witness tampering conspiracy, and there are more charges to come? I am full on like crowded. I will tell you that Ian, if it's a fun case.
I'm starting to look into it. I am behind the 8 ball because like I've never heard of Turtle Boy. And I think people kind of expect me to know who Turtle Boy is on this one. And I'm like, I have literally never heard of this guy. So I'm going to have to try to update and try to fix. But yeah,
I got nothing. But I encourage Ian to cover it. Baby Gator, thank you for more gifted memberships. Chelsea, how's that not staying up till 3 a.m. looking? Not good. Lindsay, Rob, nearly done with today. It's late. I need sleep. Ian, bet. It's my partner in crime. My partner in crime. Against Tide, the kindness so far. 303 gifted memberships today. Thank you guys for all of that. Incredibly generous. Casey, Cat, Rob, Ian, can Shapiro bring up DCF case, etc. again to cause a mistrial if they read the room and it makes them sad? That was what I was kind of saying. Shapiro danced on a line and crossed it today, and it was a warning at a mistrial. There's been 4 motions for mistrial so far. And the defense, this is the intentional mistrial question. The intentional mistrial question is a complicated one because here's the thing. If the judge views the mistrial caused by the defense as intentional, they can do a lot.
And one of the most common things that they'll do is say, okay, there's a new trial. All expenses up till this point, all 100% on a dollar for dollar basis are borne by the side that caused the mistrial intentionally, or sometimes the lawyer personally who caused the mistrial. I've seen that ordered, and I can tell you, like, if you're a lawyer and you suddenly get an order of you personally owe Like in this case, we're talking potentially millions.
It's millions. It's millions. The
You know,
doctors were
it's-
billing $90,000 to $100,000 to be here at trial.
Yep. So it's like, all right, you now owe a cool $1 million. How do you want to pay, cash or credit? Like, and those kinds of debts, by the way, are not easy to shake, because it's like, oh yeah, you declare bankruptcy. Well, great. Your ability to practice law is actually like potentially on the hook if you
And I
F around with
believe
this
that
kind
you
of
can
thing.
condition default on it too. I believe you can condition default on it. Like you have to pay it. And if you don't, you can be found in default.
So I would say
They don't
these are
like
very
this-
much don't mess
yeah.
around with this kind of thing. And I can tell you, there's a rule, which is basically remember that at the end of the day, you should be going home. And this is kind of a rule from criminal law, hence the going home as opposed to whatever else. But it really comes down to don't make the case about you. Because so long as the case is about the parties, you get to go home at the end of it. And that's wonderful. Once you make the case about you, now you're on the hook and it's potentially your money. And like, you don't want that with these kinds of numbers. I can tell you that for free.
My camera's focusing on the jury. It's a better picture anyways. Bright fire. Is there any way you
I
can
love the way your
talk?
camera just decides those faces are the most human thing in that room.
Sorry. It was really good.
It's like, no, the people are that.
That's the robot jury box. The robot jury box. Those are my friends. Ian is the gray dude sitting next to Emily with the questions hat. And there's Kurt up in the corner. Yeah, that's the jury box. Brightfire, is there any way you can talk, if not tonight, then maybe in a later recap about when Shapiro mischaracterized the note or during the GAL testimony? I did. Scroll back. I talk about it. I do. Louisiana Girl, thank you so much. Your coverage is amazing. Thank you. BA60, thank you very much. Dawn Burke, if you think I'm kindling, look up history. I'm not thinking you're kidding, Dawn. I want you to email me with details so I can actually talk to you, not in the middle of a live stream when I'm reading chats. Send me an email. I'm very curious. Casey, Kat, Robin, Ian, and Captain Corey got to have a voice in whether to have a third heart transplant. Once Maya hit J Hatch, her voice was muted. That's part of it's part of it. Kristen M96, Robot for Charity. 2, shout out for Celine's Mike Squirrel calculation tonight. Celine, give me drop in the regular chat the most recent, and Ian will pull it up because he's watching chat. What's the count? KBF, you should interview Dennis Slate from Texas. He handled a child abuse case involving a child abuse doctor, caught CPS lying on the stand, and got the highest sanction ever awarded against CPS. Dennis Slate from Texas. If you have his contact info, can you email that to me?
I think this is the one you were looking for.
Yep.
Mike,
so I have muted myself.
10 spinny wheel, 5 squirrel, 90 WAP, or squirrel 90, WAP 2, Rob 70 plus 50 bonus points for carrying. Runkle adds a ×3 multiplier to the squirrel points going forward. I don't know what this scoreboard is about.
Here's the scoreboard. The microphone has 1, as in I have come back and muted myself and been muted, like talking, 3 times. The spinny wheel is when I go to fast forward or move in the stream that I'm covering, and it starts spinning 10 times. Squirrel 90 means how many times do I end up off track of the topic that I was discussing? 90.
That's actually a pretty good score. You're just at 90.
I know. We are professionals is the WAP. We are professionals is how many times I forget to have.
That is
the
not what I
share
thought that
screen
song
ready.
was about.
I know. And then Rob 70 means how many times I've come back from a break and been able to discuss the matter without my being muted, etc. That's 70. So I'm ahead in the count. Plus 50 bonus points for caring because of the subject matter I'm discussing. Runkle adds a 3 times multiplier to the squirrel points going forward. So that's an explanation. Celine has been keeping score for every recap. It's been phenomenal. But KBF, please email me, lawandlumber@gmail.com. I'm very curious to talk to your friend. BA60, the number of medical child abuse cases in Pinellas County through Dr. Smith were 3 times as high as any other county in Florida. Don Burke, look up Dave Manns. Dave Manns. I promise you I will. Abby Rafi, thank you for the super chat. The world wonders. I apologize on behalf of the state of Massachusetts to you for having to learn about Turtle Bay. That's to Runkle, not me. Don Burke, look up Dave Mance. Don, I caught it. Thank you. Kay Stevens, thank you for the very generous donation. 50 memberships. Thank you. Thank you very much. Michaela Honey, same with ambulances doing bad things or forgetting something due to personal experience. Baby Gator, I'm not related to Turtle Boy. I just need to clear that up. Baby Gator and Turtle Boy, I got it. That took me a minute. Don Burke, I don't want any money from my dad. I'm not doing that. I'm just looking it up. That's it. Looking it up. You can email me with information. I'm happy to talk to you about it. Adrian, thank you for covering this. I feel so much vindication through this trial. I've had chronic pain my whole life. I have other friends that suffer from chronic pain. One of them might be on the screen. Took 38 years to diagnose HEDS. Many doctors still don't believe my pain. It's devastating to be dismissed like that.
Yeah, no, that I mean, that's something they found in studies too, is that if your pain is not taken seriously, it really
it messes with you.
Yep.
So without further ado, it's been 6 hours and 45 minutes and 50 seconds, almost 7 hours. I'm going to bid you all good evening and thank you for joining me for this extra long marathon recap. Thank you for being here. I will catch you guys next week. Love you all. Thank you for the generosity and good evening. Check Runkle of the Bailey out on Monday, because the topics that I was considering covering,
I'm gonna be doing some we're gonna have
Ian's
some
gonna have
snark
cursey
about
words. Them. Yeah, Ian's gonna have cursey words. They're gonna be fun. All right,
because like
love you all.
SBF deserves nothing but cursey words.
Oh, his haircut too. He cut his hair.
I'm kind of disappointed because I enjoyed making fun of his previous hair, but we can make fun of his new hair too.
You did not see the sketches of the new hair.
I did see sketches. We're still good. Like the making fun of him will have come to a middle.
All right. We'll catch you guys on Monday. Thank you guys for being here. Much appreciated. Good evening.